Can we establish like that we just started, because then it's just something that we need to have in the.
Yes, 1A is on page 2 and it ends at the top of page 4.
I apologize.
Absolutely. Before you begin,
So before we get started, everybody, just for the record, we'd like to establish, since we've been recessed, establish our quorum for this morning. So if Dr. Cleveland could perform our roll call before we get started with any other official business.
Dr. Evans,
Present.
Dr. Lippincott,
Here.
Dr. Joyner,
Here.
Dr. McClendon.
Here.
Dr.
Here.
Dr. Kirsch.
Here. Here.
Dr. Dotson.
here,
Dr. Loper. Here. Major General Eric Herring. Major General Eric Herring. Mr. Breland.
Here.
Ms. Gaines.
Present.
Madam President, you have a quorum.
All right, thank you. And also, there's the document that has been presented to the board members who are seated in person. For the 2 board members who are joining us virtually, we are making arrangements to have this document provided to you electronically. So you will be able to have access to the documents that we are making reference to, as it appears that we will have to consider this, and we want you guys to be involved in that process. So if you have access to your emails, keep your eyes peeled because it should be coming through shortly. And I'm going to turn it back over to.
thank you. Council, proceed.
Good morning. My name is Molly Walker, and I'm an attorney at Bradley Aman. My law partner, Michael Bentley, was hired by Dr. Feinzimmer to serve as the appellate counsel. He's had a pre-existing conflict that prevented him from being here today, and asked that this matter be continued, which was denied. Accordingly, he drafted and we submitted an omnibus motion related to this action to dismiss all claims against Dr. Feinzimmer. I am here today to assist Mr. Chapman. I would ask that you consider this omnibus motion in its totality, particularly the fact that Dr. Feinzimmer's eye drip therapy business did not involve the practice of medicine under Mississippi law, and that the statute is vague in its definition of what would be the practice of medicine, and as such, it must be construed in Dr. Feinzimmer's favor. And so I was not here prepared to argue this motion. It was for you to consider on the motions, and I hope that you will consider the motion as drafted. Thank you.
Awesome.
In complete candor, we believe that the assertion that eye drip therapy's business model does not involve the practice of medicine is frivolous. It is absolutely baseless in fact and law. The Normal case actually supports the conclusion that the IV therapy or the use of vitamin supplements in an IV is a practice of medicine. That was finding, was that although you can buy vitamin supplements at Walmart or convenience stores or grocery stores, when you put them in an IV, it's a prescription medication. That is a well-established principle of medicine. And we are prepared to present testimony and intend to present testimony from the compliance director with the Mississippi Board of Pharmacy, Katina White. And if the board would like to hear her testimony, the board needs to hear her testimony before it decides whether IV fluids or prescription meds, whether the introduction and giving of an IV is the practice of medicine. You can certainly wait to that point if you would like. I don't think it's necessary. But the testimony will strongly confirm that this is in fact the practice of medicine. I believe that the board, each of you are medical physicians, and you have, and as required by statute, you are appointed to this board as physicians because you have specialized knowledge, training, and experience. I believe that the board could rule at this time to deny the motion to dismiss on the basis that this does not involve the practice of medicine. And if they would like to move to, if the board denies the motion at this time, and they would like to represent it after the evidence and sworn testimony is given, certainly we would be amenable.
Councilor, you have other comments at all?
My only comments would be that it obviously was vague enough that guidance was it was necessary to draft guidance to clarify that the board saw the IV filtration as the practice of medicine. And that was after Dr. Feinzimmer had already shut down the hydration therapy clinic. So by the board's own determination that the statute was vague, it had to draft its own guidance to clarify that.
The board did issue guidance. This board was not the first to do so. Other boards across the country had done so before we did, and our guidance, I think, as the board is well aware, bars heavily from Alabama and South Carolina. Those were already out. The guidance was given you to bring attention to the fact it was not intended to excuse practitioners who had already been violating the rules and the law. Further, the evidence will show that Dr. Feinzimmer and his company, iDrip Therapy, which is based in Arizona, after our investigation or the investigation that the nursing board began into one of its RNs, after that was begun, iDrip hired a compliance consultant, and that iDrip Therapy, the consultant, informed them that they were in violation of state laws in many states, not just in Mississippi, and the business was shut down. So Dr. Feinzimmer did not have to rely on our guidance, and he had his own independent consultant who had informed him of the violations of rule prior to our guidance ever being issued. So therefore, again, I would ask the board to dismiss the motion. I mean, deny the motion.
You have a question?
Wait, before we start, is your question gonna be regarding, is it a procedural question or is it regarding the document that has been received? You ready? Hold on, wait before we do that. So really quickly, Doctors Gersh and Dr. Joyner, have you all received the document via email?
I have not, and I've been watching.
Okay.
I have not received it either.
Okay.
We have a short recess with all the technical issue, and we can just say in place, Francis, my understanding is going to transfer this now.
That would be fine. So gentlemen, if you will just hold on, we are in the process of making sure that you have the document. I just feel like if we're gonna have conversations or consider the matter, we need to have our other two board members to also have the information available for full consideration of the request. So,
Okay, we're waiting.
all right, so what we're gonna do is, I guess we'll just recess for 5 minutes. 10 minutes, okay, 10 minutes. And I was just, yeah, so 10 minutes, guys, and you should have not only received it, but it should give you an opportunity to look over it. If you all need additional time, please just feel free to let us know and we will accommodate that. Okay? All right, we're recessed.
Looks like I got it.
We are now reconvened, recess is over. And we can go ahead and continue. Yeah,
I believe, Dr. McLean.
yeah, Dr. McClendon, I think right before we took our break, you had raised your hand. I am listening in.
Madam President, I'd like to move that we deny the motion to dismiss.
Right,
I'll second.
all right, it's been moved and seconded that we deny the motion to dismiss. Any discussion on this matter? Hearing none, we will go ahead and vote. So all in favor of denying the motion to dismiss?
Aye.
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 Anybody opposed? Any abstentions? All right, so the motion's denied.
I'd like to reserve the right to have this reconsidered after.
That's fine. At this time, are there any other, evidentiary matters that we need to address prior to opening statements?
Hold on. Can I, for the record, I just need to know encouragement. I didn't hear that.
Okay. There. Okay,
So just for completeness and for the record, Doctors Gersh and Dr. Joyner, when we took our vote, I did not hear from you. So could you signify what your vote was for that?
I voted in favor of denial.
Okay, that's Joyner. And Dr. Gersh?
Yes, same.
All right, thank you. Thanks. I just wanted to make sure our record was accurate. All right.
any witnesses today?
Yes. Thank you.
I would like to get them sworn prior to your opening
Oh,
statements. I want to make sure we take care of everything.
Let's see the future witnesses. We have, White, Ron Warner, we have Michael Smith, we've got Cleveland is listed by them. I believe that's everything.
Any,
Dr. Feinzimmer and Mr. Ball.
okay,
And I did with Dr. Fines.
got it. If we can get all of the potential witnesses to stand at this time. And, Madam Court Reporter, yes.
I know. Why did this happen?
No request for a subpoena, for her Peter was made. I do not have the witness list in front of what she was not listed, they have not requested. I do not think, I think that should proceed.
Let's get these witnesses sworn before I comment on that. Madam Court Reporter, thank you.
You do solemnly swear or affirm the testimony you're about to give or will give will be the truth, the whole truth, and the truth.
I do.
Yes. You all may be seated.
You do solemnly swear. The truth, the whole truth.
At what point was the witness list tendered to counsel opposite?
Well, Johnson, she was on our witness list. It was tendered on, maybe the end of, 7th or 8th of April when we produced documents. We also tendered our witness list at that time. They tendered their witness list, I believe, at the same time as their minutes and documents. Is that correct? Yes. So that was approximately 2 weeks ago. Yeah, Dr. Johnson was on this. She was not listed on. So again, we did the issue raised earlier this morning.
Seeing that the motion for continuance was actually a motion for reconsideration, which I denied. I'm going to also deny your request to call Dr. Johnson as a witness. She wasn't, the counsel opposite wasn't given that information within, of course, the allotted time frame. Okay, if we can begin opening statements, that'd be great.
Good morning. Dr. Feinsmer, his home state is Illinois, where his primary practice is as an emergency room physician. The evidence will show that Dr. Feinsmer had a relationship with an Arizona company doing business as iDrip. The various, variations on that corporate name. That's not the official corporate name. It is in the records, but iDrip is the name under which they did business. In Mississippi, there were associated practitioners who were operating in various locations. The evidence will show Oxford, Sturgis, Mississippi, about a dozen locations. We'll pinpoint that. None of these practitioners were physicians. None of these practitioners were APRNs. The practitioners were either RNs, LPNs, and one was a paramedic. Now, this was an IV hydration business at heart. They were under this corporate umbrella of iDrip out of Arizona. Dr. Feinsheimer was one of 3 doctors that are listed as medical directors for that company. The way this worked was that these practitioners, for example, the practitioner in Oxford was an RN. Actually, there were 2, but the first one was Jessica Bates. So we'll focus on her as an example. Jessica Bates was an RN in Oxford who operated a mobile hydration service. She'd come to your location and with, no medical diagnosis or a proper physical exam and minimal documentation, she would give patients whatever IV fluids and supplements that she chose off a menu. Okay. Dr. Feinsheimer had no contact with these patients. Dr. Feinsheimer did not engage in telemedicine with these patients. Dr. Feinsheimer did not provide any detailed oversight of any of these. Again, these weren't even mid-levels. Didn't provide any oversight, minimal guidance. There is a manual, I believe, that iDrip put out, but nowhere did he accept any responsibility for supervising what these RNs and LPNs and paramedics did. And the reason that's most significant is all of the IV medications, all of the supplements were ordered by iDrip, the Arizona company with which he was associated with, using Dr. Feinsheimer's name, his license, his DEA number, and each of those prescriptions is electronically signed in Dr. Feinsheimer's name. What Dr. Feinsheimer did is akin to an unsigned prescription pad. But in traditional hard copy unsigned prescription pad, some pre-signed prescription pad, those are normally left with like the office staff of the physician. They're given to someone that physician already knows, even though it is a violation of rules, and this board has disciplined many physicians for that. The doctor knows the personnel. At least there's that much oversight. This is akin to getting a digital pre-signed prescription pad to numerous practitioners. And Dr. Feinsheimer, when we first interviewed him in person in September of last year, he could only name the first names of 2 of those practitioners, a Jessica and a Ben. He did not recognize the names of the other practitioners for whom we will produce documentation that came from the pharmacy, Empower Pharmacy in Texas, that shows that medications ordered in his name were sent to Jessica, they were sent to Ben, and they were sent to numerous other unqualified providers in the state of Mississippi. Ordered out of Arizona under his authority to a pharmacy in Texas, which then sent the supplies to various locations in Mississippi. Now, and you will find that there are actually two different types of orders for these meds. First of all, there were orders for clinic supplies under 503, Federal Section 503B. Ms. Katina White is going to explain the difference between Section 503A, traditional compounded medicines, and Section 503B, non-traditional compounding. And I excuse the word, but when compounders have a separate license, they can produce large quantities of compounded drugs. Traditional compounding is for a single patient, requires that, a clinical reason for the compounding necessity be given, and it's written in a patient's name. There are numerous prescriptions, which the board will see, which are for quote unquote patients. As it so happens, those patients are also the names of the practitioners, the RN, LPN, paramedic, who were actually administering these IV fluids to others who came in and checked the box. Among the types of things they offered was a hangover cure. There's a recipe for it that you'll see. Another one was a beauty blend. Now, prescription medications are only to be issued, ordered for a patient when there's a medical indication, medical diagnosis of a condition that requires treatment, and a prescription is an order that that patient needs that medication for a specific medical diagnosis. As you heard in the motion to dismiss, Dr. Feinberg asserted this was not the practice of medicine. It's just IV hydration. Well, under the laws of the state of Mississippi, prescribing a medication is the practice of medicine. Allowing your credentials to be used for prescriptions, to send electronic prescriptions to a pharmacy, that is the practice of medicine. None of the practitioners, again, were qualified or had their own prescription file. So the only way they could obtain the supplies was through an order placed by Dr. Feinberg or in Dr. Feinberg's name. No chart review, no oversight. Dr. Feinberg gave his credentials, and allowed his credentials to be used by IDRIP out of Arizona, allowed them to sign his electronic signature. That's assisting in the unlawful practice of medicine. The prescriptions were written in his name, so Dr. Feinberg also violated this board's rules requiring that physical examinations, history, physical, et cetera, the basics of any good medical practice were conducted, yet ordered in his name. He will testify that he did none of this. A little background. This all got started with a complaint to the Board of Pharmacy here in Mississippi about an RN conducting an IV hydration, a mobile IV hydration operation in Oxford, Mississippi, under the name IDRIP. Pharmacy referred the complaint to the nursing board. A joint investigation began involving the pharmacy board, the nursing board, and ultimately this board. So the nursing board went and took statements from the RNs. The RNs stated that they were operating under, quote, standing orders from Dr. Feinberg. There are examples of the standing orders in the book. They have no logo. They have no indication of what medical practice they're on. There's no signature of Dr. Feinberg. There's simply a name at the top and a recipe, a list of ingredients. After the nursing board started conducting their investigation, and learned that the supplies were ordered from Empower Pharmacy in Texas. The pharmacy board, under its regulatory, statutory and regulatory authority, traveled to Texas for an inspection and made an administrative request from records from Empower. The records that Empower produced included a spreadsheet that contains the name of every physician licensed in Mississippi or not licensed in Mississippi that ordered meds that were for a patient in Mississippi or shipped to a patient. That complete spreadsheet is not going to be offered today because it contains the names of numerous other physicians. The fact that other physicians may also be under investigation, may also ultimately come before this board, is not relevant to Dr. Feinsheimer's guilt or innocence. The fact that there's a person violating one law, that there's 10 other people, doesn't excuse the person. That doesn't excuse Dr. Feinsheimer or his conduct. Well, what we have producing what is an evidence. You'll hear that the pharmacy board produced these records. They received from Empower as a co-investigating agency and at our request, the request of our investigating department. They produced those records and that spreadsheet to our investigators. Supervisor Michael Smith filtered the spreadsheet with Dr. Feinsheimer's name as the prescriber and produced, there are two spreadsheets from that. They're all specific to Dr. Feinsheimer. The first, as I said, is for 503A medications, which have patient names. So for the record, we'll have to seal the patient name. Well, we won't have to strike that. We may have to seal a couple of the patient's names, but since the other patients were actually proprietors of these IV hydration stations, they're not actually protected as true patient records. The second spreadsheet filtering Dr. Feinsheimer's name is for the 503B distribution clinic stocks. As opposed to other positions that this board has dealt with in the past with similar issues. We're not talking about failure of collaboration or collaboration, failure to supervise. We're not talking about physicians who are directly involved with the care of these patients. Talk about a physician who turned over his credentials, turned over his prescribing authority, allowed it to be used without his knowledge, any further knowledge, no others allowed. Dr. Feinsheimer will testify that he believes he could have checked the Empower website to see what medications were ordered in his name. And he believes he could have checked the website to see who was receiving those medications, but he never did. Feinsheimer, to this point, has not accepted responsibility for his actions. He has not admitted his culpability. And so this board will be asked to determine his guilt, guilty of the violations, the charges which have been made, and what is an appropriate level of discipline. So ultimately, the question is, if you find him to be guilty of violations, you're going to have to ask yourself, what penalty is appropriate for a physician who simply sells his credentials and allows them to be used without his knowledge? I believe that's going to be the ultimate issue that this board has to decide today.
Morning, ladies and gentlemen. I think by now y'all all know me, but just for the record, I am Philip Chapman with Hagwood and Tipton Law Firm, and I am here this morning on behalf of Dr. Feinberg. I think we all probably feel we're going to be here a while today, so I'm going to try to keep this short for my opening statement. We are going to discuss what Mr. Barnes is talking about today. We're going to talk about all of it. What we're going to do, we're going to probably raise a bunch of evidentiary issues. We're certainly going to make some legal arguments about some definitions of things, statutory definitions we're going to talk about today. You know, in the legal world, we deal with statutes all the time. They're meant to be read by their clear, plain meanings. Words in those statutes have meaning. We go over all those words, some of those statutes. It may be boring and it may be tedious, but we're going to do it. But most importantly, what we're really going to do here is we're going to try to paint you a picture and tell you a story. And we're going to put Dr. Feinberg on the stand. We're going to let him tell you his story. And we're going to let him tell you a story about his life, about his career, about his practice, about his contributions to the community in Illinois. His specialized service that he provides there on top of his ER work. We're going to let him tell you how he got involved with IDRA, how he tried to do his due diligence with IDRA, what he was doing was in line with things he had done in his EMT practice. And how so when he was told that what they were doing was in compliance, he had no reason not to until he learned otherwise. Now, when he did learn otherwise, he immediately took steps, not as a member or an owner of the company, but as an employee medical director, took steps immediately to shut that company down and fix what was wrong. Before he was ever actually involved in an investigation. And we're going to let him tell you all that. We're going to remind you that as the board, as Mr. Barnes said, it is your job. It is your discretion to determine whether a violation has occurred, and if so, what punishment is appropriate. And such punishment needs to be proportional to all of the facts and circumstances, the individual facts and circumstances of that case, not any nebulous hypothetical case that you may face in the future, not really any case you faced in the past, but the case in front of you today. And that's what we're going to do.
I call it Katina White. I apologize. I've been told that I need to speak up as usual. Hopefully our new sound system will actually be ready for July, and we did not think pass it on. So that's why we're gonna have to get fairly close to that mic. It doesn't pick up very well, but it's getting too close. Would you please state your name?
Katina White,
Okay. What is your profession?
pharmacist
Okay. Where are you employed?
with the Mississippi Board of Pharmacy.
Okay. How long have you been in that position or employed by the pharmacy board?
It will be 3 years in November of this year, so a little over 2 years.
What is your job title?
Director of Compliance.
What do your duties as director of compliance with the pharmacy and what do you believe?
Sure, I, as the Director of Compliance, have oversight of investigations, inspections, complaints, and continuing education, and oversight of the compliance agents and staff that work with the compliance department.
Don't mind, would you please give the board the benefit of your education training in large hospitals?
Yeah, I attended the University of Mississippi as an undergrad and then moved on to pharmacy school at the University of Mississippi. Graduated in 1997 with a Doctor of Pharmacy degree from the University of Mississippi, and later worked with St. Dominic Hospital after becoming licensed pharmacist in October of 97, and worked with St. Dominic for a number of years. Then I transitioned to long-term care pharmacy for a few years and back to hospital pharmacy after that, and remained with St. Dominic's until I transitioned to the board in 2021.
And why did you go work?
The Director of Compliance position became open, and at the hospital level, I had been involved in ensuring compliance with regulatory agencies, as well as Joint Commission, CMS on the pharmacy side, all of those different things. And so I felt like I would be able to benefit the board and the board would be able to benefit me in moving into that role.
Am I correct that in your role as compliance director for the Board of Pharmacy, that you are intimately familiar with Mississippi laws, regulations that apply to pharmacy practice?
Correct.
Are you also intimately familiar as part of your duties with federal law and regulations that apply to pharmacy practice?
Correct.
All right. Ms. White, if you would, please, and if I apologize if I accidentally called you by your first name. We work together, we know each other, and I do not mean to be disrespectful. But, when did you first hear about iDrip?
I first heard about iDrip in November of 2022.
And again, I know that you're having this conversation, if you don't mind, if you, before, you would direct your answer to the board just because they're the ones that decide the facts in this case. Sure. All right, so how did you come to, hear about iDrip?
There was a complaint that was emailed to the compliance inbox in November of 2022 from a concerned citizen who wanted to bring iDrip and Jessica Bates, the RN, to our attention.
Okay. And that was the complaint inbox for the Board of Pharmacy.
It was a complaint. It's called the compliance inbox. And it's our general inbox that citizens can use to email complaints as well.
And I was just trying to, for us to be clear that it didn't come to nursing or us, it came to pharmacy first.
It did.
Okay, and what was the substance of that complaint?
Basically, the complainant was concerned. She had become aware of iDrip of Oxford that was operating under an RN at that time, that she noted to be Jessica Bates. The concern was that iDrip was basically a mobile therapy unit that moved around to people's homes or patients could actually meet the RN at a hotel. It could be a garage, it could be a campus dorm. And so her concern was, number one, there are medications that are being given via IV, the IV route. And so she had several concerns about, is this lawful? Can the RN do this? And her concern also was, I don't see the physician listed on the Facebook page at that point is what she was looking at. But she also had flyers, I think, that had been distributed throughout Oxford.
What did you do with that information once you received the complaint?
So after receiving the complaint, I reached out to the Board of Nursing at that point and made them aware that we had this complaint, and the main person that had been pointed out in the complaint was Jessica Bates. And so wondered, first question that pharmacy board had for nursing board is Jessica Bates an APRN or is she an RN? And so from there, began dialogue with the nursing board to try to figure out what Ms. Bates' credentials were.
And did you learn what Ms. Bates' credentials were?
Yes, the nursing board did their look up to see if they had her registered as a RN or as an APRN, and later responded to us that this was an RN.
To your knowledge, did the nursing board undertake an investigation of RN Bates?
Yes.
Did the nursing board share with you the information they obtained during their investigation of RN Bates?
What they shared was that they had concluded that she was an RN, and that they would be setting up an interview with Ms. Bates to discuss her practice further, and that they wanted us to come along and be present during that interview and assist with any medication-related questions.
Okay, were you personally along to that interview, or was it one of your investigators?
It was one of our compliance agents.
Do you recall who that was?
It was actually Agent Sid Seal, who covers part of that area.
Okay, So, your investigator went with agents of the nursing board to meet with, RN Bates. After that, what information, did the pharmacy board, did you and the pharmacy board learn about the, IV hydration practice that Ms. Bates was allegedly conducting?
So we were able to confirm that Ms. Bates did not have a brick and mortar building where she saw patients, that she actually did provide mobile services. She and a patient would decide where she would meet the patient. That could be a hotel room, as I stated earlier. It could be in the patient's garage. It could be in a campus dorm room. It could be in a like a local restaurant or business, sports business, that sold sporting goods, just anywhere that they could find a room. If they agreed to meet her there and that's where they wanted her to meet, they could do that. We also learned that Ms. Bates was ordering medication and it would come to her home and she did not have a knowledge of how to properly store the medications. We did learn that. And we also learned from speaking with her that her medical director, she stated was Dr. Feinzimmer.
Did you learn any information about the source of the supplies that were being ordered and shipped to RN Bates?
Yes, she told us that she ordered her medications from Empower Pharmacy in Texas. And so we asked at that time, the agent that was there asked to see the medications, and they appeared to not have any patient stickers on them the patient labeling that we would expect. And so we wondered which Empower the patient medications had actually come from.
And did you learn which Empower they came from?
We did. We learned that they actually had come from both Empowers.
Okay, when you say both Empowers, could you explain?
Yes, there's Empower 503A, which is a compounding pharmacy that falls under our purview because they do ship medications to Mississippi. But the 503A compounding pharmacy is limited to only sending medications that are patient specific. So on the order of a physician or an APRN, someone who is given prescriptive authority, those medications are then sent to a specific patient. They can be sent to that patient's home, or they can also be sent to the practitioner's clinic. Practitioner meaning a doctor or APRN. The 503B, on the other hand, is what we would call an outsourcer. And so a 503B outsourcer has the oversight of FDA, and also if they're permitted within our state, we also have purview of making sure that they follow what we call good manufacturing practices. Simply because of the amount of compounded medications that they are producing. So they have to follow those guidelines. Within those guidelines for a 503B outsourcer, they are allowed to send medications to a clinic under a provider who has prescriptive authority, under an order from that provider for that clinic for administration to patients at the clinic during a clinic visit. 503B also does have they also can send patient specific, but not as much. But also, even if it is patient specific, it still has to be on the order of a provider who has prescriptive authority.
What steps did the Board of Pharmacy take? It would just briefly, what steps did you initiate to investigate Empower's operation?
So Empower, we learned, sends quite a bit of medication to Mississippi. And so we wanted to, just from what we learned from this investigation, the investigation with the Board of Nursing at that time, and the interview with Jessica Bates, we wanted to actually see Empower's operations. And we wanted to see how Empower both both places, the 503A and B, were actually sending the medications. The medications that Ms. Bates had that were not labeled appropriately, and we felt like they had been sent for an individual patient, is that how they left the pharmacy and ended up with her not being labeled correctly. So we wanted to actually go and see their operations. So myself and two senior compliance agents went to Texas to do an inspection and to sit down and talk about operations with Empower Pharmacy, both the 503A and B.
Okay, and at or about the time that you made this inspection visit to Empower in Texas, had you, the pharmacy board, you shared information about the iDrip operations with this board in our investigation, our executive director and investigations?
Yes, everyone, the Board of Nursing and Board of Medical Licensure were aware that we were planning to visit Empower.
And is that's because that one of our licensees, Dr. Feinzimmer, had been named as a participant in this operation?
Yes, that's how the Board of Medical Licensure became involved.
So when you went to inspect Empower, did you obtain records?
We did.
Okay, what records did you obtain?
We asked Empower for shipping records or, excuse me, any shipments of medications that they had made to Mississippi. We also asked that those records include the patient, the physician who's, or APFRN whose ordering credentials that were used to order those medications. Also, those records we needed to have include in them what the medications were, date shipped, all of those things that we would normally ask for.
Okay, and were there, did Empower produce two spreadsheets to you?
They did.
Okay, could you describe the difference in the two spreadsheets?
Yes, one was for the 503A compounding pharmacy, and the other one would have been for the 503B outsourcer pharmacy.
Okay, I have one moment. We have one moment. Okay, well, we'll go one at a time. So, but I believe we agree that we will can provide board with a physical copy or distribute copies of these, and they'll be available on your tablets. However, they are reserving the right to object to each individual exhibit. So I have to ask the hearing officer to instruct the board members, only to look at those exhibits which have been offered and that you have.
Okay.
So, yes, fair to say, yes.
Okay.
Okay.
I have one, I think, but I'll take next one.
Yeah, and if we run short, there's not enough copies, that's sufficient. Again, we don't provide a copy to every board member in hard copy. For environmental concerns, but we certainly will make more if they're needed. We'll have one that is gonna be, sure, there are some, patient names, the are some redacted, will have name, regarding patient name, and patient product. So we'll make those for, those, any exhibits could be, released to the public. The exhibits that we are producing to the board, right at the side, are unredacted. The board has the right to see the unredacted records, but again, the sensitive and confidential portions will need to be redacted and accepted under seal. Is that acceptable as far as?
Yes, it is. Thank you.
And because we're going by individual exhibits, I will not be referring to these exhibit 1 or exhibit A. I'll be referring by the base numbers. Each of us, our exhibits are base numbered MSBML 0001, et cetera. And Dr. Feinzimmer's exhibits are also base numbers individually, beginning with Dr. Feinzimmer's name and then, sequential number. So we've got a specific page. If you would, Ms. White, if you would turn to page 145.
Is there any objection to the introduction of 145 into the record?
And I am offering, just for the record, if the clear, 145, at this time, 145, 146, 147, and 148.
Any objection?
Check all of them based upon authentication.
Okay.
You don't know where these records came from. They're likely our records. Here, the state as the custody will accuracy or any.
I've noted the objection for the record. I'm going to overrule your objection.
Ms. White, do you recognize pages 145 through 148?
Yes, this is the records that were given to us by Empower Pharmacy in Texas.
Okay, now pages 145 and 146. Strike that. Let me back up. As a matter of foundation, are these the complete spreadsheets that Empower provided the policy board?
No,
Do you have any knowledge as to who filtered these spreadsheets for information specific to Dr. Feinsberg? Did you ever learn who filtered these?
it was not us.
I'll lay the foundation later. We'll produce a witness who did filter the spreadsheet. But you recognize that these are at least a portion of the spreadsheets that Empire produced to you, that this is the information that was provided, the columns, the information about providers, patient addresses, etc.
Yes, this is the information.
Okay, and so pages 145 and 146, is that the spreadsheet related to section 503A medications?
It is, these are patient-specific prescriptions that were filled by Empower.
All right. And I know that this is very small, but if you look on the top of page 145, what's the first name listed as a patient name on the spreadsheet?
The first patient is Jessica Bates.
Okay. Would you look at page 147 and 148? Is that also, do you recognize that as a subset of a filtered portion of the spreadsheet which Empower produced to the pharmacy board related to 503B operations?
Yes,
And the same, you don't know who filtered these to be specific to Dr. Feinstein, but you do recognize this is a subset of the original spreadsheet.
It is, it's the information, it's just taken out specifically for Dr. Feinzimmer.
All right, if you don't mind, I would ask that you turn to page 87. And I am going to be introducing or asking for introduction. Let me do it this way. Would you look at pages 87 to 135? If you would lead through there, I guess I should do it the correct way. The procedurally proper.
87 through,
135. On at least some of the copies, page 136 is on the back of a page, so I'm not offering, I'm not asking. For page 136. And while it's waiting for you the record, for the record, while she reviewed the documents, wanted to inform the voting council that Dr. Gersh and Dr. Joyner attending remotely have been provided electronic copy of the documents, but they understand that they're under the same limitation to only look at the documents as they are properly introduced and admitted. Ms. White, you completed your review.
yes,
You recognize those documents?
I do.
What are they?
These are the actual prescription orders that we requested from Empower Pharmacy.
So those were produced to this Board of Pharmacy by Empower Pharmacy on your administrative request.
It was.
Okay, let's look at page 87. What's the company name at the top?
Hydrip therapy,
And there's an address in Arizona.
correct?
All right. Is there a physician name on the prescription?
The physician's name is Benjamin Feinzimmer, DO.
And
We would state the same objection. Well, there's still nothing from Empower, so it's their actual records. Records. Verify these came from Empower on records are accurate.
these have been authenticated by Ms. White. These were documents requested by the pharmacy. She has established both their source and the chain of custody.
I don't know that she's actually there about the change. If we don't know that, we have nothing to show.
I'm actually going to sustain that objection. I assume that the next question will be to lay the foundation to connect the two.
So Pharmacy Board obtained these records since we are apparently gonna comply, even though this board is not limited by strict rules of evidence or procedure. These were records the Pharmacy Board obtained, from Empower.
They are.
You personally inspected these, received them, and are aware of their source.
I am aware of their source. They either came from being handed directly to us during the inspection or being emailed directly to me from Empower Pharmacy's chief pharmacist.
And Empower, both their 503A and 503B operations are licensees of the Mississippi Board of Pharmacy. Is that right?
Correct, they are.
And you have the right to request records and receive them from your licensees at any time.
We do,
And you did so in this instance and received them from Empower.
yes.
Okay,
At this time, I will admit, MSB ML, page 87 to, what was the page number?
135.
135. You may continue.
And did I formally, if I have not, I asked that 145 to 148 also be formally introduced, as they have also been authenticated. By Ms. Westchester.
Any objection, council? The same one stand?
Other than, we haven't gotten up where they've been filtered or who filtered or any of that, yes.
We will provide, subject to, we will establish proper foundation with.
Got it. Overruled. Admitted.
Did this board, investigators for this board, request that Empower provide, that the pharmacy board provide us with copies of the documents you had obtained from Empower?
Yes, we received a request.
And did you in fact produce those, records to this board?
We did.
And are the documents 87 through 135, those are copies of some of the records, a portion of the records applicable to Dr. Feinzimmer that you provided?
Correct.
All right. Now let's look at page 87 again. And I believe I was asking you, I apologize if I don't want to double track, but I asked you if there was a doctor's name on there, and you, I believe, identified Dr. Benjamin Feinzimmer, DO, is that right?
Correct.
All right. On the right-hand top of the page, there's a DEA number. I'm not asking you, I doubt, well, do you know Dr. Feinzimmer's DEA number off the top of your head?
I don't.
For the record, am I reading this correctly? FF 2592182. Did I read that correctly?
Yes.
And then, the next reference is state LIC. I'm assuming that stands for license. And the number given is AZ007752. Did I read that correctly?
Yes.
All right. Is there now, then what is the next heading underneath that? It's centered in the page. What does it say?
It says electronic prescription order.
Is there a patient list?
There is
What is the patient's name?
Jessica Bates.
Okay. You see in the yellow box there where it says patient's work address?
Yes.
What is that work address?
23 County Road 412, Oxford, Mississippi.
I'm not even gonna try to produce medications. What's the first medication on that order, that prescription?
Just NAD is the short version of nicotinamide adenine dinucleotide.
Okay, NAD, but that I can handle. Would you explain what that is?
Yeah, so NAD can be used for a number of reasons, but most commonly for this type of IV therapy that it would be being added to. It's used like more of an immune booster or metabolism booster.
Okay, what about the second item, L-carnitine?
L-carnitine would be used again as more of like a fat burner, that type of thing, boosting metabolism again.
All right, and each of these, at the end, it says injectable. So these are the injectable forms of these medications, correct?
Correct.
All right, are either of these prescription medications under Mississippi and federal law?
They are when you inject them, when you are planning to inject them through an IV, they are. And they're compounded medications, so compounded medications are prescriptions.
As a pharmacist and compliance director for the Board of Pharmacy, can you tell us whether a bag of IV fluids is a prescription medication?
It is.
So it requires prescriptive authority and a lawful prescription for it to be ordered or administered.
That is correct.
If you would turn to page 188, just flip the page.
88 or?
88, 188, 88, I apologize. Just the next thing. At the top, special instructions, it says no known allergies, correct?
Correct.
What does it say next to diagnosis?
Next to diagnosis, it says no known medical conditions.
All right, and tell me if I am reading this correctly from the form. The compounded medication, well, you didn't talk about that. Hang on, let me back up. So 503A, that's what commonly referred to as traditional compound?
It is.
And 503B, as you reminded me, those are outpatient sourcing facilities.
That is correct.
So 503A is for specific patients, 503B can be for clinic stocks. Is that right?
That is correct.
Okay. I'm going to read this into the record. And again, I'd like you to follow along with me. The compounded medications listed above are made at the request of the prescribing practitioner whose signature appears above due to the medical need of a specific patient, and the preparation is prescribed because the prescriber has determined that the preparation will produce a clinically significant therapeutic response compared to a commercially available product. Did I read that correctly?
You did.
And is that a fairly standard clause to go on a prescription, for a compounded medication?
Or compounded medication, it is.
Okay, does this form say who it was submitted by?
It says submitted by Benjamin Feinzimmer, DO, gives a date,
Okay, and does it say who it was signed by?
signed electronically by Benjamin Feinzimmer, DO.
And the pharmacy in question, see, this is Empower Pharmacy, 7601 North Sam Houston Parkway West in Houston, Texas. Is that right?
That's correct.
Is this a lawful legal prescription for a medication under Mississippi law?
It is.
And I'm not gonna ask you, details about each one, but if you would you, again, I hate to just flip through, but in your review, did you know yet whether or not each of these is an electronic prescription order that was in the name of Benjamin Feinzimmer, DO?
Yes, each of these is.
I'm gonna ask you some questions about the spreadsheet, but before we do that, I would like to ask you some questions about pages 137 through 143. Have you seen these documents before?
I have.
Do you know where they came?
They came from Jessica Bates when the Board of Pharmacy agent and Board of Nursing investigators interviewed her.
So these were obtained directly from Jessica Bates, like your investigator.
Correct.
Has counsel opposite, seen these documents? Any objection?
No objection.
I'd like to go ahead and admit those at this time.
Thank you very much.
137.
Bates numbers,
Mhm.
just pages 137 through 143. We can call it 3 if we like, but we're just gonna go, I thought it was.
3 is fine.
Yeah, I think so.
Mhm.
Right. What were these purported to be, provided to your investigator?
These are the menus that, Jessica Bates would present to her patients. And the patients then would choose what they wanted to be infused. So this is the menu.
Okay, and we'll talk about some more patient-specific documents. Second, we're looking at page 139. What's the title for that recipe?
Hangover cure.
All right, let's talk about the contents. Starts with a bag of lactated ringers and IV fluids. Right? You got zinc, magnesium, B complex, vitamin B12, with 2 milligrams of hydroxycodone. That's lexicon. It's on the page. Folic acid, right? Are any of those are vitamin supplements, right?
They are, but they're given IV. They're being given IV.
Okay, so, I mean, fact is you can get vitamin supplements in capsule or pill form, at Walmart, Kroger, or any pharmacy, correct?
That's correct.
You can get them without a prescription.
That's correct.
You can take them off.
Mhm.
Okay. Once you give them an injectable form, put them in an IV, are each of those at that point, do they become prescription medications?
They have to have an order of someone with prescriptive authority. Yes.
Okay. All right, below the line, glutathione, what sort of a additive is that?
That runs along those same lines of the antioxidant properties and immune boosting, cognition boosting, all of those things.
All right, then extra. Zofran. What's Zofran?
Zofran is an antiemetic.
Okay, what is it typically used?
Typically for patients that are experiencing nausea and vomiting, you see it a lot with cancer patients.
What about Toradol? Is that a prescription medication?
It is. Toradol you would normally see. It's an anti-inflammatory, and you're going to see it a lot with patients who are having issues with joint or muscle pain.
Well, Pepsi. I mean, there's a non-prescription version of Pepsi, correct?
Correct, but this one is IV, and so this is only available via prescription.
You would turn to page one. I apologize. Are you familiar with a medical diagnosis of a condition called a hangover?
Condition or medical
Medical
condition.
condition.
I'm not.
Okay, if you turn the page, the next page on 140, it says migraine blends. Well, a migraine is a medical condition.
Yeah.
Okay, let's look at page 141, beauty blend. You know of any medical diagnosis or condition that is a medical indication for someone to receive something called a beauty blend?
No.
Okay, and again, on each of these, and if you would, flip through until page 143, are each of the ingredients listed on these pages, starting with the bag of lactated ringers, are each of the medications or additives, are these prescription medications?
They would be based on the route of administration.
And how does one go about putting these ingredients together in an IV?
Well, in order to do that, you would have to, if you're the person that's doing it, you're gonna draw each individual dose out of the vial that is available and add each ingredient to the IV bag.
And what, is there a term for that?
There is.
Mixing and pharmacy, what is,
We call it compounding.
and there's special laws and rules that apply to compound.
That's correct.
So each one of these descriptions of these, solutions, whoever put these together was engaged in compound.
Correct.
All right, if you would, I'd ask you to turn your attention back to page 145. That's the first page of the quote unquote patient specific spreadsheet. Got that for you?
I do.
And I may have asked this before, who's the first patient listed there in the spreadsheet?
The first patient is Jessica Bates.
Okay, there's several entries, and then there's other names, on this. Do you recognize any of these other names or whether how they might be related to this case?
Yes, I do. I recognize Ben Oglesby. He's another RN who had a mobile hydration clinic. I also recognize Chris Crittenden. He is an EMT who was running a mobile hydration clinic. I believe Janet Beal was also another RN who was running a mobile hydration clinic. I'm not sure if April Davis's licensure or if she was licensed.
Well, let's just, go with, as an example, let's go with Jessica Bates. What is the patient address given there in the fifth column?
Her address is 23 County Road 412 in Oxford.
Okay, earlier, I believe we read that, that address listed as her work address on prescription. Do you know what else is at that location?
That is actually where Jessica Bates resides. That's her home address.
So her place of residence and, her place of business, according to records that you have personally.
Yes.
If you don't mind, again, and I just want to make sure that I want you to confirm that you are seeing these same locations that I am. I see Oxford listed as a location. Is this the shipping address?
It is.
Okay, so you had products and power were shipped to Oxford. I see Nesbit, you see that?
I do.
Cleveland, Mississippi.
Yes.
You see Sturgis, Mississippi, there in about the middle of the page.
Yes.
I'm just looking for units, okay? About 3/4 of the way down, there's a reference to Hattiesburg, Mississippi.
I see it.
A little further, Gulfport, Mississippi is listed,
Yes.
Starkville.
Yes.
Flipping to the next page. Madison, Mississippi.
Yes.
I apologize. I think I've moved over to, I've moved over to 503. I apologize. And so page 145, that is the 503A portion of the spreadsheet, correct?
That is correct.
And for each of those, the doctor's name is given as Benjamin Fine, correct?
Correct.
All right, if you look at page 146, 147, and 148, I believe we've already established that this is the spreadsheet for 503B orders, that is clinic supplies, correct?
Yes.
I have a question about this.
Okay,
Earlier, when you introduced, you said that 145, 146 for 503 days, next to 503B. Is that correct or that?
I was incorrect and I misspoke. As the witnesses testimony, you are right, and I need to clean that up. 145 for the record is 503A. Pages 146, 147, and 148 are 503B.
Correct.
And 503B again, clinic stocks, correct?
Correct.
Okay. Now starting on page 146, and I I'm gonna ask you to flip through the other pages to see if this is the same for each. But the doctor's name, what doctor's name is given? There's two different versions, right? It's the same last name, Feinstein, correct?
Correct.
In one place it says Feinstein or DS as the last name, correct?
Correct.
The first name is given as Benjamin. Occasionally it's listed as Benjamin Allen, correct?
Correct.
So the doctor's name for each of these is Benjamin Feinstein.
Correct.
And that's true on page 147. It's also true on page 148. Is that right?
That is correct.
Okay. Back to 146, the column under clinic name, it's about right in the middle of the horizontally of the page. You see that?
I see it.
All right. And I just want to go through and let's read, let's confirm clinic names. iDrip Therapy Nesbitt,
Yes.
iDrip Therapy Cleveland,
Yes.
iDrip Therapy Amy Toso.
Yes.
We've already covered IV Cleveland, iDrip Therapy Janet Beal.
Yes.
We covered Nesbitt, iDrip Therapy Sturgis B period F period.
Yes.
We've already covered Cleveland and Oxford. Next page, Cleveland, Nesbitt, Oxford, Nesbitt, Cleveland. All the same locations we've already. Okay, on page 148, about the fourth line down, there's a new iDrip therapy. It says iDrip Therapy Hernando, correct?
Correct.
Would it be appropriate for us to take a short break this time?
How are y'all doing? Fire break, anybody? Are you good?
Y'all need a short break.
Break or?
Short break. Let's take a 10-minute break. Back at 10:40.
For the record, I was informed during the break that, Mr. Chapman informed me that he did not have enough physical hard copies of their documents. However, they've been put on the Service Pros. And they are, and I informed Mr. Chapman of this, they're being sent to Dr. Gersh and Dr. Joyner with the same, proviso that they're not to look at them until they've been admitted. Is that fair? Is that?
That is fair. Thank
Permissible.
you. Yes, that's permissible. Thank you.
Okay. I tend to the witness.
Organized. Before I start, is it Mrs. White, Dr. White? Let's stop.
Ms. White is fine.
Make sure I'm fine, make sure I was respectfully call you what you want me to. I got a few questions for you, Ms. White. Let me start with this. You said that initially this all began with a complaint that the board received, or the board of pharmacy received from a concerned citizen. Right?
That is correct.
Anything in that complaint involve any patient harm?
No, just concern.
Anything throughout the investigation conducted by the board of nursing or the board of medicine that showed any patient?
Not to my knowledge.
And with Empower, you mentioned that you and a couple other agents went out to Empower. I think you mentioned both locations, several locations, the 503A and 503B, correct?
That is
Is
correct.
that actually two separate physical locations or two divisions in one place where?
It is two separate physical locations.
Now, and then so we've gone over these spreadsheets a little bit, the 145 through 148. Those. You've represented to the board that this is everything that you got from Empower, correct?
No, I said that this was part of a spreadsheet that we got from Empower.
But it's everything on Dr. Fine's work.
Correct.
So there's nothing, no other records for IDRA from Empower that have been left out of this. And Empower, I believe you said that Empower was the sole pharmacy that's providing them these items.
I said that as part of the investigation, Empower came up as the pharmacy that Ms. Bates said she was receiving her medications from.
Did you investigate any further, any other pharmacies that any of the other ones may have been using?
Yes,
Did you find any others?
yes.
But we don't have any records of that here.
No,
So all we're looking at then is the Empower sheet.
we are.
All right, let me ask you this too. We went through, I'm not gonna ask, turn it back, but we went through some of these, the menus, for lack of a better word, we'll call them. And Mr. Barnes pointed out on page 139, Zofran, Toradol, and Pepsi, is that correct?
That is correct.
Can you show me anywhere on 145 to 148 where any of those three drugs were listed?
No.
Why not?
More than likely, she did not order those medications from Empower.
And you don't have any evidence that they ordered from anywhere else that we did.
I don't.
Okay, you're a pharmacist. You're familiar, I guess, with the Legend drugs versus prescription, things like that.
Legend versus over the counter. Legend is
Explain
prescription.
what is a Legend drug?
A Legend drug is a prescription drug, so it requires a prescription.
Now, and you've stated, I guess already, that all of these items, the vitamin supplements, I'm assuming some of these are amino acids, things like that. Even though these are things that are found in the human body, things that we can't get over the counter in certain levels, once they become compounded or once they are meant to be injectable, they then become prescription.
Yes, only available by that way.
And I believe you said that's solely due to the route of administration, correct?
Yes.
Now, We go back to. Go back to page 87 and 80. Now, I'm a little confused. Just walking there a little bit too, I guess. We have these prescription forms. And these were sent to Howard. Or how is this?
Yeah, these were electronic prescription orders that were submitted to Empower.
Now, we're talking about compounding these and mixing these, but did how and the difference in the 503A and the 503B? So I guess the 503A, you said have to be patient specific
That is correct.
because they're compounded.
They are compounded
Does
medications.
Empower compound them and send them out compounded?
Yes.
But then anything within the 503B would have been sent out separately and the nurse compounded or not?
So just to clarify, for the 503A, the medications that you see here, the number 1 NAD plus, that is a compounded medication. The number 2 L-carnitine injection is also a compounded medication. They are not the commercially available form of those medications. So once these medications were then sent to the patient, or in this case, Jessica Bates, then further they were added to the IV fluid. Same thing with the 503B. Those would have been compounded medications coming from the 503B for clinic administration. But once they got to Jessica Bates in this case as well and others, then they added those to an IV fluid.
Look at page 88. And Mr. Barnes had to go through this a little bit. We have the diagnosis, no known medical conditions. I let me back up for that. You stated that this is a lawful legal prescription in the state of Mississippi, correct?
Yes, it's electronically transcribed prescription order.
And we have their diagnosis, no known medical conditions, correct?
That is correct.
And then we have the clause that Mr. Barnes read for the board about due to a medical need of a specific patient and all that, et cetera, et cetera. Well, does that clause and the diagnosis then contradict each other a little bit?
By the clause saying that there is,
Due to the need of a specific patient and the preparation is prescribed because the prescriber has determined that the preparation will produce a clinically significant therapeutic response.
if you go back to the actual prescriptions of the drugs, it tells you there that the reason that they had to compound was because it was to decrease injection site pain for them to be able to administer.
Well, that's not really what I'm asking though. That's why I guess what I'm asking is, we have this clause that was pointed out about that the preparation will produce a clinically significant therapeutic response. So, but then it also says that there's no known medical condition in the patient. So is that contradictory, or can you, let me rephrase that. Can you have something that's clinically therapeutic in someone who's not sick?
I will say that I'm not a physician or an APRN that does diagnosis. So in this particular case, that clause is there to cover the pharmacy for the fact that it's a compounded medication, but there may be a commercially available product out there.
Okay, so that covers the pharmacy.
It does.
So it's not necessarily stating that this is being given to treat any particular condition.
The fact that they left off diagnosis, it could have been blank, or they chose to put no known medical conditions. So that would be the judgment of the physician or the APRN.
Okay. Now I could go through, we have numeracies, it's 87 through 134, whatever. I can go through each of these prescriptions, or all of them stipulate that each of these individual prescriptions by diagnosis says either no known medical conditions or stipulated.
Yes, rules those two.
I would point out for the board then that every one of these individuals, and are these all of the prescriptions that you were given by the panel?
These are all of the prescriptions that were submitted or written by Dr. Feinstein.
So then we would state for the record then that each of these states for diagnosis, no medical conditions. I believe, clear this up a little bit too. I think I got a little confused, or maybe it was said two different ways. Ordering IV fluids, ordering injectables, ordering any of the stuff we're talking about here today. Said you have to have a prescription, but is it that it has to be ordered by someone with prescriptive authority, or does there have to be a specific prescription for a condition or patient for that item to be sent by?
So for rephrase
You said,
that,
okay, you said, at one point you said, specifically, you stated that these items, these vitamin supplements or whatever else we're talking about, must be ordered by someone with prescriptive authority. Now, is that different from having an actual prescription for a patient?
yes. So in this case, when you look at the 503A, they have to have an actual prescription for a patient before they can dispense the medication.
But the B's.
But the B, it has to be someone who has prescriptive authority that places the order.
Right,
It doesn't have to be for a
they
specific
obtain it.
patient.
Can they obtain it and keep it in the clinic or wherever?
Correct.
But that's the difference between A and B.
Yes.
Get close to. The Board of Pharmacy, maybe out of your jurisdiction, I guess, since they're in Texas, did the Board of Pharmacy do anything or send anything to empower for health development?
We have an ongoing investigation. So at this point, I really can't comment on that.
Okay, now you were involved with y'all were involved with the Board of Nursing in their investigation, correct?
Correct.
And you stated that, or repeat for me, Ms. Bates, the investigation showed that she would present these menus that are at page there, I forgot. And then the patient or the client or whatever it is they're going would then choose what they wanted.
That is what she stated.
Anything in your investigation to show any otherwise than that?
No.
And one last thing, I guess Mr. Barnes brought up the hangover cure menu and the beauty blend and all of that. You stated that none of these, in your knowledge, are diagnoses or conditions, correct?
Medical conditions.
I object to the form. This states prior testimony of those two, because we did talk about migraine.
Okay, well, let's say then but now migraine, okay, we'll look back at that one, that is page. That just says migraine blend, correct?
It does.
And I believe that's all I have. Thank you, Ms. White.
Yes.
And Ms. White, I have just a few more questions for you, if you follow up, and the board has as our hearing officer, the board has the right to ask questions too. I apologize. You were asked about patient harm. Is it the policy of the pharmacy board to wait for an incident patient on before you conduct an investigation?
Yeah,
In fact, isn't the purpose or one of the primary purposes of the investigation to prevent patient harm?
that is correct.
And I believe you've explained this, that we're really talking about compounded drugs on multiple levels here, okay?
That is correct.
Because some of the, again, Empower is a compounding pharmacy. They create some compounded that is not the name brand or the name, of the drug. They do a compounded version of it. And that's what each of these items, is. Each of those is a compounded version, correct?
Correct.
And then you have a further level of compounding when anyone takes those ingredients, those particular supplements or medications, and then further compounds them into a bag of IV fluid, correct?
That is correct.
Is it important that compounding be conducted in a sanitary environment?
Yes, it is important. It's very important.
I believe this was clear, but I just want to make sure. So the only drug orders that require a prescription are the patient-specific orders, correct?
That require an actual prescription for a patient.
But pharmacies cannot sell and ship clinic stocks to a practitioner's location without them being placed by order of a practitioner with prescriptive authority.
That is correct.
Physicians have prescriptive authority in Mississippi, correct?
Correct.
APRNs have prescriptive authority in Mississippi.
Correct.
With some limited exceptions for specialized types of, like a CRNA has a specific scope of practice.
Right.
Physician assistants have a limited prescriptive authority as well. Correct?
Yes.
Do RNs have prescriptive authority in Mississippi law?
RNs do not.
What about licensed practical nurses, LPNs? Do they?
They do not.
What about paramedics? Do paramedics have prescriptive authority?
They do not.
Now, when you were asked about the no known condition on the thing, it is not a requirement that a prescription state the diagnosis for which the prescription is being made, correct?
It is not.
Okay. Could it be, and I'm just asking, well, I don't want to ask you to speculate, but no known condition, could that be ruling out contraindications or medical diagnoses that clash with that thing? If it's too speculative, you can just say so, and I'll talk.
Yeah, it is speculative. I don't know on that.
Okay. But certainly the fact that on the prescription itself, it says no known condition, that does not justify the use of an injectable prescription medication, does it?
No.
Tend to be witness.
Do any of the board members have any questions for this witness? Attorney Barnes, are you all finished with the?
I'll finish.
That's why you make that down. Thank you. Excuse me, doctor.
And I just want to confirm that she will not give a call. This white lady.
You're free to go at this time.
At this time, I would call Investigation Supervisor Michael White to the stand. Smith. No comment.
I also like the record to reflect that all witnesses have been sworn in.
Please don't make any comments about executive function. I apologize. Supervisors. Please state your full name for the record.
Michael Brandon Smith,
And what is your occupation?
I'm an investigation supervisor for the Mississippi State Board of Medical Licensure.
How long have you been employed by the Mississippi State Medical Board, or Board of Medical Licensure?
I'll be 7 years next month.
Okay. When did you become investigation supervisor?
Almost 4 years ago.
Right? And in your role as investigation supervisor, what do your job duties include?
I assist the investigators in their caseload, help monitor what they're doing, give them feedback on what they can do to enhance their case, to look for new avenues on investigating whatever violations may be there.
If you would, the exhibits that are there, on the witness stand, if you would turn to page 145. You recognize the document?
I do.
Okay, how do you recognize it?
This is a spreadsheet that I received from the record investigation, Jonathan Dalton, who received it from Ms. White earlier, and I filtered it to by just typing in the position, last name category, the last name Feinzimmer, finding these results.
Okay, and again, and so page 145, those are the quote patient specific. That's the patient specific spreadsheet, correct?
145 is what I call a patient, and then the others are claims.
Okay, the other ones you mean pages 146 to 148.
Yes,
And you heard Ms. White's testimony about clinic stocks versus patient stocks. And she discussed the contents of these spreadsheets. So you agree with her that the first page is for patient-specific drugs, the other spreadsheet is for clinic stocks.
I do.
Okay. And again, you are the person who you received a complete spreadsheet from pharmacy, Board of Pharmacy, for all Empower shipments into Mississippi. Is that correct?
I did.
Okay. You personally filtered that spreadsheet with Dr. Feinzimmer's name, correct?
I did.
And so page 145, that patient-specific spreadsheet, and then the clinic stock spreadsheet on 146 to 148, those are subsets of the entire spreadsheet provided by Empower. You partially did the filter.
I did.
Who was the primary investigator of this board assigned to investigating the allegations against Dr. Fines?
Agent Ron Horner.
Attend to the witness.
Any questions from council?
That's the problem.
Will you repeat that last name? Who was the primary investigator assigned? I'm sorry, I didn't hear you.
Agent Ron Horner.
Thank you.
Okay, you are sorry, tell me your title again. Supervisor of Investigations. And who do you report to? Jonathan Dalton. And his position is Director of Investigations. So how involved were you in the investigation into Dr. Fine? Minimally. You aware that he had a meeting with Dr. Cleveland and Mr. Barnes in September of 2023? I am. Did you attend that? I did. Right. Who else attended that? I think that was Ms. Phyllis Johnson and Dr. Cleveland, Councilman Paul Barnes, and Dr. Fine was there as well. You said that Mr. Horner was the primary investigator. Was he not involved? He was unavailable. So you filled his role then? Correct. How did you prepare for that meeting? I typically don't prepare much when I'm just the investigator supervisor, other than just knowing the
general discussions that are gonna be had.
Did you meet or talk with Mr. Barnes or anybody from the board prior to the meeting?
I don't
I
recall.
object to the extent that that calls for, privilege, the testimony concerning privileged communications between, board attorney and the investigations division, heritage report and investigations for the purpose of and for the use of, the board attorney.
I'm not asking for what he specifically talked about. I'm just asking if he talked.
Overruled.
Did you speak with him? You said you, okay, I'm sorry, repeat the question. Did you meet or talk with Mr. Barnes or anyone?
I don't recall.
Did you ask any questions?
I don't recall that either.
Did you meet or talk with, Board of Nursing Director Johnson prior to the meeting?
I know she was there, but I don't, other than maybe saying hello.
Okay, so generally, I guess then with this investigation, you said you were minimally involved. In supervisors. Did you get reports from Mr. Horner regularly on the investigation?
Any report that any investigator submits goes to me first.
Those written reports, they email, electronic, how are they?
Word document.
All right. Do you have those saved somewhere? Keep those in file?
They give it to the case file.
Is that like a hard file? Do you have software? Is it for statement? Drive?
The agency has a case software.
Um, do you recall at the meeting, if anyone told Dr. Feinstein before they started questioning if he could have counsel present?
I don't recall specifically if he did, but I've been in numerous meetings with Dr. Cleveland present.
I don't even know about the others. Just want to know this.
Can I tell you without a doubt? No.
Do you know if anyone told him that he was free to leave at any time?
I don't recall.
Do you know if anyone told him he was free to not answer any questions?
Again, can I tell you with unequivocally no, but having been in hundreds of meetings with Dr. Cleveland, I know he tells every licensee that.
Are you aware that that meeting was recorded?
Yes.
Is recording all these interviews standard practice?
No.
Do you know why this one was recorded?
It was recorded purposely for the benefit of a line Warner, being that he was absent.
Do you know who recorded it?
I did.
How did you?
What did on my computer?
Did you notify Dr. Feinstein? No. Are you aware that we have a recording, actually two files, within the file board, as part of their evidence? There are copies of that report.
That I have been informed.
Have you listened to the recordings?
Not all of them entirely, but
Are they complete recordings from the entire meeting?
to my knowledge, yes.
Okay, I would, without having to go to the recording and bring it up, it used to be later, at least when it picks up in the middle of the question. I don't know if there are any introductory remarks. There are no introductory remarks. We sort of picked up mid question.
I believe this witness could testify as it began. I will stipulate my understanding that there might be, some gaps at one place, like between the two audio files. So I will stipulate that it is not a recording of the entire meeting. Sorry.
Okay, so you said that it was recorded solely for Mr. Horner's then.
Correct.
Have you ever recorded any other meetings?
Yes.
Of Dr. Cleveland licenses?
Yeah, we now make it a policy to be.
Video. Do you notify the licensee if any video?
Video.
Do you preserve those recordings?
The videos are preserved and council was provided the opportunity to have a call.
How do y'all? Do it?
The IT department.
Um,
Me reiterate.
Yes, I'm not gonna say a liar for the same reason. Um, were you instructed to record the meeting with Dr. Klein?
I was not,
Did you do that on your own initiative?
I did.
Was Dr. Cleveland or I or Ms. Johnson aware that you were recording that? Meeting?
No.
Did the existence of those recordings, come up during, response to the, discovery request by Dr. Feinstein of us when he asked the board to produce discoverable information?
Yeah, I did not consider it to be evidentiary, and when we were first asked for the evidence produced to you, to give them, I didn't really consider it. It was purposely done because moments before the meeting started, I found out that Agent Fuller was not going to be able to attend. So in order for him to be able to know what's going on, I hopped on my computer while the meeting already started and used the recording function. That's why it started coming a few seconds into it, because it was so just kind of off the cuff and happened as soon as we found out he wasn't going to be here. Typically, the investigators are the one taking the notes and writing down all the stuff that's stated.
You stated that now it is, the policy of the board through the executive director to, videotape meetings with, licensees. Is that right? Correct. Again, not merely audio recordings, but videotape of the entire meeting, correct? And now, is it the standard practice, as directed by, Dr. Cleveland, that again, those recordings are begun at the very beginning? They contain the full content of the meeting, including all warnings and, cautions that are given.
Correct.
In each of those meetings, and you specified that you've been in numerous meetings with Dr. Cleveland and you were cut off. Could you please tell us from your experience what Dr. Cleveland's routine practice and habit and protocol is for informing, what it is as for providing information to licensees for this type of thing? First of all, strike that. What's an RC?
A regulatory compliance meeting?
Okay, was this a regulatory compliance meeting?
Yes,
It was also a part of the investigation, correct?
absolutely. All RC meetings are a part of the investigation.
Pursuant to board rules, are investigators permitted to, interview licensees?
Yes.
Apologize when you get too many yellow stickies, you can pull it back. I would expect this. I would just want to be sure that, for the record, that the specific citation is included and I only have one copy of this. I'm gonna show it to Mr. Chapman. And I don't think I need to make this an exhibit. It's a legal document that I'd like to show with, permission and subject to objection. Rule 1.3 of the board's procedural rules, which are part 2645 of the board's chapter 1. Would you read that first sentence of the last paragraph of rule 1.3?
During an investigation, the investigative staff may interview and take statements of witnesses and licensees.
Go ahead and continue with the rest of it.
During the review of the licensee, the investigative staff shall inform the licensee of the nature and purpose for the investigation, and that if requested, provide licensee with a copy of any written complaint provided that if anonymity has been requested, all identifying data of the complaint shall be removed.
That is this board rule of procedure under which the investigative staff conducts investigations, correct?
Correct.
Just for the record, I believe you identified Ron Horner as the chief investigator on this. Okay.
He is.
Attend the witness board.
Does the board have any questions? Thank you. Oh, excuse me, you have a question?
Yeah, is Mr. Horner, available?
Yes.
Okay, thank you.
Can I ask one more, two more questions, maybe?
Two,
Yeah.
Alan now.
Can y'all hear me if I just said?
Yes, that's,
Mr. Horner, you said it has become standard practice to videotape all of these now? Can you tell me why?
Sorry, you said Mr.
Oh, Mr. Smith, I'm sorry.
I'm not at that level. That's probably a Dr. Cleveland decision.
Do you know when that became standard practice?
It's been in the last couple of months.
That's all.
thank you.
They, supervisors. Call investigator Ron Horner as a witness.
Just about how long do you think this witness will take?
It, I'm trying to think. I'm gonna have to use him to introduce a number of exhibits
Correct.
because he was the primary investigator.
Okay.
It's, you know, collaborating with other investigative agencies, so it may take.
Okay.
Just trying to make sure y'all eat today, so that's why I wanted to.
You can have a seat, Mr. Warner, and again, you were present at the beginning of the hearing and were sworn.
Correct.
All right, would you please state your full name for the record?
Ronald Horner,
Okay, and what's your profession?
an agent for the medical board.
Okay, and how long have you been an agent?
Close to a year and a half.
Okay, what did you do before you became an investigator for the board?
I was a criminal investigator for about 20 years with various police departments in Mississippi. And most recently, before coming to work for the board, I was an investigator for the Attorney General's office.
Okay, if you don't mind, could you just list some of the police departments that you worked for as investigator?
The Horn Lake Police Department and West Point Police Department.
So Horn Lake, West Point, and the Mississippi Attorney General's office.
Correct.
Okay, are you a certified law enforcement officer?
I am.
Now, we've heard testimony, the board's heard testimony that you were the primary investigator assigned to work on the Feinzimmer investigation. Is that correct?
That's correct.
And did you answer directly to Supervisor Michael Smith in that regard?
Yes.
Okay. If Director of Investigations Jonathan Dalton needed to interact with you, could he do that directly?
Absolutely.
But was Supervisor Smith always kept in the loop?
Yes.
Okay, if like that. Agent Horner, if you would, explain to the board how you came to be. I'm not talking about being assigned, but how did you come to actually become involved in investigation? What's the first thing you did after you?
I received an investigation that we had received a report from the Board of Nursing concerning two RNs that were operating IV hydration mobile clinics, one in Sturgis, one in Oxford. Once I received the report, I began to review the information, and I contacted the Board of Nursing to get more information on the complaint. I spoke with their investigator numerous times and, followed up from there, interviewing witnesses and so forth.
So, I believe you were present and heard Ms. White's testimony about the pharmacy board's investigation and that there was an initial meeting, with nursing board and pharmacy board investigator with Jessica Bates. Were you present at that meeting?
I was not.
Did you ever, have occasion to interview or participate in an interview of Ms. Bates with investigators from any other agency?
I did.
Describe that.
The Board of Nursing advised that they were going to be interviewing Jessica Bates and Ben Oglesby, again, to clarify some details. So I was able to sit in on that interview and speak with both of the nurses.
Did you receive any documents, Ms. Bates, or copies of documents during that meeting?
I did.
Okay, can you describe the documents you received?
They supplied like I said, the copies of the menus that they were providing for the clients, describing what IV solutions they offered, and those sort of documents.
If you would, in the documents that are there on the desk, would you look at page 13 and 14? Do you recognize that document?
Yes,
What is that?
that's a official complaint report.
Okay, did you create that report?
No,
Does it indicate who did?
it's,
Under your information, did you look there? Is there a
Yes.
name?
it says the name on it's Jonathan Dalton.
Okay,
Are we admitting that?
Are you
yeah,
admitting?
I am asking that be admitted.
Any objection? So admitted.
And then if you would, and I realize this may take a little time, but would you start on page 15? First of all, let me just ask you about page 15. Does this document look familiar?
Yes,
Okay. Why is it familiar to you?
this is part of the information that I received concerning Jessica Bates.
Do you recall whether you received it directly from her during a meeting or whether it came from the nursing board? You know, what was the source?
I believe this actually came from the nursing board.
If you would, start on page 15 and go through page 86. I apologize for the necessity of being so formal, but could you please look through those and confirm that these are all records pertaining to quote Jessica Idrill that you received during the course of your investigation?
Good. Yes, that's correct.
And so are these records that were presented as patient records for just the Bates eye drip patients?
It was.
Okay, now, these aren't the complete patient records for everyone she saw, were they?
Correct.
Or these a representative sample that were requested from her, a certain number of charts or records for patients requested from her?
Yes.
If you would, I would offer, these into evidence as they be admitted. The patient records of, Jessica Idrill.
Any objection from council?
And it's pages 15 through 86.
Yes.
I suppose same objection we had earlier is that complete custodian records to sign off. If they are.
Overruled. Also, are these admitted under seal? Are these sealed, patient records? How are we handling it?
The personally, yes, the personally identifiable information needs to be understood.
Got it.
Otherwise, as far as the forms are concerned, does not do. We would need to redact patient information.
Any objections to any redactions? You
All
may
right.
proceed.
Excuse me. Page 15, please. And please do not say, the person listed as a patient out loud. But do the records, am I correct that the records for this patient whose name is given on the first page, start on page 15, and end on page 21?
Yes, that appears to be one patient.
All right, on page 15, again, no patient identification or specific information, but there's a section at the top for entry of personal information, like address, street address, that sort of thing.
Correct.
Item 2, says date, time you would like us to come by, correct?
Yes.
Item 3, which IV blend would you like? And there are 5 options: Myers Cocktail, Immune Blend, Energy Plus Performance, Hangover Cure, and Hydration. And there are dollar figures next to each one, but there are 5 options, correct?
Correct.
Are any of them checked?
Yes.
Which one?
The hangover cure.
Okay, item 4, which add-ons would you like? And of course, the board can look at that page, but none of the add-ons are checked.
No.
All right, question 5, are you pregnant or breastfeeding? Number 6, do you have high blood pressure / hypertension? I'm reading that correctly, right?
Yes.
Item 7, do you have any heart, liver, or kidney conditions? I read that right?
Yes.
8, have you been diagnosed long QT syndrome?
Yes.
Item 9, do you have diabetes type 1 or type 2?
Yes.
And then there's a question, if yes, when is your most recent blood sugar level?
Yes.
And again, I will read the next questions and, I won't read the questions, the board can see them. But there's one about, have you had any complications for IV months? And specifically uses the phrase, are you a heart? Right?
Yes.
11, please list any allergies. 12, please list any prescribed medication. And this patient did indicate, one allergy and a couple of prescribed medications, right?
Yes.
13, do you have any other medical conditions? And then there's a box, and the box no is checked.
Correct.
Right, and 14, who referred you to us, and there's information given there, correct? But again, I don't want any specific information. And then there is, a paragraph at the bottom that begins, I certify that the above information is correct. To my knowledge, and I have not omitted any details about my medical condition or medical history. I hereby release hydrotherapy and its affiliates from liability without limitation from any injuries that occur to me as a result of not providing current, correct medical history information in this form. And it goes on and says, it's again, the whole language in the record is it's consent, and it is signed by the patient, correct?
Yes.
All right, on page 17. The heading at the top says IV/IM consent form. I would like to direct your attention to the second paragraph on that page. And follow along with me and make sure I get this correct. I understand that the infusion/injection is being carried out under the direction of Benjamin Feinzimmer, DO, and or Leo Traisman, MD, and or Alex Stranoso, MD, medical directors, and by a non-physician who is trained in the safe insertion, monitoring, stabilization, and removal of intravenous intramuscular catheters/needles and infusions/injections. If at any time a determination is made that the procedure infusion is outside of the conditions of safety, it may be discontinued. Did I read that correctly?
Yes.
I would turn to page 18. And again, would you please follow along with me? I hereby grant IDTAV, DBA eye drip therapy, its representatives and employees, permission to use and or publish photographs or videos of myself in print and or electronically. I understand and agree that these materials will become the property of eye drip therapy and will not be returned. I hereby authorize eye drip therapy to edit, alter, copy, exhibit, publish, or distribute the photograph or video for purposes of publicizing their programs or for any other lawful purpose. In addition, I waive my rights to any compensation arising relating to the use of the photographs or videos. I release and discharge eye drip therapy from any and all claims arising out of the use of the photos or videos for any lawful purpose, such as for publicity, illustration, advertising, and web content. And going on, first of all, did I read that paragraph correctly?
Yes.
Okay, next paragraph. Additionally, I grant eye drip therapy and its agents and employees the irrevocable and unrestricted right to reproduce the photographs and or video images taken by me or members of my family for the use of publication, promotion, illustration, advertising, or trade in any manner or in any medium. I hereby release eye drip therapy and its legal representatives for all claims and liability related to said images or video. Sorry if I start too bad. For the court report, I apologize. Furthermore, I grant permission to use my statements that were given during discussion, interview, or other communication with or without my name for the purpose of advertising and publicity without restriction. Waive my right to any compensation. Then last, there is, the last paragraph mentions minors. And then there's a place for a client signature and a date. Is that right?
That's correct.
Okay, page 19, the heading at the top of that page, eye drip therapy soap notes. Right, and there's a patient name, again, don't repeat it.
Correct.
Does it say, item 1, RN administering IV service, who does it say? What's the name?
Jessica Bates.
And then item 2, events and repeat clients only. I have reviewed clients' medical history, medications, and allergies prior to IV start. That's checked, yeah.
Correct.
3, patient condition before IV. All boxes must apply to administer IV. Box 1, patient is in no obvious distress. That's checked.
Yes.
Patient is fully aware of his, her, their surroundings. That box is checked.
Yes.
Patient is lucid and able to make rationale misspelling decisions. That's checked, correct?
Yes.
Item 4, blood pressure. He gives a blood pressure, doesn't
It does.
he? Okay. Item 5, before IV respiratory rate is given.
Yes.
Item 6, before IV heart rate is given.
Yes.
Paragraph 7, time of successful IV insertion placement, recording failed attempts, locations of failed attempts, and then it shows right is checked, IV catheter is checked, 20 gauge. The time of insertion is given, site placement is listed as AC, and explain failed attempts is marked NA, correct?
Yes.
On the next page, item 8, on the right, IV infusion order. On the right side of that page, there's a box that is checked. Can you read what that says?
It says hangover cure 1 LR -1 ml zinc -2 ml magnesium -3 ml B complex.
All right. Again, so these were presented to you, produced to you in this investigation as patient records. This is one patient we discussed that for Jessica Bates, RN, doing business as hydrotherapy officer.
Yes.
Other than the one place we mentioned, is there any indication of Dr. Feinzimmer playing any role in the care of this patient or client?
None that I saw.
We're looking at page 137. 137 to 143, these have already been admitted. And you may, I believe you should have heard Ms. White testify about these. Do you recognize these documents?
I do.
Okay, were those also part of the documents that were produced to you as part of this investigation?
Yes, they were.
Do you recall when you obtained them or what the specific source was?
I obtained these from the medical, the board of nursing from their investigator.
And the spreadsheets that are again on page 145, continue to page 148, during the course of your investigation, if you had reason to review those documents and use them as part of your investigation.
Yes, it is.
Right.
Like they.
Maybe a good place to stop at lunch is here. This forms primary author of the charging affidavit. I will have to introduce that to him, and I expect there may be some cross-examination.
Okay. Is the board ready to break for lunch at this time? Or do y'all?
Oh,
It's
If we're at a good stopping point.
a good stopping point.
I believe so.
That's fine. Okay, that's 8:45 minutes.
Yeah, so can we reconvene at 12:45?
Let's reconvene at 12:45. Lunch is here.
Right.
No break for lunch, 12:45.
Yeah.
See what you does, how about
Mhm.
You remind everybody not to discuss Texas.
Absolutely. Please do not discuss this case during lunch in the restroom or anywhere else. And
Please don't be in the bathroom.
talk.
And I was just reminded of these things.
Yes.
Okay.
Yeah. Um,
Sorry to the bathroom.
We don't take it.
do
I try not to.
Do they wanna,
y'all want?
y'all wanna get food?
We can put you in the
You're happy
kitchen
to
over in the licensing division.
If y'all don't want to leave for.
You'll not leave.
Okay. We're gonna ask
Let
that you
guys
all
Go ahead.
go
first.
first.
Y'all go first.
You may proceed, counsel.
I'll continue my examination of Agent Horner. Agent Horner, would you turn to page 1? And so, page 1 is simply a cover page. You didn't author that particular page.
I did not.
Okay, turn to page 2. Are you the author of this affidavit? Did you sign this, under oath?
Did.
Right. So is this affidavit based on information, documents that you received during the course of your investigation into IDRIA, Dr. Feinberg's activities?
It is.
Um, Paragraph 2. You described that the board received a complaint from the board of nursing. And that 2 practices in particular were located in Sturgis and Oxford, Mississippi.
That's correct.
And explain the sense because the nurses had stayed for the MSD.
Prior to that, do you plan to offer this into evidence?
I do. So I'll offer it now. But,
What page?
excuse me,
No, you're fine.
1 through 10.
Okay.
And if we need the acknowledgement of service, I would like to include pages 11 and 12, which are simply an acknowledgement from one of Mr. Dr. Feinzimmer's attorneys acknowledging electronic service on December 2023. If I could have one more question for Agent Warner Clark.
Okay.
Is this the charge in the affidavit that was served with the summons on Dr. Feinzimmer?
It is.
I offer this into evidence.
Okay, any objection? Okay, so admitted, continue. Thank you.
Yes, ma'am. Okay, again, on paragraph 2, this is on page MSPML 2. Do you see the sentence that begins, the nurses had stayed to the MSPML?
Yes.
Could you explain that? Which nurses are you referring to there?
Jessica Bates and Ben Oglesby.
Okay. And they specifically used the term standing orders?
They did.
And now earlier when we were looking at some of the IDRIP forms for Jessica, her practice, there were 3 doctors' names listed as medical directors. But did they mention any medical directors or doctors involved other than Dr. Feinstein?
No.
All right, paragraph 3. But look at paragraph 4, please. And I just want to confirm this. You say licensee did not take a history from any of the patients in the Mississippi clinics. Licensee did not perform a physical examination of any of the Mississippi patients. Licensee did not make a diagnosis of a medical condition for any of the Mississippi patients. Licensee did not conduct any telemedicine visits with any of the Mississippi patients. First of all, did I read that correctly?
Yes.
And during the investigation, did you receive any information or evidence to indicate that that paragraph was in any way untrue?
No, I did not.
Paragraph 5, without, it's in the record without repeating it. But the first sentence, in point of fact, no qualified licensed healthcare professional legally possessing prescriptive authority evaluated any patients in Mississippi clinics prior to or during the administration of medications, vitamins, or IV fluids. Or did I read that correctly?
Yes.
Did you learn anything in your investigation that indicates that that statement was in any way untrue?
No, I did not.
Paragraph 6. You describe information concerning the Board of Pharmacy and their investigation of Empower. Is paragraph 6, the contents of that, is that consistent with the information and evidence that you gave during your investigation of Dr. Feinstein?
Yes, it is.
Paragraph 7. Is that statement consist, or did you learn anything in your investigation or any information, receive any information or evidence that indicated that paragraph 7 was in any way incorrect or untrue?
No, I did not.
Paragraph 8, discussing patients and clinic owners. Could you just explain briefly, without repeating, exactly what's in the paragraph, could you explain what you learned about patients and the clinic operators, in this investigation?
Just that the clinic operators were nurses. There didn't appear to be any, medication ordered specifically for the patients. It basically was all being handled by the nurses.
And on any of the records that you, for example, any of the records pertaining to Hydro, any evidence through the investigation, did it ever indicate that anyone with prescriptive authority examined these patients, made a medical diagnosis of a condition in these patients, and legally ordered IV fluids for these patients?
No.
I'm sorry, I didn't hear the objection. Any response, counsel?
I can clean it up,
Sustained.
all right? Mr. Horner, you've been employed by the board for approximately a year and a half. What is your understanding of the professional practitioners who have prescriptive authority in Mississippi?
That would be doctors or nurse practitioners.
What about physician assistants?
Yes.
Are you aware of anyone else, in your experience as a law enforcement officer and investigator for anyone else who lawfully has prescriptive authority in the state of Mississippi?
No.
So the last sentence in paragraph 8, none of the Mississippi clinic owners or operators receiving medications and IV fluids ordered with the credentials and in the name of licensee were found to be qualified licensed healthcare professionals lawfully possessing prescriptive authority. Did you uncover any clinic owners or operators or practitioners involved in these IDRIP facilities other than Dr. Feinstein, who was a physician, APRN, or a physician assistant?
No.
Mr. Warner? You said you were a police investigator before you came to the board, correct?
That's correct.
20 years or so?
Yes, sir.
So you're familiar with chain of custody requirements, evidence, that type of stuff?
I am.
Let me ask you this, in your investigation, everything you got, and everything that we have in here and these documents we've gone through, these client charts and these spreadsheets from Empower and these prescriptions, all of those came to you from some other agency, correct?
Yes.
And who'd you receive them from?
Some of them came from the Board of Nursing. Also, the Board of Pharmacy provided some.
Did any of them come with chain of custody verification documentation? Anything signed by anybody from Empower or from either of those boards stating they were correct and accurate?
No.
So really, you really don't know if maybe any of those documents have been manipulated or filled in or anything like that, do you?
No.
Once you got them, once you got the documents that you have and they provided to us, how did the Board of Nursing store them? How are they kept in custody? Y'all?
Kept secured by the agent, that would be by me, and anything that would be here would be kept in the investigations division under
Our file scanned in somewhere.
both, yeah.
Now, as I understand it, now, did you request these records from these boards?
Yes.
Okay. Are these the only records you requested?
As far as I know,
But they're the only records you received,
I believe that's correct.
but you didn't, and I believe all of these client, these charts that we have, that are pages, 15 through 80, whatever, these all came from Jessica Bates, is that correct?
I believe that's correct.
You didn't ask for any records for any of the other providers in Mississippi?
I believe that all this was provided at the time that we were interviewing Jessica Bates and Ben Oglesby. And that's all the information that I received.
But you didn't really request anything else?
No,
Why not?
didn't think it was necessary.
Thought you had enough to get Dr. Feinberg without anything else?
Check or
What's wrong?
argumented.
I'll withdraw. You said you were involved in interviews with Ms. Bates and Mr. Oglesby, is that correct?
That's correct.
Was that done at the Board of Nursing's office?
It was.
When was that? Do you remember?
I believe that was in May 2023. I believe.
Did you happen to interview any of the individuals involved or listed in these charts?
No.
Let's see, and we went over pages 13 and 14. This was the complaint that was filed with the board, correct?
You said page 13 and 14.
14, right.
Yeah.
And so that, the board became involved once it received the complaint from the Board of Nursing, correct?
Yes.
Anything in that complaint to allege or indicate there was any patient harm in?
Not that I'm aware of.
No individual harm by any means. Okay. Now, Mr. Smith testified earlier. Okay, well, Run me through, I guess, when you're assigned to a case. Give me your involvement, I guess, from start to finish with how.
Once it's assigned to me, I evaluate the complaint, evaluate all the information that we have. Make a determination if we need to interview witnesses. Whether there's records to be obtained. Some of that input comes through Dr. Cleveland as well.
So do you discuss cases with Dr. Cleveland while you're investigating? Or do you?
On occasion, not daily, but on occasion, yes.
Do you provide reports to your supervisor?
Yes,
Um,
as necessary, depending upon the case.
any of those written reports?
Yes.
When you're investigating, okay, so I'm along those same lines, when you're investigating a case, exactly what type of records do you create? Creating your records.
Mostly just Word document reports
To
that be submitted to my supervisor.
emails,
Yes,
texts,
rarely.
emails or texts, either one, both, who are those you go to?
Mostly my supervisor.
Do you take, when you're investigating, say, an interview, or we're talking to, like in this case, back up. In this case, did you talk to someone from the board of nursing specifically?
Yes. It was investigator. Can't think of her name.
I may can help.
Jones, I believe it was.
Would be the one that's on page 14, Tawanda Jones.
Yes, that's it, Tawanda Jones.
Okay, did you talk with her via email, phone?
Both.
Did you, when you were talking with her on the phone, did you take notes?
Probably,
That's the handwritten or electronic?
more than likely handwritten,
Where are those notes stored once you get done?
locked in a file.
Same hard file on a lot of documentation or something separate?
Same one.
What records do you generally gather in an investigation?
Patient records normally. Information as far as maybe even personnel records. And other documentations like prescription information, spreadsheets, that sort of thing.
What methods do you use to gather this? How do you go about it?
Multiple ways, either by email, regular mail.
Or as issue subpoenas?
Yeah.
I may have already asked this, but tell me, where exactly do you keep your investigative records? I know it's in file, is there a specific room that you're?
Yes, we have a place in our investigative office where we can.
Store them all electronically as well?
Yes.
Is that a drive is accessible by just the investigative staff, everyone on the board who has access to these files?
That would be the investigative staff and possibly the IT.
Does the board have a document management system or a storage system?
I wouldn't know the answer.
Like, is there a particular drive to store them all?
Oh, yes.
Any software used to keep track of investigations?
Yes.
That's searchable.
Yes, my staff, yes.
Anyone assist you in your investigation? Who else from the staff assist you?
Probably just mainly Supervisor Smith.
Do you know if he took any notes while you were helping you?
Not that I'm aware of.
What's your understanding? Is that the usual practice? Your understanding of usual practice? You have him assist you? Does he not take notes?
Yeah.
You can't say that.
Yeah.
You said you did communicate with the Board of Nursing. Did you communicate? Did you yourself specifically communicate with anyone from the pharmacy board?
I don't believe so.
Board of Nursing, but you said with Tawana Jones, you did, email and phone, you think?
Yes.
All of your communications, notes, et cetera, that we've talked about here in the last couple of minutes. Has anyone asked you to gather those for this hearing? Or to review them?
No.
Did they ask you to preserve them or save them?
No.
Have you done anything specifically? Now, when did you know you were going to be participating in this hearing?
When I was notified, probably, I don't know, maybe a few weeks ago, maybe.
You do anything from that time till now to make sure you preserve those notes, documents, or anything like that?
They're still stored. There's nothing, no way to prepare them.
Have you been assigned any other complaints by your supervisor or by Mr. Dalton or whoever does the assignment of any other hydration therapy businesses?
Check, yeah, whether or not other, licensees are under investigation, is it relevant to the charges against Dr. Feinzimmer? And, each licensee is entitled to their own before the board and to answer charges. This is an attempt to get into confidential investigative files concerning other licensees, so I object.
Any response?
Well, what we would say is, again, Your Honor, or hearing officer, what we're looking to do is we are trying to establish that each of these cases is factually different. And that the board has seen, and going to see multiple of them, but each one is different, like Mr. Barnes says. But the board has discretion based off of that to look at each fact and circumstances together.
I am going to sustain your objection because he has not asked for individual names of complaints. He's only asked a general question regarding if there is any investigation regarding hydration clinics, period.
And we would stipulate.
So wait, so you're sustaining it because of that, or?
Oh, I'm sorry, I'm overruling it, sorry.
And I would just say for the record, we would stipulate to that say
Wait, stipulate the list.
to the statement that each case must be judged on its merits and that individual private circumstances may vary.
Again, that objection, I apologize, is overruled, but you have a fine line there.
Line.
Yes.
Okay, so have you investigated any other hydration therapy? Or individuals?
Yes.
Have any of those come to completion in the investigation process?
No.
None that you've done.
Right.
Okay. Are you aware of any others that have come to completion without telling you they?
I don't know. I'll be honest with you. I'm not sure.
Have you received, okay, so. So now, and this may be repetitive, I'm sorry, I can't remember if I asked this or not. You did say these were all the records you requested and all the records you received.
Yes.
Okay. Now, let's go through a little bit of your affidavit. Start with page 2. Actually, take it back. Let's start with page, I think 6, maybe, or 7, whatever the last page is. Should be 7. Down there at the bottom, you sign and date it on the bottom of page 7. What's that date?
December the 8th, 2023.
Now, did you complete this entire affidavit that day?
Yes.
Yeah, okay, it wasn't work in progress. You had been working on it for a while.
I had been working on it, but I didn't complete it until that.
Okay, when did you start working on the affidavit?
I don't know.
Any kind of ballpark guess, how long it took you? Week, month?
Couple of days probably,
But December, maybe you think?
yes.
Just for clarity, then on one point, let me look at paragraph 1 on page 2. In the last sentence of paragraph 1, you state the licensee, which is Dr. is also the medical director of IDT AZ1 LLC in Arizona, doing business as hydrotherapy. Now, are you aware that at the time of your affidavit, that business was no longer a going concern?
I was aware that there had been a consultant and that they had dissolved the company at that point, yes.
So the company's dissolved, it can't happen that. It wasn't currently at that time of the affidavit is the medical director. It would have previously. Right. Is that fair to say?
Yes.
Now, okay, paragraph 2. You state that the board received a complaint from the Board of Nursing on approximately March 28, 2023. Is that correct?
Correct.
That's the date on pages 13 and 14, right?
Yes.
When exactly did you become involved? When were you assigned to this?
It would have been either that same day or shortly thereafter.
Go back to, let's go back to page 17. This is one of the forms for, we'll say this is the first class chart. We've got a narrow starts on page 15. And what is this form?
You know, 15.
Well, the chart began on 15, but I'm looking at page 17.
That would be a chart that was involved with Jessica Bates.
And what specifically is page 17 of it?
The IV-IM consent form.
So that'd be a form given to the individual coming in for the service, correct?
I would assume so, yeah.
Can you read for me the last sentence of the first paragraph, starting with the word further up to the line down?
Further, I acknowledge that statements regarding vitamin and mineral infusions/injections have not been evaluated by the FDA and that infusion/injection of such has no diagnostic value, nor is the infusion a substitute, cure, therapy, or treatment for any disease or condition.
And you admitted earlier when Mr. Barnes questioned you that is signed by that individual at the bottom, correct?
Correct.
Let's go to page 24. Be the second chart, internet evidence. Same question, what's that for?
IV-IM consent?
Is that signed at the bottom by that individual?
Yes.
You read to me the last 2 sentences of the first paragraph, again, starting 4 lines down with further.
Further, I acknowledge that the statements regarding vitamin and mineral infusions/injections have not been evaluated by the FDA. The infusions/injections of such have no diagnostic value, nor is the infusion a substitute, cure, therapy, or treatment for any disease or condition.
I'll present to the board that we have 10 line charts in this documentation provided by Mr. Barnes, pages 15 through whatever, 80 or 86, whatever. All 10 of those I have an identical IVIM consent form, exactly like one of these two. I can go through the other 8 if you would all like me to, or stipulate they all say the exact same thing.
We'll stimulate to be all said the exact same thing. It's not the law. None of them are signed by either.
But they were all signed by the individuals who received.
Correct.
Also stipulate.
Thank you.
Now, let me turn you to. Let's look at page 62. We won't mention any names again. This is one of the charts again.
I have it here.
Bottom of 62, there's the final question on that page. Which statements best describe why you are here today? Can you read those options underneath that, please?
I want to have more energy and feel better overall. I want to do everything I can to nourish my body. I want to do everything I can to enhance my weight loss efforts. I want to prevent getting sick.
Turn to the next page for 1 second. We'll come right back to 62. Anything else further? Nothing beyond those 4 options there for why they're there.
That's all I see.
Now, I know you're not a medical professional, you're an investigator, but are any of those 4 items a specific disease?
Any rebuttal, counselor? Because I'm gonna sustain his objection otherwise. Okay. Got it.
Uh, Page 7 again. No, I'm sorry. Yes, page 7. What do we have on page 7? What is this?
Describing the counts at which Dr. Feinzimmer was charged.
That's in your affidavit, correct?
Correct.
Did you determine what counts are listed in that affidavit?
I am involved in the process, but Barnes is one that makes determination.
Barnes puts those in there. Anyone else involved in that process besides the 2 of you?
I'm sure Dr. Cleveland has input to it, but I'm not party to that.
You weren't you didn't directly speak. So in your investigation, we've discussed that you did interview, or you were involved in the interviews of Ms. Bates and Mr. Owens.
Correct.
You have received all of these documents from either the Board of Nursing or the Board of Pharmacy. You did not interview anyone else, correct?
Jack, they, gave us some time and,
I can put that up.
Okay.
During your investigation of Dr. Pine, did you ever call Dr. Pine?
No.
Did you ever interview any of the individuals in the shows?
No.
Did you interview any other of the providers listed on the spreadsheet provided by Empower?
No.
Did anything in the investigation that you did perform indicate that any individual was harmed by any transaction?
No.
Was there ever any indication that anything being done controlled a narcotic or a controlled substance?
Not that I'm aware of.
Any other sort of habit forming drug or medication?
No.
Second. Mr. Smith testified earlier that he attended the meeting with Dr. Feinberg, Dr. Cleveland, Mr. Barnes, Ms. Johnson in your stead. Is that your understanding?
Yes.
Why were you not there that day?
I was not updated on the meeting change. It was, the initial appointment was for be like 2:30 in the afternoon. And I didn't get a notice that it had been bumped up till 10 a.m. I was traveling from North Mississippi here for the meeting when I found out the meeting was about to start in about 10 or 15 minutes.
Did you ask Mr. Smith to video or to tape that audio?
No.
When did you find out that he did?
Maybe later that day.
Did he provide you a copy at that time?
Not at that time.
When did he?
I don't remember exactly. It was shortly thereafter.
Have you listened to it?
Yes.
Listened to it when you first got it?
Yes.
How was custody of that video kept?
Objection. Audio.
Oh, sorry, audio. How was the custody of that audio?
Locked in my records keeping locker.
Well, you locked this, you locked a laptop in there? What do you, how exactly was that? Was there a transcript made?
It's, well, actually, it was submitted electronically. So yes, it would be on my state issue computer, yeah.
Any other hands touch it between Mr. Smith and you? Did you know of?
No.
I think that's it for now.
Redirect.
Agent Warner, in your experience as a law enforcement certified law board, do you ever have interagency investigations in cooperation?
Yes.
Is the investigation at Dr. Feinzimmer and Hydra, is that one of those occasions?
It is.
And I believe, Mr. Chapman cleared this up, but he asked if these were the only records that you got at one point. And those are the only records related to Dr. Feinzimmer that you got from nursing and or pharmacy?
Yes.
Okay. What is your understanding? Does the general public have access to the board's investigative files?
No.
Do you know whether the board members have access to the investigative files?
I don't know, but I wouldn't think so.
Do you know whether access to the board's investigative files is agency-wide or whether it's limited to the investigative division and executive staff?
I would say it would be limited.
What is MELS? I'm not going to ask you what it stands for. It's the electronic licensing system, I believe. Can you confirm that?
Yeah, it's our agency's, yes, computer program for how we manage everything.
And is that, the software that investigations uses to manage and, to manage investigations and evidence?
Yes,
Okay, is there a side of it, for licensure purposes?
yes,
Do you have access to the licensure portion?
yes.
The licensing, do you know whether licensing personnel have access to the investigative?
I don't know.
At the time, strike that. I believe you testified that, this board's investigation, Dr. Fines, began with contact, from the nursing board in approximately March of 2023.
Yes,
Okay, so when you, wrote and finalized your affidavit, the charging affidavit, I should say, signed by you as the chief investigating officer, in December, this investigation been going on for, what, 7 or 8 months?
yes,
At the time of the events in question related to Jessica Bates, Ben Oglesby, was Dr. Feinsworth, to your knowledge, the medical director of Adria?
yes.
To the witness.
Do the board members have any questions? Okay.
Call Jonathan Dawson. For the record, we did not list Mr. Supervisor Director Dawson as a witness on our witness list, but we included anyone named by the other side, and Mr. Dawson has been named as a will call witness by Mr. Chapman.
Okay, any objections?
All right, could you please state your full name for the record?
Jonathan Dawn.
And, excuse me for the interruption. He has already been sworn, correct?
I
have.
Okay,
I apologize.
That's okay.
For looking at that. What do you do for a living?
I'm the Director of Investigations for the State Medical Board.
Hey, how long have you been the Director of Investigations?
Around 4 years now.
Okay, before you were became the Director of Investigations, what position did you hold?
I was the Supervisor of Investigations.
And how long did you hold that position?
3 years roughly.
Okay, did you work for the board prior to that?
I did.
Okay, when did you start working for the
2009. I've been here 15 years.
Okay, since you began working for the board since 2009, have you always served in the investigative division?
I have.
When were you an investigator before you became supervisor and then director?
I was.
So as director, you have overall, broad supervisory, authority over all investigations. Is that correct?
I do.
Do you, are you personally involved in the details of each and every investigation?
Typically, no.
Okay. What specific involvement, personal involvement, can you recall that did you have in regards to the investigation of Dr. Fines?
I was contacted by, as the complaint states, I was contacted by Investigator Jones from the Board of Nursing to discuss this IV hydration clinic or operation that they were investigating. And she reached out to me essentially with the name and wanted to know, was this someone that was licensed by our board? So as we typically do, we work a lot of interagency investigations. So I assisted her with that. Looked up this name and found that Dr. Feinsworth was licensed by the board, and we had a discussion about what they had uncovered to that point. It sounded as if that was something that might potentially involve violations of the Medical Practice Act, and for that reason, I initiated a complaint for the executive director's review.
And, under the board's, procedural and investigative rules, is it permissible for a member of the investigative staff to initiate an investigation based on information received from outside the agency?
Absolutely.
Would you look at pages 13 and 14, in the documents?
Yes.
And what is that?
This is a PDF representation of the complaint that I filed electronically based off the information provided to me by Ms. Investigator Jones.
So is the board's complaint system electronic?
It is.
If you receive a written complaint, how do you put that into the system?
So we would, as staff, we do receive phone calls sometimes for individuals that don't have access electronically to our electronic filing system. So we will send them a paper complaint form that they will then mail back to us, and we will then put that in. In this case, this was a phone call I received, so I went in and entered this myself as information from another source.
All right, and under the heading confirmation information there, what's the submission date?
March 28th, 2023.
All right. If you turn to page 14 on the narrative. Right there at the top of the page. So this complaint came in, or you made the complaint based on information from the pharmacy board against Dr. Benjamin Allen Fleisch, correct?
That's correct, from the nursing board.
Under the incident information in the narrative, could you please read that
Yes.
out loud?
The board was contacted by Board of Nursing Investigator Tywanda Jones related to Dr. Feinsheimer. Investigator Jones stated she was trying to verify whether Dr. Feinsheimer was licensed by the board. I reviewed the licensure system and was able to locate his record as a licensee. Investigator Jones stated he was identified by 2 IV hydration practices run by RNs, one in Sturgis, Mississippi, IV hydration to youth, and one in Oxford, Mississippi, IV drip Oxford. She states these are both mobile IV hydration practices, and they are operating off of standing orders issued by Dr. Feinsheimer. I explained the history of similar practices, citing the case against Dr. Chad Vega, and how standing orders are not proper practice for patients not seen by the provider. Furthermore, since there is no mid-level to properly evaluate the patient, Dr. Feinsheimer is assisting in the unlicensed practice of medicine by enabling the RNs to give IVs to individuals with no proper H&P or other evaluation by a provider, opening this as an investigation into both practices.
And did the board's investigation into Dr. Feinsheimer corroborate the narrative?
That's my understanding.
Leading up to this hearing for the last couple of weeks, did I ask you contact the nursing board and obtain any documents?
In addition to what we already had,
Yes.
not that I recall.
Okay, when you look at page 235.
Yes. Oh, yes, yes, I do recall this.
So do you, what are these documents?
This is,
And the pages, I'm sorry, 235 through 342.
I'm sorry, say that last part again.
235 through 342. They also bear other papers in blue, which say MSBN 1 through MSBN 108.
these are evidentiary documents related to a hearing that took place at the Board of Nursing regarding Jessica Bates. The top page is a chronology of the documents that were produced to the board at our request.
And do you recall approximately when you received this group of documents?
I don't remember the exact date, but it was, recent. My recollection.
Are there documents contained in this, set of documents from the Board of Nursing that had already been received in the investigation?
Yes.
Okay. For example, beginning on page 11,
You referred to the MSBN.
I'm referring to the SBN number. No, well, that's the Board of Nursing number. Thank you. Board number is 245.
Yes, sir.
And going through page 251, you recognize those documents?
I do.
You recognize those as being the menus or recipes, as they variously called for, that were used by Jessica Bay.
Yes, sir.
Beginning on page 252, MSBN number 18, and going through page
Of these records, and if these were what were used by the state, she actually used it, this is what we had.
Any rebuttal?
it is my understanding that, trying to think what the term that the, nursing board uses, but she made a deal. And so there was never an evidentiary hearing, where these documents were formally introduced as evidence. And so I apologize for that statement. And I can clear up again whether we're obtained. So. to the
Sustained.
extent I said that I apologize. Mr. Dalton. Is it your understanding that the nursing board is providing us documents that would have been introduced into evidence if a hearing against Ms. Bates had been necessary?
That's my understanding.
Okay, and as I was asking you, begin on page 252 and going through page, I think it's 323. Do you recognize those documents as documents that had already been received by this board?
I'm not in my role intimately familiar with all the documentation, but this does look like the documents that have been seen previously, yes.
Okay, if you turn to page 324, had you seen this before the nursing board produced this file? If you recall, 324.
Is this the, you said 324, this is the email to Wanda Jones, is that my look at the right document?
Yeah, from Jessica, the top one is from Jessica, that's purports to be from Jessica Bates to Wanda Jones, and then there's other emails there on the page.
I believe that I have seen this.
But had you seen it, before you received this packet of documents?
No.
What about page 326, state's final order? Had you seen that before you obtained this entire packet from the nursing board?
No.
What about 327?
No.
And that document continues on 328, 329. So that was, excuse me, through 330. So that was a document that you had not seen before.
Correct, I had not seen that document.
And then on page 331 through page 342, there's a document that it appears to be a transcript. The title is Bates hearing, Jessica, October 4th, 2023. Had you seen this transcript before you obtained, this package?
No, I had not.
I am. Yes, at this, I would say, at this time, I would admit this as documents received, from the nursing board, bearing their base numbers and, with their index.
And that was, for the record, 235 to 342.
Yes, ma'am.
Any objection? So admitted.
Mr. Dalton, is the investigation software system for the state, so that's secure system?
Absolutely. Would you like me to describe how it's secured?
Sure.
Okay. So, the mail system is divided into two really independent, sides of the system. One is a licensing system that handles the licensure process, which we're going through renewals currently. The other side is an investigation system. Now that is, completely firewall off, for lack of a better word, from the licensing system. There is a portal in which, an investigator could potentially access the licensing system from investigations, but the licensing system cannot access the investigation system. It has to have a special unique login that's tightly restricted to just investigative staff and certain executive staff.
Okay, so the IT department obviously has access to mails. correct?
Yes, correct.
And do we have an outside vendor who also is, well, let me ask you this. Do you know who developed the mail system?
Yes,
And who was that?
company, ThoughtSpan Technology.
Okay, and is that company the outside vendor that built this or customized this for this board?
Yes, this was a software package that's used in numerous jurisdictions across the country, and we had it customized for our purposes.
And is the system updated frequently to iron out wrinkles, et cetera?
Very.
How long has the board been using the system?
I want to say maybe 4 or 5 years now.
Was Dr. Cleveland here when the system was first? It's all there had to be begun.
Yes, he was here.
And that's where the official copies of all investigative file documents are stored is on the mail's investigative side.
That's correct. Agents maintain what I would call their own working file, just for their own notes, but the official file is kept in the mail's investigation system.
Do all the investigators for the board work out of this office or work here?
No, they do not. We have certain staff that are stationed here, but quite a few actually are work from home in the field, working out of their homes at different locations in the state to help cover the different geographic areas.
So they work remotely?
Yes.
What agents does the board have or investigators do we currently have to work remotely, primarily remote?
Sure. Agent Horner is one, working the northern part of the state. We have Agent Todd Ponert, who is in Hattiesburg, Agent Jenny Payne, who is in Hattiesburg, and Agent Alex, last name escapes me right now. Alex out of Hattiesburg. And Agent Brett Estes, who works at his home as well.
I apologize for the record. I did glance at Estes, who is sitting in the room, and who was recognized by Mr. Dalton. Other than investigations in IT, to your knowledge, are the executive staff, that is the executive director, the deputy director, Mike Lucius, chief of staff, Jay Ledbetter, and myself, Paul Barnes, as board attorney, are we the only other people that have access to the mail system?
That's correct.
That's
That's correct, other than the IT vendor themselves, yes.
Tend to the witness. Oh,
You do not.
I need to ask one question. In the narrative on the complaint, you mentioned the doctor name, Chad Vega.
That's right.
You recall the facts of Dr. Vega's case?
I remember them loosely. I worked that case.
Do you recall any of the details of Dr. Vega's misconduct? If you don't, it's that we can go into it with another.
I remember bits and pieces, but I don't know that I remember such detail that would be useful in this hearing.
Fair enough, and I don't want you to speculate or, and if you don't remember, you don't remember. I tend to remember.
Take your time, sir.
All right, Mr. Barnes just asked you about Dr. Vega. And you stated that you didn't intimately remember the details, right?
That's correct.
Can I help maybe refresh your memory a little bit?
Sure.
Now, you did say in your complaint, it was a similar case, correct?
Based off what she told me, yeah, it sounded familiar to his case to me.
It dealt with standing orders, perhaps?
That's what jogged my memory.
Yeah. That document is,
This is a consent order signed by Chadwick Thomas Vega.
that's with this board, correct?
Yes, sir.
I'd like to have that admitted into evidence. It's finds in our pages 1 through 5, I believe, any objection.
I object to the relevance, but I don't object to it being part of the record.
Overruled, and I think you actually opened the door for this, Counselor, so.
Okay.
Overruled.
Take a look at paragraph 1 on page 2, please.
Okay.
That's gonna be the beginning, actually, I'll tell you above that, right above that, now therefore. Will you just read that first little sentence there?
Sure. Now, therefore, the Mississippi State Board of Medical Licensure, with consent of licensee as signified by his joinder herein, does hereby place licensee's medical license on probation with removal of said probation subject to the following terms and conditions.
Now in paragraph 1, what exactly, what is paragraph 1 included in those probation terms?
In all words, you just read it.
Let's read.
Okay. Licensee is hereby prohibited from issuing medications or initiating therapies, inclusive of intravenous therapy, for patients whom licensee has not established a bona fide doctor-patient relationship through collection of an appropriate medical history and completion of a physical examination in a manner consistent with acceptable medical standards prior to the initiation or issuance of said medications or therapies.
So, Mr. Dalton, would it be fair to say that Dr. Vega's case involved IV therapy?
Yes, sir.
Specifically listed, correct?
Yes, sir.
Would it be safe to say that it includes IV therapy given with an allegation of no established bona fide doctor-patient relationship?
No objection.
Could you reset your question?
Would it be fair to say that it dealt with IV therapy given in the context of perhaps no established bona fide doctor-patient relationship?
Yes.
And would it be fair to say that it involved standing orders under your recollection?
Based on my recollection, yes, sir.
And this doctor received what now? This penalty?
It states that he was placed on probation and restricted from the utilization of, restricted from initializing any therapy that he didn't oversee, I guess, directly is the tenor, I guess, of that requirement, specific to IV hydration.
So probation,
Yes.
Correct.
Mhm.
so no suspension? You look through the rest of the document if you need to.
I don't see language about a suspension, no,
No
sir.
revocation?
Just a question, from the chair. Do the board members have access? I know we said that you did not have enough copies for the board.
believe.
Is
Were
it
they
supposed to be
put
on the,
Okay.
which
Which
document?
Finds number 1 through 5.
We have exhibit.
You should have it. Well,
I have,
I guess they don't have the extra that I just put in, because, or Jackie put in this morning. So you would have to go to the officer.
That it?
Give us one moment. to Make sure everybody, no, you're fine.
Is it in the
Is
Feinsheimer
it-
exhibit?
is it, because I have funds in our production,
We got
One
two
through-
Feinsheimer's production. Which one are you?
and then I
Wait,
have
what?
exhibit.
So it's 1 through 5.
Here's
have
exhibits,
it.
5, 8, 7, 10 AM, sound right?
Is this your exhibit
have
that you're referring to?
Yes.
Yes, I'm in the first.
It's
I'm in
first
the-
time for my production.
It's the first 5 pages of this production, is he's saying, so there's one that starts at page 1.
Here,
through
then
300.
So it's,
Yeah.
I thought it was talking about, okay, I got it.
Some people have it and some people don't.
Wait,
I
so-
have access to
Wait
it.
a
I have
minute,
a few
it's
hard
on,
copies I can.
just
that I
one,
can-
one second, please,
Go ahead.
guys, if you go on your Surface Pro to the file folder, there's a file folder in your toolbar down at the bottom of your screen. And if you click on that, you'll see a list of files. And if you look at that, there is one that says Feinsheimer's production, I guess it's 1 through 306,
It should be right, yes.
43,350 kilobytes. If you click on it, it's dated 5/6/2024, 6:46 AM.
Why it's called a production.
It does, it says Feinsheimer's.
It usually indicates that date.
So that's where, it's my understanding that's where we are right now. And Doctors Gersh and, for Doctors Gersh and Dr. Joyner, it is the 306-page document. And it should be listed as Feinsheimer's production.
Okay.
All right.
Here we go.
Everybody, are we all on the same page now?
Mhm.
All right.
And he is discussing the, Attorney Chapman is discussing the consent order from Vega. That's 1 through 5. It's already been admitted.
So we are currently, that consent order is the first page, starts on the first page of that 306-page document. I just wanna
Making
make
sure
sure everybody.
we're here.
Yeah.
Sure.
I'm good. I have it here.
Got it. Okay. Thank you so much for, you may continue.
Well.
We're talking about the terms.
Suspension and probation.
So no suspension, no revocation. That's correct. Hey, let me shift gears real quick. Let me go back to this complaint, pages 13 and 14. Just to clarify for me now. Did you say that you received this call from Investigator Jones?
Yes.
Okay, so you did receive it. And I see the submission date is 3/28 and 3/43.
Yes.
This is gonna sound like I'm trying to do a gotcha on you, really not. That's not how it works.
That's it.
Say that one, then. Take a look at, MSBML 236.
Okay.
I'm just really trying to clear up the timeline of how this process works with complaint intake.
Sure.
We tell me what this document is,
So this is an email from me to Investigator Jones.
and what's the timestamp inside of that?
It says 3:26 PM.
So, if you recall, I mean, we got to go by the times on it, but did you send this email before you entered the complaint into the system?
Yes, it looks that way.
Is that normally how you do this?
So my recollection is that she had called me, we spoke on the phone, and she had asked what we had talked about to memorialize it and send it to her in an email. So I had chosen to do that before I went into the system. That's my recollection of the sequence.
Fair enough. I was curious. Which I guess leads me to the next question is, next set of questions. Explain to me, I guess, well, how do board complaints come in? Or how do board complaints? How do you go ahead?
Sure. So they come in a variety of ways. Typically the public, we do get complaints from other agencies, law enforcement, other healthcare practitioners. It really can come from anywhere, but I would say public by and large.
You get phone calls, emails?
Well, since the implementation of the system is typically electronic in this format, but it would be someone accessing our website publicly and entering it the same way I did.
Well, okay. What do you mean? I guess explain that. So a member of the public can go on the board's website and type in a complaint that files into one of these?
That's correct. So what happens is an individual could go in, there's a portal, let's call it that, on the website, where they can click and go and they walk through a process. And if you'll look at this complaint report, you'll see some check marks on the left side where it says your information, subject, incident, all those things. It's a series of screens that they go through where they put in the information. And this document is just a PDF representation of those different steps. So a member of the public would typically go in and do it that way. We internally follow the same process. So if we get information, we follow the same process a member of the public would go through. We go in through, not through the website, but through the investigation system. It's the same process.
Tell me the process then, once that complaint gets entered. Let's say, well, let me ask this, if a member of the public enters one, do you get a notification?
Yes,
Who does that go to?
it comes to me.
Just you?
Yes, I believe that's right. Yeah, I think it comes to
Instantaneous?
yes. Mhm.
How many of these complaints do you think you get?
It's hard to say. I would say on average, maybe 25 to 50, somewhere in there.
Per week?
We get a lot.
How then is that, for lack of a better word, how then are those farmed out? Do you do any kind of, well, before that, do you personally do any initial investigation or anything into those complaints to maybe weed out the wackadoos?
I have to object to this. Is he asking about procedures have changed? Are you asking about procedure at the time?
Yes.
of this?
Okay,
Yes.
overall.
Okay, so at the time that this would have been done, most of those would come in and then I would review them. Your term, weeding out the wackos. I would look at the complaints that seem to on their face not likely be a violation of the Medical Practice Act. So very far out afield. And tend to, and sometimes those are simply misfiled in the sense that it was a nurse practitioner. So someone files a complaint on the wrong type of licensee, and so they're not ours. So we would close that, notify that person, and refer it to the agency it needs to go to. But the ones that were deemed, like I would look at that and say, okay, if this information was true, this might be a violation. Those would go to Dr. Cleveland for his review. Now, since this time, we have a little different process, but it's similar in nature.
And so repeat that last part for me again, about going to Dr. Cleveland.
Yes,
It goes from you vet it initially, then you send it to him.
that's how it worked at this time. Yes, sir.
When does it then get assigned to an investigator?
So Dr. Cleveland would then have the ultimate decision on whether or not a case needed to be opened. So we differentiate a complaint and a case because not all complaints become cases. So if he, in his determination, decided, yes, this could be a violation, then it would be assigned back to me. The case would then be opened, which I would then do. I would assign that case with some usually limited instruction, maybe receive Dr. Cleveland or even just my own instruction on how to start off the case, assign it to the supervisor of investigations and ask that he assign it to an investigator for further investigation.
Once that's done, then how often are you kept in the loop on an individual investigation?
periodic. We have meetings weekly to just kind of go over things for update purposes if something of note has taken place. But for the most part, when it's assigned out to the investigator, they go through the processes that they deem necessary to go through with some oversight from the supervisor. He would report to me, you know, high level things that may have happened. Occasionally, they may call me for some advice on something. I have been here a little while, but other than that, just periodic updates.
Any of those updates written? You've written updates, memos or? like that?
Typically not memos. We very rarely do memos. I will say that the investigations or enforcement system has a note field where when we pass documents, for example, if I were to have a case assigned to me for an update, it would show up as like a note, and then I could assign it back to someone with either an instruction or nothing at all. It may just be an information, hey, read this document, and then I give it back to them when I'm done reading. That's all.
What determines if a case is noted for update?
It would be based on the investigators when they produce documents, like if they produce a report or if some important evidence is discovered or something like that, or if it needs to be flagged for further discussion at these weekly meetings that we have.
Any minutes kept at these meetings?
No, sir.
Back to the complaint, page 14. Okay, you input all of this, correct?
Yes, sir.
Did you talk to anyone before you inputted other than investigators?
No, sir. I talking with Ms. Jones, I determined that, like I said earlier, the basic facts suggested that we might want to do an investigation.
Read for me directly underneath incident types in the incident information box.
Unlicensed practice of medicine, unprofessional conduct, substandard care.
Who made that call that those were the potential, I guess? Tell me what that is.
Sure. So internally, that's a way for us to kind of categorize what a case may involve. Those can be adjusted on the fly depending on what we learn. Just listening to what she said, those seem like appropriate labels to start with.
You get any input from anybody as to whether that was what you want to do or not, or that was just your call?
That was just my call, putting it in. And that would be the same thing for a member of the public as well. They would select those options on what they felt like this was.
Let's see, and as soon as that's right here, we've been here this long, you're aware, one of the counts against, there is no count against Dr. Feinzimmer for unlicensed practice of medicine. It's a count of assisting in licensed practice. Clear that.
Yes, sir.
So since these records have come in already, if he's assisting, who is actually committing the unlicensed practice? He's assisting.
It will be whoever's actually doing the practice of medicine.
That'd be in this case.
It would be the nurses that were identified in the case.
SBML. Let me go to 327. Or 326, probably somewhere there. We're going to go through. Start with 326.
Take this apart just because it's going to make things easier.
All right, what is this document?
This is a final order from the Mississippi State Board of Nursing dated October 4th, 2023.
Or who?
Jessica Elizabeth Stone Bates.
I'll ask. She'll be able to tell me any better than they can, but since this was put in by the board council, then we assume this is the Jessica Bates who's been mentioned numerous times. Correct.
That is my understanding.
Now, so this final order incorporates and approve, well, use the correct word, I'm sorry, approved and adopted the attached agreed settlement proposal. That document begins on page 327.
Yes.
Will you take a look at page 328?
Okay.
We're going to read through a few paragraphs, but let's take a look at paragraph 7.
All right.
You read that for me?
Yes. Respondent agrees to, offers no defense to, and admits that sufficient evidence exists to constitute a violation of Mississippi Code annotated section 73, 15, 29, 1, in that respondent engaged in unprofessional conduct as identified by the board in its rules, namely practicing nursing beyond the authorized scope of the license or directing others to practice beyond their scope in violation of 30 Mississippi Administrative Code, Part 2820, Rule 1.2D.
Same thing, paragraph 8.
Respondent agrees to, offers no defense to, and admits that sufficient evidence exists to constitute a violation of Mississippi Code, annotated section 73, 15, 29, 1K, in that respondent engages in conduct likely to deceive, defraud, or harm the public.
I would just point out, I guess, and I missed it too, in paragraph 7, when he said the statute, I think that's 73, 15, 29, 1L, not 1L. I didn't recognize that.
It looks in.
They did. 9, please, paragraph 9.
Respondent agrees to, offers no defense to, and admits that sufficient evidence exists to constitute a violation of Mississippi Code annotated section 73, 15, 29, 1E, in that respondent has negligently or willfully practiced nursing in a manner that fails to meet generally accepted standards of such nursing practice.
And 10.
Respondent agrees to, offers no defense to, and admits that sufficient evidence exists to constitute a violation of Mississippi Code annotated section 73, 15, 29, 1L, in that respondent engaged in unprofessional conduct as identified by the board in its rules, namely possessing, obtaining, furnishing, or administering drugs to any person, including self, except as legally directed in violation of 30 Mississippi Administrative Code, Part 2820, Rule 1.2R.
Now I'll go ahead and help Paul out here a little bit, but I know what he's going to say. Now, obviously, Board of Nursing regulations don't have any application to physicians. Obviously, Board of Nursing document is not persuasive upon the Board of Medical Licensure. We know that. But this is the individual who is involved in this case as one of the providers underneath Dr. Feinberg, correct?
Correct.
You stated in your initial complaint, the incident types were unlicensed practice of medicine, which the board has since chosen to downgrade to assisting in unlicensed practice of medicine, and unprofessional conduct for substandard behaviors, correct?
Yes.
Now, she has been found to have evidence showing that she committed unprofessional conduct, that she operated beyond the scope of her license, that she acted in a way to conduct likely to deceive, defraud, or harm the public, which is included in Dr. Feinberg's case. All of that she has found to be sufficient evidence exists to constitute violations of those, correct?
Correct.
Now take a look at page 329. Under paragraph 15. Will you read through that and tell the board what penalties she received for these actions? Actually, before we do that, we again said that Dr. Feinberg has been charged with assisting in the unlicensed practice.
Correct.
So all of these things go together. If he's assisting, it's based off of these nurses. And logically, the nurses would be the ones who engaged in the unlicensed practice. Some of the penalties this nurse got for engaging in the unlicensed practice.
Okay. Penalties: that upon acceptance, approval, and execution of a final order by the panel incorporating the terms of this ASP, respondent agrees to the following penalties, which are authorized by Mississippi Code annotated section 73, 15, 29, 2. As a condition to being licensed / privileged as a nurse in the state of Mississippi.
Before you start here, I would just, I'm perfectly fine if you just read what's in bold at the beginning of each of these letters, subparagraphs.
I can do that.
Except possibly for H. Think of that.
Okay. A is formal reprimand. B is a fine. C, legal aspects of nursing course. D, ethics course. E, scope of practice course. F, medication administration course. G, compliance affidavit. H, current active license. Do you want me to read that?
Let's go ahead.
For the duration of this ASP, respondent shall maintain a current active Mississippi license. And I, show cause hearing. Should respondent fail to comply with the terms of this final order, respondent may be directed to appear at a hearing to show cause why the license should not be revoked or other disciplinary action imposed.
Okay. But so in all of this, for everything that she led to, and was assisted in doing, she got a formal reprimand, a fine, 4 continuing education courses, a compliance affidavit, and is required as a penalty to maintain a current active license. Right?
That's what I read, yes, sir.
Okay, now tell me again, I guess, and I know it's gonna be general, but in your role as, how long have you been director of investigation?
About 4 years.
That would be back to 2020.
Is that about right?
So what is your knowledge then of investigations, or as far as overall investigations? You're kept loosely up in it.
Loosely present. My main role is more of a policy setting, kind of a global direction of the division itself, and kind of how we conduct things.
I believe. I think that's it.
I apologize, I've got my bags out there in the way. I'll take. Let's look at fines number 1, the Chad Vega consent order. Look at page 5.
Yes.
What's the date of that one?
It was executed on the 24th day of March, 2017.
2017.
Yes, sir.
That's pre-COVID.
It is.
Okay. Let me ask you this. You said you only recalled bits and pieces about Dr. Vega's case. Do you recall whether he physically practiced medicine here in the state of Mississippi?
Oh, yes, he does.
Okay. Did he at the time in 2017?
He did.
Okay. Do you know whether Dr. Vega ever went to the clinic where these RNs and other personnel were doing IV hydration?
I believe he did.
Okay, you're not sure.
Not 100%, but I'm very, very strongly believe that he did.
But he was physically present here. He didn't practice emergency medicine in Illinois.
No.
Where you're at. And I think it's relevant. I think they opened the door when they asked about Vega.
They did, and you did ask him whether he practiced medicine here, and he answered yes. So I believe your next statement, I'm going to sustain that objection regarding him practicing somewhere else, because I think he already answered that Vega was actively practicing in Mississippi. Is that, he answered that question correct? That's the point that you're trying to make, Counselor?
Well, my next question was going to be whether he recalled whether Dr. Vega was licensed in the other states.
Sustain that, but you can move forward with that particular question.
Do you recall whether he practiced in any other states?
Overruled.
I believe he only practiced in Mississippi.
Mr. Dalton, the mail system. If a change is made to a case, a procedural status, or a document is uploaded, or it's assigned or reassigned, do all of those events generate some type of note on the system that records it?
Absolutely.
Are those notes a permanent part of the investigation?
Yes, it's an audit trail.
And remind me, how long have you worked for the board as an investigator?
15 years.
Do you have any control over what the nursing board does to nurses when you turn a complaint over to them?
No, sir.
You were asked a number of questions about the complaint, and it appears that you may have, I don't want to misdo the math, but it appears that you may have sent a reply email to the investigator of the nursing board, Tawanda Jones, a few minutes before you formally entered the complaint onto the mail system. Is that right?
That's correct.
All right, if you would look at page MSBML 328.
Okay.
Paragraph 7.
Okay.
Respondent, and this is a top of page, agreed settlement proposal of Jessica Bates. So this was a negotiated agreement with Nurse Bates.
Yes.
Okay. Paragraph 7, respondent agrees to, offers no defense to, and admits that sufficient evidence exists to constitute a violation of the statutory section in the record. In that respondent engaged in unprofessional conduct as identified by the board in its rules, namely practicing nursing beyond the authorized scope of the license or directing others to practice beyond their scope in violation of 30 Mississippi Admin Code, Part 2820, Rule 1.2D. Did I read that correctly?
Yes.
Paragraph 8, without the preface which again is respondent agrees to, offers no defense to, and admits that sufficient evidence exists, constitute a violation. But the last part of each of these, I'm going to ask you about. Respondent has negligently or willfully practiced nursing in a manner that fails to meet generally accepted standards of such nursing practice. Correct?
Correct. That's paragraph 9.
Okay, paragraph 10, namely, possessing, obtaining, furnishing, or administering drugs to any person, including self, except as legally directed in violation of 30 Mississippi Admin Code, Part 2820, Rule 1.2R. Correct? Correct. Paragraph 11. Mississippi Code annotated section 73-15-5-2 defines the practice of nursing and states that the acts listed in the statute for the practice of nursing, quote, shall not include acts of medical diagnosis or prescriptions of medical, therapeutic, or corrective measures, except as may be set forth by rules and regulations promulgated and implemented by the Mississippi Board of Nursing. Then there's another rule side, administrative side. A section of the code states that an RN shall be responsible and accountable for practicing within the scope of practice as established by the board and according to generally accepted standards of practice. Rule 1.2F states that the RN may formulate a nursing diagnosis.
Yes, that's what it says.
Paragraph 12. Respondent is a registered nurse and not a nurse practitioner. Respondent has been practicing out of scope for a registered nurse by administering IV hydration without specific orders since May of 2022. Respondent signed up with a company called iDrip and was operating under the umbrella of services offered under the franchise. Under this model, IVs were administered based on a client's want, and there is no medical justification for the selected IV. Client selected fluids and medications from a menu of services, some of which included Toradol and Zofran, and respondent administered the IV via standing orders from an MD located in Arizona who never assessed the client. Did I read that correctly?
You did.
And so, and since Mr. Chapman asked you, just confirm, so, Nurse Bates received a formal reprimand. She received a fine. She was ordered to take 1, 2, 3, 4 continuing education courses, including legal aspects of nursing, ethics, scope of practice, and medication administration. Is that correct? Correct. Also, she was required to maintain a current active Mississippi nursing license. Do you know whether there is a penalty for a nurse if they resign their license while they are under a consent order or agreement with the nursing board?
I don't know for a fact, but I know there is if it was a medical practitioner.
All right, well then I withdraw the question since he does not have a foundation for the answer. I tend to remember.
Just a follow-up, okay? Any questions from the board? Okay, thank you.
And Mr. Shaw to be excused.
Yes.
I called Dr. Benjamin Feinsmer as an adverse witness. Good afternoon, Dr. Feinsmer. You may have to pull that microphone a little closer to you. As we've all noted many times about this one. Dr. Feinsmer, what is your principal state of licensure?
Illinois.
And is that also the location of your primary practice?
Yes.
What type of medicine do you practice?
Emergency medicine and EMS.
You board certified in emergency medicine?
Yes.
Are you board certified in any other specialties?
No.
Okay. If you would, explain to the board how you came to be involved with the company doing business as Adria.
My first job out of residency was in Kenosha, Wisconsin. A nurse there put me and a ER partner of mine in contact with Brandon Collins, the CEO of Hydrip in Arizona.
Is Mr. Collins a doctor?
No.
Do you know what qualifications he has to advise concerning the parameters of medical practice or the legal aspects of medical practice?
I'm sorry, can you ask the question again?
Does Mr. Collins have any training or education that qualifies him to advise others concerning the legal aspects of medical practice?
If you would please speak up,
Sorry.
because I can't, no, that's fine.
If he knows.
Sustained.
Do you know whether Mr. Collins has any education or training that qualifies him to advise others like yourself on the legal aspect of the practice of medicine?
I do not know that.
But you know he's not a physician.
Yes.
So how many states did IDRIP, well, hang on, let me back up. IDRIP, the home of IDRIP is Arizona as far as the umbrella corporation. Is that right?
Yeah, that was the initial state, yes.
Okay. How many states did IDRIP ultimately end up doing business in?
I'm not certain the exact number, probably around 15.
Okay. How many of those states Did you, participate in IDRAP? Let me rephrase that. How many states did you practice medicine in connection with IDRIP's activities?
I don't know the exact number.
More than 5?
Yes,
More than 10?
I'm not sure.
So at least somewhere between 5 and 10.
Yes,
Mississippi was one of those.
yes.
When did you take any steps to determine whether IDRIP's practice model applied to Mississippi law?
I took repeated steps in requesting information from Mr. Collins, from the CEO, to ensure that we were compliant with the states that we were operating in.
Mr. Collins is not licensed as a doctor, physician in Mississippi. is he?
No,
You are licensed as a physician in Mississippi, correct?
yes,
You are responsible for your own compliance with Mississippi law, correct?
I understand what you're asking, yes.
Do you agree?
Ask to rephrase the question.
Do you accept that as a licensed physician, you are personally responsible for your own compliance with Mississippi law?
Yes, I understand.
Now, at some point, IDRIP hired a compliance consultant to advise the company, correct?
Yes,
Let me back up. Did you have any ownership interest in this company, or were you really employed?
I was a 1099. Mr. Collins made comments that if the business was sold, that there might be some additional percentage, but I was an independent contractor, medical director.
How much money did you pay?
Over the course of 3 years, $45,000 approximately.
Okay. During the course of those 3 years, did you do that for 3 years in Mississippi?
No,
Okay. How many years did you, serve as a medical director for IDRIP in Mississippi?
about 6 months or so.
Who was the medical director for Mississippi, in 2022?
Well, we entered Mississippi around the summer of 2022, and then once we found out about the investigation at the beginning of 2023, we started to stop the operations. It was just me for those 6 months or so.
So why did you hire a compliance consultant?
I didn't hire the compliance consultant.
Did you, sorry, go ahead.
Mr. Collins did at my request and the request of Dr. Tradesman. Because we had some ongoing concerns about statutes and regulations in the states we were operating in.
Was that before or after, the Mississippi Board of Nursing began investigating, nurses associated with IDRIP locations in Mississippi?
I don't remember exactly.
Do you believe that IDRIP retained the consultant before you were being investigated?
I don't remember.
Do you recall how long it was? Well, strike that. Had IDRIP hired, this compliance consultant by March of 2023?
Yes, I believe so.
You continued to operate, at least until what, approximately September? Is that right?
No.
Okay, when did you cease operations?
In Mississippi,
Yes,
the beginning of March,
beginning of March. Why?
we were made aware of a nurse investigation, and out of an abundance of caution, we stopped.
Did your compliance consultant advise you that you were in violation of Mississippi law?
I don't remember specifically if he said that.
Do you recall whether the compliance consultant advised you or IDRIP that you were in violation of the laws of other states?
I remember the compliance consultant raised concerns that you're suggesting, and we began the process of shutting down once we were made aware.
You did not personally do any investigation into the legality of your practice in Mississippi beyond asking Mr. Collins until the compliance consultant was retained. Is that right?
I asked Mr. Collins repeatedly over the course of the business if we were compliant with the states that we were entering. He repeatedly reassured me that he had people and himself that were looking into those and that we were in compliance.
Okay, other than asking Mr. Collins, non-physician, did you take any other steps to determine whether or not you were complying with Mississippi law before the compliance consultant was retained?
I did not look into the state statutes, no.
What about other states other than Mississippi where you practice? Did you do anything personally to determine whether or not you were complying with the laws in those states? I think it's part of the race just it's a part of the operations of IDRIP multiple states.
Overruled.
I relied on the CEO to guide me in that arena.
You never practiced telemedicine.
I am not certain. I worked for a company called Emerge Diagnostics. They did telehealth evaluations for workers' comp claims and injuries.
Okay, I apologize. In connection with your relationship with IDRIP, you did not practice telemedicine, say Mississippi.
No,
Okay. You did not examine any patients in Mississippi.
correct,
You did not take a history or perform a physical of any patients in Mississippi.
correct.
You were aware that IDRIP in Arizona submitted numerous prescriptions in your name, with your license number, your DEA number, and bearing your electronic signature to Empower Pharmacy. Is that right?
Yes,
Do you know whether those prescriptions that have been discussed today, you've been present, described, that were for specific patients? Do you know whether those prescriptions, those medications were actually administered to those particular individuals, or were they administered to other individuals, not Jessica Bates, for example?
I don't know the answer to that.
Okay, well, the clinic stocks, you're aware that clinic stocks of IV fluids and other supplements and additives and Zofran and Toradol, clinic stocks were also ordered based on your prescriptive authority.
I don't think there's any evidence that Zofran or Toradol were.
I'll withdraw the question. You're aware that clinic stocks of IV fluids and many additives and supplements were ordered based on your prescriptive authority from Empower and shipped to clinics in Mississippi, correct?
I was reassured by the CEO that that was acceptable, yes.
So the answer is yes. I'm sorry, you have to speak out loud. So the answer is yes.
Yes,
If Jessica Bates was administering Zofran and Toradol to any of her iDrip clients and those medications were not ordered in your name, do you have any idea where they came from?
Objection, this is for hypothetical.
There's no documentation or shows power supply. For all the things.
And I asked whether he knew where they came from.
Sustain.
Doctor, did you know the names of any of the practitioners in Mississippi who were receiving supplies ordered in your name or under prescription in your authority, before meeting with board staff, the executive director in September of 2020?
I don't remember that.
Had you ever met any of them?
No,
Had you ever talked to anyone on the telephone?
I don't remember that. There were procedures in place where they could reach out to me by text or phone whenever they had a question.
Are IV fluids a prescription medication?
Objection. I think it's a very general. More specific.
That general statement is a valid principle of law and practice of medicine. Is it a prescription medication or not?
Overruled.
I initially thought not until I came down here and met with Dr. Cleveland and you.
So now you understand that IV fluids are prescription medications, correct?
Objection also.
I'm not entirely sure. Fluid by itself is a medication, maybe something required for the authority, but I don't think we should treat anything in the state.
I'm actually gonna sustain that objection, because I think, well, I can't tell you how to do you proceed, Counselor.
Mr. Barnes,
Yes.
the fact that this interaction is going on and you are lawyers, I did not understand. I still have trouble understanding the depth of what you're asking. I can answer your questions, but this creates uncertainty for me.
Okay, so can IV fluids be administered to a patient without a prescription by a practitioner with prescriptive authority?
Can I
Did you
influence you?
Did you ask, can they be administered?
I did ask whether they could be administered.
RN can administer IV fluid, they don't have to. Administration is sticking the vein.
Based on the lawful order of a practitioner with prescriptive authority only, as the nursing board order reflects.
Counselor. I'm going to sustain the objection.
All right. Just give me a second to figure out how to ask whether
Got it.
giving IVs are, is the practice of medicine. I'm trying to get there. The board has already denied the motion to dismiss on the basis that it was not the practice of medicine. All right, if this is what we have to do, let's look at page 87, please.
Recommendation of what was decided.
Prior to that, we really need you to use that lapel mic.
Sorry.
I do apologize for that. We have to make sure that,
Turn it on to keep it back.
yes, so restate your objection for the record so that we can pick that up, please.
All right. Wow. I am objecting to Mr. Barnes' characterization of what the implications are of the ruling this morning on the motion to dismiss.
Okay, guys.
At this time, we're
need
gonna
to
take a 5-minute
A
break.
5-minute recess. Oh,
Go ahead.
no, we were both we're on the same page of music here. We need to take a recess, guys. So
5 minutes, please.
can we have 5 minutes, please?
Can I sit down?
You make them, yes.
You can go.
has exited for the duration of the meeting. However, there is still a quorum.
And for the record, Ms. Brillen's a consumer member and not a voting member of the board.
Thank you.
That is correct.
Motion. Prior to that, council had an objection with the characterization of the motion to dismiss. Would you like to give a little bit more information and let council opposite respond on that objection, please?
Sure. My objection was that he had said the board had already decided that Dr. Feinzimmer was practicing medicine in Mississippi. And my point was just that although the board did deny our motion to dismiss, there was no finding regarding the practice of medicine.
I'll withdraw.
Okay. Thank you.
Dr. Feinsberg, is a bag of IV fluid a legend drug?
I was unclear until I came down to meet with you, and I understand now more clearly.
So is that answer yes or no?
Yes, after I met with you, I understand.
So prior to that, in your training and education, your practice, you never knew that a bag of IV fluid was a legend drug.
Mr. Burns, I didn't know the legal description of the fluids as I practiced medicine.
Okay. What is a legend drug?
According to the pharmacist who was here earlier, it's a drug that requires a prescription.
Do you disagree with you referring to Ms. Katina White?
Yes,
Do you agree or disagree with Ms. White's testimony?
I certainly can't reject an expert.
So you cannot reject Ms. White's testimony that a legend drug can only be given on the order of a practitioner with prescriptive authority. Okay,
Objection, that calls for legal.
Overruled.
Can you restate the question?
you said you could not, and I apologize. I'll ask the question, I'll rephrase. You stated that you couldn't, I don't know if you said object or reject the testimony of an expert when we're discussing testimony of Ms. Katina White. Is it also true that you cannot object or reject the testimony by Ms. White that a legend drug can only be given in order of a practitioner with prescriptive authority?
I don't know if this will answer your question. When I was in medical school in pharmacy class and they explained prescription medications, IV fluids was not something that we really went over in school. As I practiced medicine, I did not consider the bag of IV fluid a prescription medication. Once I came down here and you shared the legal explanation, I understand.
Do you agree or disagree with the testimony of Ms. White that any medication or supplement given via IV is a prescription-only medication?
I understand that a prescription. Ask the question. I'm sorry. I'll try and be clearer.
Do you agree or disagree with the testimony of Ms. Katina White that any medication or supplement given via IV is a prescription-only medication?
I agree with her expert opinion.
When did iDrip shut down operations in Mississippi?
I believe early March of 23.
Do you know whether there might have been any orders, prescriptions or orders placed in your name after March of 2023?
If they were without my knowledge.
Right, would you look at page 145, sir? That is, it's one of these legal. I think it's the first. And I apologize that the print is very small. I'm in trouble. Okay, now, testimony is previously established that this is a spreadsheet that was filtered with your name as the prescribing physician, received by the Board of Pharmacy from Empower Pharmacy in Texas. Would you look at the very last entry on the bottom of that page?
Which page am I supposed to be
You're
on?
on page 145, 145, MSPML 145.
Yes, I think I can see it.
Okay, do you see that says 4/28/2023?
I do.
That's the fill date. You see the next column is the date written. It says 4/19/2023.
Yes.
The patient, Janet Beal, I can't. Previous entries are Beall. This one appears to be Baell. Did I read that correctly, sir?
Yes.
Dr. Feinzimmer, I am specifically not asking you for a legal conclusion. However, I want to ask whether you're aware that section 73-25-33 of the Mississippi Code entitled Practice of Medicine Defined includes the following language. The practice of medicine shall mean to suggest, recommend, prescribe, or direct for the use of any person, any drug, medicine, appliance, or other agency, whether material or not material, for the cure, relief, or palliation of any ailment or disease of the mind or body, or for the cure or relief of any wound or fracture or other bodily injury or deformity. And I'm going to stop there. And the description, the definition goes on to talk about midwifery and things that are clearly not of any relevance. Are you aware that
Excuse me, does he have a copy of that code provision?
I asked whether he was aware whether it included the words? I think I'm entitled to get an answer to that question first.
Well, I think he's entitled to look at it, otherwise no one's memorized the code here, I doubt.
I'm asking whether this witness is aware.
Of the exact language of the Mississippi statute.
If the answer is no, he can say no, and I'll show him the statute.
Overruled. I'm gonna treat that as an objection.
Are you aware that that language is included in the definition of practice of medicine?
Since you've read it here today, yes, I'm aware now.
If I would, and I am again showing I'm showing the witness copy of section 73-25-33. Would just here in the first line, getting with to suggest, recommend, prescribe, or direct for the use of any person. You see that language is in fact contained in the definition of practice of medicine.
I do see that language.
Are you familiar? No, I'm just using that as a legal reference. I don't think we have to use a statute. I make an exhibit of it, but we certainly.
Okay, no.
It's a.
I
don't
would
think it's
not. I
necessary,
thought it
but
was already included somewhere in the record. I could be wrong, but I need to follow up on that. But yeah, it's
One way reference to it, take official notice from the statute.
absolutely, it is included in there. Wait,
We don't consider anything.
but I did.
And I've just provided copies to council opposite. A copy of rule 1.4 or an excerpt of rule 1.4. Part 2740, chapter 1 of the administrative code, entitled Rules Pertaining to Prescribing and Administering and Dispensing of Medication. I'm providing a copy to the witness. For the maintenance of the board. I
Is
have-
this already included in the material that you presented?
I don't believe this rule.
Any objection? This will be board.
Yeah, it's not marked.
Yeah, it's unmarked. I just make it a part of the composite exhibit, whatever the last page number is. I'll make it an additional page number.
Sorry, let me get my things before I.
You don't look at theirs and then give me the paper. Now I know where your hands have been.
That was on the side of my. So.
Now they have a little sticky thingy for that.
Hi, Dr. Fines. I apologize. I've been pronouncing your name wrong several months. I apologize. It's Fines. Yes, okay. I do apologize. In that disrespect. Okay. The document in front of you, do you see that it, just about a quarter of the way down the page, you see rule 1.4, maintenance of records and inventories.
Yes.
Next sentence says, every licensee shall maintain inventories, logs, and records prescribed in this rule. See that?
Yes.
Have you ever read this rule before?
No.
Okay, if you would, look at the bottom of the page, the last paragraph in patient record. See it?
I do.
A licensee who prescribes, dispenses, or administers a alleged drug or controlled substance must maintain a complete record of his or her examination, evaluation, and treatment of the patient, which must include documentation of the diagnosis, reason for prescribing, dispensing, or administering any alleged drug or controlled substance, the name, dose, strength, quantity of the alleged drug or controlled substance, and the date that the alleged drug or controlled substance was prescribed, dispensed, or administered. The record required by this rule must be maintained in the patient's medical records. If the medical records are maintained at the office of the licensee, the records must be available for inspection by the representatives of the Mississippi State Board of Medical Licensure. Did your relationship with IDIA, the professional relationship and actions, in your opinion, did you satisfy the requirements of that rule?
Until I,
Then legal conclusion.
Overruled.
so I came down here to meet with you. I relied on the CEO And his assurance is that we were meeting all the standards and statutes. Once you explained to me that I was not in compliance, that IDRIP was not in compliance, yes, I acknowledge what you're saying, and we stopped.
Okay, and this is, I'm looking at the page, at the bottom, it's 93, it's the second page of this part of the release. The first, beginning of the first complete paragraph on that page. And I quote, licensees must not prescribe, administer, or dispense any legend drug, any controlled substance, or any drug having addiction forming or addiction sustaining liability without a good faith prior examination and medical indication. I read that correctly, did I not?
Yes, you did.
Okay, and so in your professional relationship with IDRIP, in your opinion, did your practice comply with that requirement?
Objection, call for the conclusion.
Overruled.
Once I met with you and you explained this, no, we did not comply, which is why we stopped.
When IDRIP hired a compliance consultant, what did the compliance consultant tell IDRIP? And by extension, you about IDRIP's practice in Mississippi?
Objection, not say.
I'll read those. What did the consultant, you hired IDRIP on your request or your recommendation, or your, based on your concern, strike it, based on your concerns and those, another, like, what was his name?
Tradesman.
Tracy, and he's one of the three people listed in some of the IDRIP, documents for justification as one of the medical directions, is that right?
Yes.
Okay, is concern the right word, that you had concerns about the legality of operations of IDRIP in Mississippi?
I don't know about the legality. I had asked over the course of this business repeatedly if we were complying with state statutes and regulations, reassured we were. Once we found out that Nurse Bates was being investigated, we stopped.
After you had received the report of your compliance consultant?
No, I don't recall the exact date, but I believe we stopped operations before the compliance guidance was formally completed. I don't remember though exactly.
What was the compliance guidance that was provided?
I don't remember. There was detail that I'm not familiar to recall.
You don't recall whether the compliance consultant formed IDRIP and you as one of the medical directors that your bottle in Mississippi did not comply with legal requirements. You do not recall whether you ever felt told.
I remember that certainly there's a nurse practitioner component that was missing.
You understand that under Mississippi law, a nurse practitioner as an APRN has their own independent prescriptive authority within the scope of their practice. You understand that?
Calls for a legal conclusion.
I don't think that's a legal conclusion. I think that is a standard of care that this physician must operate under every day of this career.
Overruled.
That's the question again.
Are you aware that under Mississippi law, an APRN has prescriptive authority within the scope of their practice?
I was not aware of the specifics of Mississippi law, relying on the CEO to guide me until I came down and you shared with me the fallouts.
In Illinois, can APRNs prescribe medications independent of the authority of a physician?
Objection, not relevant. Both as to Illinois and as to a nurse practitioner, it's already clear that they were not working with a nurse practitioner.
And I'm trying to explore the extent of the licensee's knowledge of medicine and the legal requirements that govern his practice.
Overruled.
Are you asking me if I'm aware that nurse practitioners can prescribe medications?
Yes, that's to start with. Yes, sir. That's question one. I apologize.
Yes, I'm aware of that.
I apologize. Okay, and that's true in Illinois,
Yes.
okay? And you may not have been aware, but I will represent to you that the same is true of Mississippi. Okay, but there were no APRNs involved in IDRIP's practice model as you conduct operations in Mississippi. Is that correct?
Yes, correct.
Okay, and there were no physician's assistants involved in the practice model of IDRIP as you conducted operations in Mississippi.
Correct.
Okay.
Now, he was called as an adverse witness, so you reserve the right to call him during your case or,
Reserve confidence.
okay. Do the board members have any questions at this time?
I got to.
At the time of your evaluation for IDRIP, what were your, first, it's a two-part question. First is, what were your understanding of the qualifications required of the job as medical director? And then the second part of that is, what were your responsibilities? What did you understand your responsibilities to be as a
Can I back up and explain to my expertise and how I function in 15 years of medical practice to help shape that answer? So as I'm an ER physician, but I'm also an EMS physician. So I'm responsible right now for 250 paramedics, several fire departments. And I formulate standard operating procedures or SOPs. I give them safety parameters. They are educated by our EMS educators, and then they take care of patients who call 911. I don't evaluate those patients. They behave in accordance with the SOPs. There's something called off and online medical direction. Offline is just what I described. So I develop SOPs, share those SOPs, educate the paramedics. Online medical direction is if in real time there's ambiguity or they have uncertainty about something they're about to do, they would call the hospital over radio and they could ask the physician or the nurse, especially trained nurse there, for guidance. I've actually made it part of my practice, which is unusual for EMS directors, to give all my paras my cell phone and they'll call me 24/7 if they have some unusual cases. That is the model that I assumed to be true and was assured by the CEO was an acceptable model. So to answer your question, that is the practice I understood would be appropriate and acceptable for IDRIP.
So were you aware at the time that your signature would be used to order medication? Was that a part of your, what you consider part of your SOPs?
Yes, in fact, it's common practice for both fire departments and private ambulance services to have me sign a form with my DEA that allows them to purchase controlled substances and medical devices under my license without, my knowledge at every ordering step. So yes, is the answer. I was assured that that was acceptable.
Did you understand that the IDRIP model, did you think that it was an emergency model or that it was an elective?
Right,
We're aware that.
that's right. But we work with what we know, and my expertise with 15 years of practicing was the model that I shared and was assured that that was tolerable. That was acceptable.
Dr. I'm David McClendon, I'm internal medicine physician. Have you ever been diagnosed with any type of mental health disorder?
No,
It just seems to be based off the training, your reported expertise, your involvement. That while we're here, the issue just seems to be inconsistent with someone who has been in leadership, a high level leadership position, even running codes, ER Bay 1. And the ability to do that takes high level thinking and understanding the rules. So it just seems to be something's off. Why would we?
I'm sorry you interpret that as me potentially having a mental health disorder. I exercised my expertise, which was in the development of SOPs and allowing the nurses like paramedics to call me when they had questions. I appreciate what you're saying. I clearly do not have good business acumen. And I certainly tolerate your accusation that I fell short of understanding the business of this. I'm a good emergency room doctor. I take care of a lot of people, and I've done so for 15 years. And I'm sorry that you interpret my failure here as someone with a mental disorder.
So can you speak a little bit on the motivation to get involved with this?
Sure. Bottom line is I wanted to help. I see the challenges that patients face regularly gaining access to their primary care doctors, to their specialty doctors, to the emergency room with overrun ER waiting rooms. And, you know, we house patients in the ER for days because they can't get upstairs into a floor bed. Daily, people are expressing their frustrations with access, and having difficulty getting people to help them feel better. This provided an avenue for that. I mean, I understand Mr. Barnes' job here. I understand Dr. Cleveland's job. I understand everyone's job. I never meant to put anyone at risk. I thought what we were doing was helpful. I was assured that we were doing it in a compliant nature. Once I found out we weren't, everything stopped. I would never have done any of this had I known it was running afoul of any state statutes or regulations. So that answered your question fully.
Okay.
Thank you.
Wait, Dr. O, have a question?
Yeah. So, my question was really just in thinking about the care that was rendered to these people, because there's been a lot of discussion about this. Whether it's the practice of medicine or not, but so you have an emergency medicine background. And how many times, not how many times have you treated people for other reasons, but how many times do people come to you in the emergency department to get treatment for just a hangover? Or how many times do they come to the ED and have sat in your ED and looked you in the face and said, I really need more hyaluronic acid, so let's give it to me through the IV? Like, because I feel like I hear you, and ERs are
oftentimes abused and misused for a variety of things. And especially since COVID, I think there's been a disproportionate amount of volume that's been pushed to you guys, like without question, your frontline people. But when we think about the level of service that was being provided here and what was really being done, how much of this practice was really what you saw in your emergency department?
Certainly the delivery of IV vitamins is not something I typically see in the ER. Is that what you're asking?
I'm just asking a little bit, there's been a lot of conversation. I just am trying to see how this compares with the type of medicine that you are accustomed to practicing.
Yeah.
And in the concept of even in the things that are helpful. Because I totally hear you and agree, there are problems with limitations on access to care. But so just like, did you see this as really an extension of that thing? People who work in EDs, it's not a mental disorder, but there is something special about people who are drawn to that space. They're a special group of people. And there's something about that that makes them there and stay there. So I was just thinking, like, how much of this did you really see it as an extension of that thing that you love, that you felt really called to do, or was a big part of what you did day to day?
I share with my wife regularly that sometimes I'm frustrated that I went into a career where I know that some of the things that I do in the ER are not all that helpful. I'm doing things to help people feel better, knowing that, you know, a large percentage aren't really that meaningful. So, and I'm an osteopath, so I have a motivation to really take a more of a whole body approach. So I did think that this was helping people who certainly weren't finding refuge or safety in the standard medical arena. I did.
No, thank you. It wasn't a test question. I just genuinely asked the question because I really wanted to know, like, what your perspective was on that.
Yeah, thanks. I'm Shelba Gaines, a public member. I have a medical background. And I come in what Madam President said, that was part of my question. Being on the medical board as a public member gave me a great insight of the position we serve our state. I have children. I have family members who are not in the medical field. And my son was in Oxford, and I'm thinking, based on my pressure, he may want to stay sober. And I'm thinking he probably went to one of these mobile clinics. And as a physician, you took an oath to help. And I'm sure he has fake ID. And nobody saw his true age, because looking at the patient, how do you know if that's their real age or if they don't have a medical problem?
Yes, ma'am. I can't. There are times when people are going to deceive or photographs. It's impossible to capture everyone. All I can tell you is that myself and Dr. Trazen did repeated revisions, and we reviewed and reviewed and reviewed these SOPs and these safety features. And I made myself available to the nurses 24/7. They could text me, they could call me. We had a 24/7 pharmacist available. We tried to put as many safety bars in place as we could, but you're right, there are people who are going to get through.
Okay.
Go ahead, Dr. Givens, you go first.
I'm Rod Givens. I'm a radiation oncologist, board member. And I just want to take a sort of a big picture view of this, okay? And so you practice as a ER physician, correct?
Yes.
Hospital ER.
Yes.
Gunshot, motor vehicle accident, evaluate, write orders, and so forth. And so I think the big picture is there's a record. You see the patient. And this is just basic medicine. Physician sees the patient, evaluates the patient, documents that interaction, and prescribes or treats. Prescription, manipulation, operation of some sort. That's just basic medicine. And I would assume in all 50 states, some variation of that. Would you agree?
Yes.
Mississippi is no different. Where is it? Why are we having this huge argument about not seeing a patient, treatment being given, and so forth, and there being a lack of awareness of whether or not that's appropriate or not? And I just want your comments.
It's actually, yeah, sure. There's only, I'm not trying to be evasive or excuse, I'm not. I relied on the CEO and his other employees that we were abiding by regulatory requirements and statutes. I certainly understand how you're explaining right now seems silly, I do. At the time, as the doctor pointed out, my business acumen is poor. I thought I was setting up as many safety parameters as I could. I thought I was creating a safety net for these clients. I hear what you're saying. And that's the only answer I can provide is I was relying on the CEO to give me guidance.
And I'll have to ask you, does a CEO practice medicine? And is that how you base your practice, is on a non-physician directing you on appropriate medical practice? That really becomes the crux of my question.
Well, if the CEO of my hospital was guiding me on some functionality in the emergency department, even if it massaged that practice, I guess I would rely on a CEO. I realize what I'm saying is going to trip me up. I hear you. I hear you.
Yeah.
And which is why the moment that we found out that we were not compliant with anything, we shut the whole thing down.
I have a question.
Dr. Gerst, go ahead.
Yes. It looks to me that you always want to do what's right. And you followed your CEO. I think perhaps because you saw him as an authority. Have you learned a lesson here in terms of, on a go-forward position, you use different parameters to decide what's right and wrong?
Gersh with a G.
Sure, Dr. Gersh. The answer is, of course, I'm never getting involved in any of this ever again. I've been approached after the fact and said no to everything. I just want to practice emergency medicine and be in the field and do nothing else. I just want to go back to being a doctor and taking care of my family. So yes, I've learned.
Dr. Feinzimmer, I'm Dr. Lippincott, a psychiatrist here. And what is your current affiliation with iDRIP?
The company is defunct, it's done.
So how many states are you licensed in?
Right now, probably about 10. I had been licensed in more through Emerge Diagnostics, which was the workers' comp telehealth company. That's how I accomplished most of my licenses.
So did you have a Mississippi license prior to your affiliation with iDRIP?
I don't remember the timing. It's possible I had my license through Emerge first. I can't remember.
And you said that iDrip has been dissolved. Was that but you were a contract employee of iDrip, correct?
Correct.
So did you resign from the company or what?
After the investigation of Nurse Bates, we shut down Mississippi. It became clearer and clearer as the weeks and months went on that we were non-compliant in several other states. And then myself and Dr. Traisman started insisting and making plans with the CEO that the company should go to zero.
So the CEO shut down operations at your insistence,
Yes.
you and the other doctor.
And I apologize because I didn't introduce myself. I'm Michelle Owens, the president of the board. And I had a couple of questions because these things have been alluded to, but didn't really come out in testimony. We've looked at so many documents, talked about so many statutes. So as I'm trying to get in my head the timeline for this process, because it's been alluded to, but not very clearly stated. You mentioned something that I'd like to hear more about, and this is the concept of an effort to revise or change as information became known to you about concerns, whether it was the investigation that triggered a concern or whatever process. Can you help us to kind of, or at least give us your perspective or your version of the timeline as it pertains to how this happened? So internally, what information you might have been made aware of, and then the process that you and maybe the other medical directors or whomever came together to talk about what needed to be done. Because it seems, I'm not saying it can't happen, but it seems improbable that you go from, full speed ahead to we're going to shut down the company. And so can you kind of walk us through what you can recall about how that process really took place?
Well, sure. Over the existence of the business, I would ask about compliance. And as I mentioned, I was reassured. Fine. Beginning of 2023, I can't remember exact January, February, when we were made aware of the nurse investigations. We started internal discussions. They were generic because we didn't know ultimately what was happening. Then the beginning of March, I think, is when the nurse had her hearing. We got a few more details, and then the next day is when myself and Dr. Traisman told the CEO to stop in Mississippi. The compliance people, again, I can't remember exactly when they participated. There was discussions before this, but certainly after it was ramped up. They, over the course of weeks and maybe a couple months, shared with us their findings and suggestions. And so the spring of 23 is when we started making plans to dissolve with his complete dissolution by summer of 23.
So thank you for that. And just a couple of follow-up questions that I have with that. And this is really more an internal process piece. So it is in the documents that we have received, it is discussed that some of the individuals who were working with this company bought into the company. So they had a piece, it says they bought into it. I don't know exactly what that means. Like, that to me says that those people might not have been entirely employees, but perhaps maybe they had some profit sharing component. It's mentioned that Ms. Bates, and I don't want to get too far in the weeds, but I just kind of want to understand how this works. There are documents in here where Ms. Bates talks about buying into the company. And so I'm just trying to understand, like, was there a competing interest for these individuals who were doing this work or who were running these independent, like,
local portions of the business, was there a pressure to or any conflict that was relayed to you all based on the fact that they had a financial interest in the business at all?
No, not that I'm aware, no.
Okay. The other piece is you were in the role as medical director. As the medical director, you are not the CEO. Just like the CEO is not the medical director. How much autonomy did you have in your role as medical director to, like, did they allow you to have full reign over the direction, the medical direction, and overseeing the care, or were you more of a person who just oversaw things from an administrative component, or were you a person who really kind of delved deep into clinical care and protocol and participated in either the establishment of the maintenance of those or the improvements of those?
The last one. So I drafted the SOPs, created the safety features, and then made myself available to the nurses. That was my level.
You might have said that, and if
That's okay.
it's been a lot of stuff said, so I'm sorry if I asked a question it's already been stated because I wasn't trying to trip you up. And in the process of what you all learned as this process unfolded, were you made aware of in any location where your company had a footprint of any adverse events that had occurred as a result or in concert with any of these stations? Not specifically as it pertains to Mississippi, but were you made aware of any unexpected outcomes or adverse events in relationship to other locations?
I think there was one time I was made aware of the day after an IV start, the antecubital fossa was a little reddened.
Thank you. That's all I have.
Dr. Fuller?
Dr. Ed, has anyone advised you as to what happens to a licensee that has multiple state licenses with discipline in one state? Are you aware of what's?
Yes.
There was a time in my career I thought it was sexy to have multiple state licenses.
I could not agree with you more. I have systematically dropped or relinquished my licenses. I want one license in Illinois. I want nothing else.
Caution you to be careful about when you issue licenses.
I understand what you're saying. I appreciate that.
Whatever takes place.
The telehealth I appreciate that. The telehealth company emerged in California. I parted ways with them since they were the ones that paid for my license and recertification and Con Ed requirements. And that was no longer, I've let those licenses lapse, not because I'm trying to deceive or withdraw prematurely from those states.
Any other questions from the board?
I just wanted to clarify. Are you saying that iDrip is no longer in operation?
It has not been in operation since last summer.
Thank you.
One other question. So what was the list of all the towns that you had clinics in? There's 7.
That's on the spreadsheet I would have.
It was page 145 through 147 and 48. Is that
The
spreadsheet?
long
The
fold
long
out.
fold
This one?
sheet? Yeah. Does he have a copy of, did he need a copy? Did you have a question based on?
I just want to clarify that.
Okay.
that number.
Gotcha.
All right.
Okay. Any other questions? Paul, is there any redirect?
I would reserve any further questions until after Mr. Johnson had put him on in his case in chief.
Absolutely.
Be done.
Okay. At this time, Dr. Heisenberg, am I pronouncing that
Yes.
right? Okay, you can step in.
And anyone, of course, can check my math, but it appears to me that there's 7 locations in Mississippi with clinics and stocks.
Thank you. Okay,
Like council reps.
okay. Absolutely. Let's take a 10-minute break.
We'll resume at 4:01.
4:01.
Thank you.
I believe before we took that break, that the board rested. At this time, I would ask, if council opposite is ready to proceed.
Say anything else to do.
Okay.
We're gonna call Dr. Cleveland and adverse witness.
Okay. Yes. And for the record, you have been sworn in? Okay. Dr. Cleveland, you may take a seat. Okay.
I'm sure everyone here is familiar with all this, Dr. Would you please tell us your position, title, full name, education, et cetera?
Kenneth Cleveland. I'm a physician. I'm currently the executive director of the medical board. If you want more than that.
A little bit more, let's go, yeah, what did you do before you executive director? How long you been executive director?
I've been the executive director a little over 6 years now. Prior to that, I was in private practice medicine, practiced general surgery for a little over 10 years.
Board certified?
I was board certified in general surgery prior to retiring from general surgery.
What are your duties as executive director? That's why I'm making problem, man.
We.
Objection.
Yeah.
Yes.
Yeah. I can actually.
Okay.
What are your duties as executive director in regard to physician complaint investigations?
So, as executive director, I oversee the whole agency, so licensing, investigations. And so definitely within the investigations, once the initial complaints have been vetted out during the time when Dr. Feinsheimer's complaint came in, the complaints would be sent to me and then I would triage them as to the next category that I thought they should go into, whether it would be just dismiss, or it could be run a PMP, it could be open investigation. And so, those are, and then I would send that back to Jonathan Dalton, who would follow my instructions on that. And then once a week, I meet with the investigative team and they update me on the new actions that they've taken in the investigations for the previous week or two. And then we also will just do a review of open investigations as to the status of them, where do they stand, what kind of direction do the investigators need so that we can get to the next step, whether it be close, meet with the physician, charge, those kind of decisions.
Who makes the decision to charge
I do.
solely?
In consultation with Mr. Barnes and with the investigative staff. But the ultimate decision is mine.
Who determines exactly what counts are charged?
Well, that's a collaboration, effort. It's a collaborative effort. Once the investigation matures to a point where we think we have a licensee who is in violation of statute and regulations that warrants being charged, we will then review the evidence again
and kind of, false, see what the evidence supports as far as a charge goes.
You and Dr. Feinsmer had an interview in September of 23, is that correct?
We did.
How does that usually work in terms of the investigation process? What triggers a meeting like that?
There can be a few different reasons. We, as was mentioned earlier, we call these RC meetings or regulatory compliance meetings, but they can also be considered part of the investigation. So if we're at a point in the investigation where we need to hear from the licensee as to what their side of the story is, then that's when we would set an RC meeting. And that can go in a bunch of different directions.
So with these meetings, have you generally already decided there's a likely violation? No, yes.
Well, if we don't believe there's violations, there's really no reason to have the meeting. So usually if we're having one of these meetings, we have gotten to a point where we believe there are violations and, there's always more than one side to the story though. And so I like to hear from the licensees, on most occasions prior to, taking the case to the next step.
When you plan out these meetings, or decide to happen,
Well, they would come from discussions at the Monday investigations meeting. The investigator reports where he or she is in the investigation. Mr. Barnes is there as well, so I would consult with him. And, based on the information that I often ask the investigators if they feel like they're at a place in the investigation where it would be helpful to meet with the licensee. And so that's how it's a team effort, but once again, ultimately the decision is mine.
once you set one of these interviews, how long do you normally give the licensee in advance? What's your notice?
So the way it happens is, for example, in this situation, Agent Horner, I would inform him that I would say, okay, I think it's time for an RC meeting. Now, there's only one person that controls my work schedule, and that's Francis Carrillo in the back there. So Agent Horner would get in touch with Ms. Carrillo, and then she would begin the scheduling process and work out a time that's convenient for both my schedule and for the licensee's schedule. So there is no set amount of time as to when it occurs.
You inform the licensee that they have the right to counsel at these meetings?
100% of the time.
If you do that in like an email shot to them to let them know that they.
They get a email that says they have a right to bring an attorney with them. But even if they do or they don't, but even when they have an attorney with them, I always say, you have a right to an attorney, and obviously you brought one with you today. If they don't have an attorney, I say you have a right to an attorney. So
you tell them again in person.
I do.
Did you tell Dr. Feinsmer that?
I did.
Do you ever tell them that if they don't have an attorney present, you tell them they have the right to leave at any time?
I do.
Tell them they have the right to not answer any questions?
I do.
Did you tell Dr. Feinsmer that?
I did.
We brought up earlier, there is a recording of the interview with Dr. Feinsmer. Is that correct?
Yes, there is.
Is that a complete recording to your knowledge?
It is not.
I would note that on that recording, none of those statements about counsel or leaving, or not answering are on there. Did you do that prior to the recording beginning?
That has to be how it happened. I was not aware that it was being recorded any more than anybody else in the room, except for the person making the recording. So,
had you ever recorded any of those meetings prior to that one?
I think maybe we had, but if we did, we made sure that the licensee knew we were recording it.
And now we also had some testimony earlier that the process now is that all of these interviews are video. Is that correct?
Yes.
When did that start?
It came out of this situation, once we were made aware that there was a recording. We discussed whether in moving forward, whether it was a good idea just to go ahead and make a recording of all of them and make it known to the licensee. And make sure that they know that they have a right to have that recording as well. So that's, I think it came out of this process, yeah.
So when did that start? When did that become a procedure?
Less than 6 months ago, I think, and I mean, I'll look at Mr. Barnes and see if he can help me remember about it. It's somewhere less than a year or more than 6 months, maybe. I don't know, it hadn't been a real long time.
In this specific investigation, I guess, well, it could be for general too, but, you said you talked to investigators prior to setting RCB, right?
Correct.
Do you review their documents that they obtained from wherever they obtained them?
So I do, you know, they will, you know, they will make reports of investigation. And, those will be, sent to me and they'll be reviewed by me. And then, you know, I can make a comment back, like, let's discuss further at Monday meeting.
Do you ever create any memos or anything, during this process? You know, the file?
The only memos that would be like the comment, what I say, let's discuss this further. Or, so.
Let's go back to Dr. Feinsberg's specific meeting, I guess. Repeat for me, I guess, remind me who attended that.
So, I was there, Mr. Barnes was there, Michael Smith was there, and Phyllis Johnson was there.
Anyone else?
Not to my recollection.
How
Well,
did you?
Dr. Feinstein.
Yeah. How did you prepare for that? Did anything that day?
So, you know, as a general rule, we're somewhat prepared, but just because these reports have been coming in, usually for a while now. Okay, and so I'm somewhat familiar with the cases, but then I will also ask the, investigator to give me the high points. Just to trip my memory on all the different ones. I mean, because we run on average about 75 open cases at a time. And so I just need little things to jog my memory.
Okay, so the investigator gives you a list. You talk to Mr. Barnes prior to the meeting. Of course, anybody else at the board?
The investigator would be involved in the discussion.
You talk to any board members?
Oh, no.
How do you develop strategy for your questions for the licenses?
Mr. Barnes and myself will discuss the case, what information we still need to find out. And, you know, really, most of the meetings, I ask most of, well, never is it all of them, but I ask most of the questions. And, you know, the other thing I tell the physician is, you and I are the two doctors in the room, and we understand doctor language. And so some of them may not understand exactly the language we're speaking sometimes. And so then we'll just have a discussion about the investigation, what the investigators have found and where we are.
This one seems like it's a little different than the normal ones, just because you have Mrs. Johnson, whatever, our title here, there as well. Obviously, this began as a board of nursing investigation, I guess, for y'all. Did you meet with her or talk with her before?
So the Board of Nursing, the Board of Pharmacy, and the Medical Board are working jointly on both these kind of investigations and on other investigations. And so we will have specific meetings where representatives from all three boards meet at those meetings to discuss these investigations.
other investigations? Do you mean other IV hydration investigations?
And I'm not gonna discuss other investigations that
You
are
don't have
going
to give me a name of anybody, just the type. Is that the,
on. Prescribing other IV hydration stations.
now, okay, back up, but now that you are videoing all of these, what's your understanding of how those video recordings are saved, maintained?
Um, I am by far not an IT expert and will not claim to be one. I know that, one of the investigators that's in the room will save it to a hard drive within our system. Other than that, I don't know, how it's stored and all that.
Fight you with this a little bit here. I know you said there are other IV hydration therapy investigations ongoing. I'm not gonna ask any names. Have you had any of these type of interviews with any physicians related to these other investigations on this?
I don't, not any that are open.
Okay, so you have had some closed ones.
Um, I don't. Okay, well, I mean, I'm trying to remember exactly. You have to understand, I have a dozen of these meetings a month. And so, you know, I don't specifically remember, but, I'm sure I'll probably.
I'll come back to that. Since you mentioned 12 or 12 how long have you been doing the RC meetings? The entirety of your stay?
Since I started the job.
About how many do you think you've probably done? You always tell me per month or per week.
Yeah, so actually, I think I overstated. It's more like 12 every 2 months, 12 or so every 2 months, not 12 every month. And so I would say, you know, somewhere around, what does that make it, 50 or 60 a year, times 6 years, so maybe 300 or so of these.
Any idea a percentage of those maybe result in no charge?
I would say a large percentage of them will result in no charge,
More than half?
more than half.
Consent orders come out of those?
No, these aren't the meetings that we decide consent orders at. You know, maybe early on, before, I, learned more about, you know, handling the jobs, we may have suggested some consent orders at some early on in my tenure here. But we do not offer consent orders at these meetings. So, and the process is now that consent orders are only offered after charges have been made.
So, okay, you don't talk with any board members prior to one of these interviews, you said that, right? Is that right?
Right. I mean, if you need me to elaborate on that,
That may not be how I asked, I'm just making sure I asked well. I was asking, you don't talk to board members before an RC, that's what you said.
I don't talk to board members about investigations at all. That's a hard line, that we do not violate.
Until we get to hearing roughly, or is that?
But this should be the first they've heard of it.
That's fine. I will come back to it. I guess I asked earlier about interviews or meetings with other IV hydration entities or positions, I guess, what we're worried about here, the licensees. Has the board issued an order to any position related to an IV hydration therapy?
Yes. Since I've been here, I think two.
Since those are public record, that those orders should be public record, can you tell me those names?
I mean, I guess I can say them, Massey Headley and, Veracetti.
What can you tell me about Veracetti's case?
It developed out of COVID. She had a pre-existing, legitimate IV infusion place, that was already up and running. This is best of my memory. Okay, so I have not reviewed this. But she felt like there was a need during COVID for more people to be able to get IV fluids. And so, she kind of converted her IV infusion center into a more of a hydration kind of practice. And she had RNs over there. Sometimes she would send a patient from her office over there to get IV fluids. And sometimes they were walk-ins or scheduled patients, with the RNs. But the RNs would, see the patient, take down their data, send it over to Dr. Veracetti, who would review it and then tell the RNs whether they could, actually give the IV fluids.
You know what her penalty was for that?
I don't remember.
Show it to you.
I'd
like to. Gonna be Feinberg pages 6 through 10.
Any objection? From
No objection.
Okay. Enter that into the record.
First off, before we get to the penalties, why don't you look at the very bottom of page 6 there, first page. What statutes was she cited in violating?
73, 25, 29 and 73, 25, 83.
You know, if Dr. Feinberg's been charged with violations of those same statutes or not?
So I'm not a guru with statute numbers, and so I don't know the actual statute numbers that he is charged with.
If it would please the board, I would point out that, or I would state that the counts included in the summons and affidavit are these exact statutes plus one extra, it'd be 73, 25, 29, and 80. But other than that, the exact same statutes. Now let's go to the penalties, which we begin on page 7, or second page. Paragraph number 1. Read that out for us.
Licensee's medical license to practice medicine in the state of Mississippi is hereby suspended for a period of 3 months with suspension immediately stayed.
And then number 2.
Licensee is hereby prohibited from issuing medications or initiating therapies inclusive of intravenous therapy for patients whom licensee has not established a bona fide doctor-patient relationship through collection of an appropriate medical history and completion of a physical exam in a manner consistent with acceptable medical standards prior to the initiation or issuance of said medications or therapies.
And I won't make you read all the paragraph, but does that look like that's just a CME course?
Some CME courses.
Anything else?
I don't think so. Obey all laws. Reimburse the board.
But no other action penalty.
Right.
And then you said Dr. Headley, about Dr. Headley. I mean, about that.
So Dr. Headley, was the owner of a, IV clinic, core therapy, and there was, IV fluids being given by, nurses, and in one situation, I believe a paramedic as well in that one. Without a physical exam or a diagnosis by a person with prescriptive authority.
Now, you said, to your recollection, that's the only two you have? Did you hear?
The best I remember. I mean, if you know one, I'll be glad to take a look at it.
Those were the two I knew of. We mentioned Dr. Vega earlier, I believe you made it before your time.
So he was 2017. I didn't
Yeah.
start until February of 18.
Not aware of the facts of that case at all.
I mean, only what was mentioned earlier, very high level brief.
So when we look at this, then is we've got a couple of different ones. And they got, well, okay, what did Dr. Headley get?
Dr. Headley was suspended for 6 months, is the best of my recollection, and he, I think he probably had some CMEs that he had to perform as well.
Did it start at 6 months or did it start something else? Part of that.
So he had the ability to earn part of that, suspension back by, speaking to medical groups or groups of students, that were to, elucidate to them how he had gone down the pathway, that had landed him suspended.
So we've got two here with two fairly widely different penalties that double. All these states.
The facts are different.
Well, there you go. That was my next question. These are all fact.
They are.
The board has discretion to review the facts and choose a penalty based on the circumstances. Such as.
They do.
Now, when you're coming up with charges, when you're coming up with counts, do you either directly or indirectly, maybe through Mr. Barnes, do either of you ever recommend penalties to the board?
No.
Clarification, other than.
Right. But what do you in open hearing? Do you?
Well, I don't. Mr. Barnes may, but I don't.
Back to Dr. Feinzimmer's interview. And we've had a lot of discussion about this today, objections and a lot of other stuff. You asked Dr. Feinzimmer if someone administers a bag of IV fluids, if that's the practice. Did you?
My recollection is I did ask him that question.
So clearly it's your opinion that the administration of an IV bag is the practice of medicine, is that correct?
Yes.
Now, as the board executive director, I'm sure you are more than familiar with all the board's rules and regulations.
Well,
I mean, you don't have to memorize, obviously, but.
I don't have them memorized. I still have to go back and look, at the actual wording of them from time to time. But I have a good working general knowledge of them.
So now you asked him that based off of what? Is there a definition of the practice of medicine in Mississippi? Statutory?
There is.
And I believe we talked about that a little earlier. Did we all bring that up for Dr. Feinberg?
Yes.
I I actually only said about 2 o'clock. I'll look at it.
Can you just pop it back out?
Yeah, got it on the right line, I guess.
While we're looking for that, would you agree that you asked him to make a legal conclusion as to whether something met that statutory definition?
Sure.
Any response, Councilman?
I mean, it is what he did. He asked him, is this the practice of medicine? He mentioned there is a statute in the state. It is a legal issue. It is statutorily defined.
It is a combined legal issue. It's also a standard care.
He didn't ask about standard. What he practice of medicine.
I understand that I believe it is a mixed question, law and fact.
Sustained.
But you did ask him if administering a bag of IV is the practice of medicine, correct?
I did.
Did you give him a copy of the statute of practice?
I don't recall doing that.
On this highlight.
Yeah, 73, 25.
And will you say that statute again on the?
73, 25, 33.
Got it. Thank you.
All right, Dr. Cleveland, I'll tell you what, we don't have to talk about the practice of obstetrics or midwifery or all that. Damn. But would you read again from the board the definition of practice of medicine that begins at the beginning of that statement?
The practice of medicine shall mean to suggest, recommend, prescribe, or direct for the use of any person, any drug, medicine, appliance, or other agency, whether material or not. I'm sorry, or not material for the cure, relief, or palliation of any ailment or disease of the mind or body, or for the cure or relief of any wound or fracture or other bodily injury or deformity.
You're not going to like this question, but I'm going to ask it. What ailment or disease of the mind or body were these IV fluids?
None.
So then they weren't given for the cure, relief, or palliation of any ailment or disease of the mind or body.
They were prescription.
That's not the question. Were they given for the cure, relief, or palliation of any ailment or disease?
Okay, so in some of the menu items, like a migraine, that would be yes. In the other menu items like hangover cure or beauty treatment, the answer would be no.
Well, the migraine doesn't say it's a migraine cure, does it? It says it's a migraine blend.
It would still be for the treatment of.
Well, do we have anything in evidence that shows that that blend was ever given?
Not that I'm aware of.
So we don't have anything that shows that was actually given. Done for that purpose.
Well, I haven't combed through each bag of IV fluid that was administered by these nurses.
Well, that's fair, and nobody's asked anyone to go through every one, but still have to make a case that it was done. I'm not seeing anything that shows migraine for anyone, or that advertising that they told them it wouldn't do it. In fact, give me 1 second. All right, so you have, what about MSVML page 17?
Okay, these are got, maybe I've got it upside down.
If you have it.
I've got it.
So we've been through all these before already too, but this is a IVIM consent form from one of the individuals treated by iDrip in Oxford on this basis. What's that last sentence of the first paragraph say?
Let me find where it starts. With the further.
Further, yeah.
Further, I acknowledge that statements regarding vitamin or mineral infusions, injections have not been evaluated by the FDA, and that the infusion injection of such has no diagnostic value, nor is the infusion a substitute, cure, therapy, or treatment for any disease or condition.
And that's signed at the bottom, correct?
It is.
So these individuals are all being told that this is not cure or treat a condition, are they not?
Sure.
And they're signing off accepting it.
Yes.
And we went over the prescription order forms earlier, and every one of them showed no medical conditions, correct? Or I can pull it back up for you, but that's.
Well, like I say, I haven't poured through every one of them in detail.
The first page I turned to 111.
I've got it.
Okay. Down there towards the bottom where it says diagnosis, what's that next to it?
The,
It's kind of small print, so. Gonna be above.
I see it.
Yeah, diagnosis.
Yeah, no known medical conditions.
So they're not ordering them for a medical condition. Would you say that's what that document says?
Objection calls for legal.
Not a legal,
You can answer
it's not a legal
whatever.
conclusion if I'm asking us what the document says.
He can ask him what the document says, but if he's asking what it means, that's illegal.
Overruled.
I'm sorry, I don't know which questions before me right now.
That document says that there are no known medical conditions for that particular order. That's correct.
Correct.
I object to the characterization of the document.
That's what it says.
I object to your interpretation of what that field medical diagnosis means.
Were you asking him for his definition of what that no medical diagnosis
I was
means?
simply asking if the record said that whatever that prescription was prescribed for, there was no medical condition associated with it.
And again, that's not the same thing as saying, what does it say? He's saying, does no medical diagnosis in that field mean that that prescription was written for no medical condition? That is not necessarily the case.
Sustain.
Take a look at page 62.
I got it.
I will represent that this particular question on this intake form is not in every one of these charts. It looks like they have a couple of different versions of this, but it is in a couple of them, but it's exactly like this one on page 62. Down at the bottom where it starts, which statements best describe, will you read that?
I see what are the main complaints. So,
Below that, down towards the bottom, which statements best describe?
okay, I see. Which statements best describe why you are here today? Mark X by all that apply.
you go, read those for them.
All right. I want to have more energy and feel better overall. I want to do everything I can to nourish my body. I want to do everything I can to enhance my weight loss efforts. I want to prevent getting sick.
Are any of those 4 bullet points an ailment or disease of the mind or body?
Well, weight loss would suggest obesity.
It suggests doesn't say. Anybody can lose weight, I'd be obese.
Objection, argument.
Sustain.
Sorry, guy.
Um, we mentioned earlier, and I haven't come in edit yet, I've got that 2 week put it in. There was mentioned that the board has issued guidance regarding dehydration therapy practice, correct?
That is correct.
When was that done?
I don't remember the specific date.
Was it before or after Dr. Feinberg met?
I don't remember for sure.
You recall talking about that guidance in your meeting? with Dr. Feinberg?
Well, no, yes, I do. It would have had to have been issued after the meeting with Dr. Feinstein.
I believe it probably was issued that afternoon after, actually. Let's take a look at Feinberg 298 through 300. I got right here.
Any objection?
No objection.
Okay, so in terms.
Let's take a look at page 292. But first, just a housekeeping question. I see that that was an email sent from MSBML licensure to Dr. Feinstein, correct?
This particular one.
Well, it's at the top one sent to Dr. Feinstein would be
Right.
below that.
Just to clarify, it was sent to all licensees.
Okay, at that time, September 5th.
Yes.
Okay. Who handles the MSBML licensure email? Okay. Who was it?
Well, you don't have to be more specific about that. You outgoing, ingoing,
Well, who would have sent this?
IT department.
But it was sent out after his meeting, because his meeting was that morning, is that correct, September 5th?
You know, I know, based on, you know, having reviewed all this stuff, that it went out after the meeting with him. If it was that afternoon, if that matches up on the calendar, then yes, I'm not denying that it did, but.
Who decided that guidance was necessary?
Well, I think the thought of it would have probably been initiated by me. And I can't remember for sure at this time if that was something that we went through our communications committee on. Or if this is just one that we had been working on and that we put out ourselves.
Why did you decide it was necessary?
Well, this is a national problem and it's a problem for Mississippi. And so I wanted to try to get the Alabama board and the South Carolina board had put something out. I thought it was a good idea. I thought we should put something out. So we did.
You know when they put theirs out?
prior to us putting ours out.
that same year or,
Within the year, I feel certain.
uh, um, well, okay, who drafted the guidance?
So, Paul Barnes did,
Did you review it?
of course.
Did you have any changes?
I may have had some edits to it. I don't specifically remember at this time. I usually do,
Were there multiple drafts?
of course.
I object to the council's complete attempt to discuss, edits of a legal document, Dr. Cleveland's executive board, attorney, consult is protected by attorney-client privilege. Also, drafts or attorney work product, and it's improper for him to attempt to invade that privilege and confidentiality.
Response, council.
We would state that we have asked for all of this information, discovery was denied. We maintain our objections to that. Again, we feel like Dr. Feinsberg is entitled to copies of whatever the board had in their file towards bringing it here today.
Before you respond, I'm going to sustain your objection.
So, have any other physicians who you have interviewed or charged or not charged? Therapy. Have they contended that that practice is not the practice?
No.
Now, in your interview with Dr. Feinsberg, you also asked, do you recall asking him, what they claimed to treat?
I don't recall specifically asking that question.
Why did you, well, take
I haven't offered it. I was not planning to. He's gonna offer a portion of the tape, but I'd break it down, but that's gonna open up a lot of additional time because Dr. Feinsberg testifies again. I will, it also. This portion. Dr. Cleveland calls. I mean, if he testifies inconsistently, I mean, if you're gonna impeach him, I guess that's your business, but I think you have to establish that he's offered testimony that's inconsistent with the prior statement that was given before you're entitled to impeach.
What was the question, council?
I was asking him, I guess. So do you recall, and I know you said, I'll ask you just for my clarification, do you recall asking him what Hydra claimed to treat with the condition?
And I do not specifically recall asking that question.
Okay, the counselor here for today. You and Mr. Barnes or Mr. Barnes, whoever did it, decided on assisting in the unlicensed practice, correct?
Yes,
It wasn't that he was doing the unlicensed practice. That's what the council states.
correct.
So who was he assisting?
The RNs and the paramedic that were in the clinic.
And we brought in the evidence of one of those, Ms. Bates, correct?
I've heard that name mentioned a bunch of times today, so yes.
And you recall what penalty she got from the board of nursing for the actual licensed practice of medicine?
I heard y'all go over it today. If you asked me to repeat it verbatim, I would not be able to.
When you choose to charge a licensee, obviously you feel like there's a chance that there's going to be a violation, right? And that the board will take action based on that.
I'm not sure that you,
Let me rephrase.
yeah, and that was,
When you charge a licensee, you feel like you have evidence that a violation has occurred.
yes.
Is there ever any thought to, oh no, one, I'll tender.
Dr. Cleveland, is a bag of IV fluid a prescription drug?
Yes,
Is prescribing a medication a prescription drug for any condition or purpose whatsoever? Is that the practice of medicine?
yes,
You were asked questions about the particular language used in the statutory definition of the practice of medicine. You were asked what conditions that were being treated. And am I correct that your answer that there were none is because there were no medical diagnoses that appeared in the patient charts from Hydra?
that's correct.
Okay. Were you taking the cart before the horse approach that appears to be advocated by the other side, which is, well, if they are not prescribing it for a particular medical condition, then it's not the practice of medicine or has no power to regulate.
That would not be my opinion. My opinion is that if a prescription drug is used, that is the practice of medicine.
Does this board, to your knowledge, have regulations for prescribing that specifically state what is required when you prescribe a medication?
They do.
All right, I've got copies here somewhere. We've used them. They're already, I think I put this, it was unmarked copy of the rule. This is rule 1.4.
Yes.
Okay. Do you have it?
Well, it's 2640.
I don't know. It's 26. It was a separate.
No, that was medicine statute.
I will just read it.
Well, for the record, it's actually marked. It's going to be that Bates number of the last page of your, it was already entered earlier, this rule 1.4, just for Madam Court.
Yeah. And I apologize. I'm just looking for another hard copy. I do not see the copy. We asked about earlier.
While I was looking for that, I'll just say sort of globally, but I object to this line of questioning generally. And that Dr. Cleveland is not a judge or an arbiter of law, and what is the legal conclusion of what is the practice of medicine is not for him to determine. He can have an opinion, but I think that it's testimony has indicated what is or is not is a legal conclusion on this part.
Any rebuttal, counsel?
Throughout the day, they've tried to, assert the position that Dr. Feinsmer is not responsible for understanding what is and is not the practice of medicine himself, that he has no professional responsibility. In fact, each and every physician has a responsibility as a professional to know the scope of their practice and to stay within that scope. Each physician, including Dr. Feinsmer, although he disclaimed it, must have an understanding of what the practice of medicine includes. Dr. Cleveland is a licensed physician, many years of experience. He also has many years of regulatory experience. This is not a legal conclusion. First of all, if it is a legal conclusion, he has a basis for it based on his years of regulatory experience, which includes serving on national panels addressing this issue, including panels sponsored by the FDA. I do not think it is a legal conclusion. I think this is a standard of care question about what is the practice of medicine within a medical sense. Dr. Cleveland is certainly qualified and entitled to offer his opinion that is whether this is or is not the practice of medicine.
At this point, he's been asking him to interpret a statute, and statutory interpretation is a legal determination.
I agree that, and the findings of fact and conclusions of law are the province of the members of this board. The ultimate conclusion, that does not mean that Dr. Cleveland is not entitled to offer his opinion for the board to consider.
Overruled.
I'm sorry, could you read that question? I know I'm not supposed to say that. Pause.
Yeah.
She objected during the pause. What was the last thing I heard?
Oh, okay, yeah.
Does the board, to your knowledge, have regulations for prescribing typically say what is required when you prescribe a medication? They do. And I've got copies and you can.
Okay. The objection may have been to the question. What was that?
She was like, I'll just, for the record.
There,
I apologize.
yeah, there has been a line of questioning related to statute. What I was trying to clarify is this is its interpretation.
Dr. Cleveland, does your job as executive director of the medical board require you to interpret statutes and regulations?
It does.
Okay. Do you know whether any other states have rendered opinions? Any other state medical boards have rendered opinions as to whether or not retail IV hydration practice constitutes the practice of medicine?
If I understand what you're asking me, the South Carolina and Alabama have put out guidance on this as well.
They had put out guidance before we did, correct?
Correct.
Do you know whether there may have been other boards since that time that have put out guidance on IV hydration?
I'm relatively sure there are, but I cannot list them for you.
Okay. So I believe I provided you with a copy of Rule 1.4.
Yes.
If you look at the bottom, the patient record,
Yes.
a licensee who prescribes, dispenses, or administers a legend drug or controlled substance must maintain a complete record of his or her examination, evaluation, and treatment of the patient, which must include documentation of the diagnosis and reason for prescribing, dispensing, or administering any legend drug or controlled substance. That paragraph goes on for additional details that is included in the record. Do you interpret this regulation to mean that before you can prescribe a controlled substance, a physician or anyone with prescriptive authority, they must perform an exam, it maintains records of examination, evaluation, and treatment, including diagnosis and reason for prescribing.
Yes,
Okay, if you turn to the next page, or flip it over, the first complete paragraph. Licensees must not prescribe, administer, or dispense any legend drug. Stop there. What is a legend drug?
a legend drug is a drug that requires a prescription, but is not a control.
Okay, going on after legend drug, semicolon, any controlled substance or any drug having addiction forming or addiction sustaining liability without a good faith prior examination and medical indication. So this sentence, that applies to legend drugs, controlled substances, or any other type of drug having addiction forming addiction sustaining liability. Is that your interpretation?
Yes,
Okay. What is a good faith prior examination and medical indication in your opinion?
a person with prescriptive authority would establish a provider-patient relationship. They would perform a history and physical exam, including assessment and or diagnosis, and then the plan to treat.
Checking out things that have already been covered by the doctor's job. We were talking earlier about RC meetings, and you said some of them be for investigative purposes. You recall a line of questioning where you were asked whether any percentage of them resulted in no charges, all that.
Yes.
Okay. If a meeting is, strike that. Yeah, before you schedule one of these meetings, you believe that you have sufficient information to determine whether or not a violation of the Practice Act or the rules has occurred. But you believe that an RC meeting would be a sufficient corrective measure to get a position on track and in compliance. Is that one reason you would have these meetings?
Yes.
And are those the meetings you were referring to that often result in no charges being made?
Yes.
Chad Vega was before you talked to the director, correct?
That's correct.
But is it your understanding, have you reviewed any information regarding Chad Vega?
Only briefly.
Okay. Do you recall whether or not he practiced within the state of Mississippi physically?
It's my understanding that he did.
Okay. Do you have any understanding as to whether Dr. Vega actually physically went to the locations where the RNs or practitioners without prescriptive authority were in fact practicing?
That's the way it was reported to me.
Dr. Verisetti.
Yes.
Dr. Verisetti personally participated in the decisions whether IV hydration would be given to a specific patient. Is that correct?
She did.
She did that by telemedicine or by telephone?
Yeah, so the nurse in the clinic would send over, whether it was by fax or email or whatever, the evaluation sheet that had been performed on the patient. Dr. Verisetti would review it and then give the nurse and the clinic permission to give the IV fluids.
Well, why wasn't that okay?
Because Dr. Verisetti was not establishing a physician-patient relationship.
And she wasn't personally performing these hangouts, etc.
Correct.
All right, Dr. Headley.
Yes.
I believe the order reflects that Dr. Headley was suspended by the board through a consent order, for 6 months. And that he was given the opportunity to have 2 months of that 6-month period stay. Is that your understanding?
That's my memory.
Mr. Chapman, have you put all 4 of these orders?
I believe I put in Headley and Baker there.
Okay, okay. So Headley is in, then. All right, let me, I'm looking at page Feinsheimer 12. Let me correct my statement. Paragraph 1 on Feinsheimer 12 states licensee's certificate number 14432 is hereby suspended for a period of 12 months with said suspension stayed after 6 months. I'm sorry, on page 12 of Feinsheimer.
Yeah.
It's all ours. I don't have a copy of theirs.
Not a problem. Oh, you did have that. There's a,
Embarrassing. I don't have that. Unless it's just got mixed up.
I'm leaning over the witnesses show around. Yeah, another time.
That's Headley you needed.
Yes, sorry, yes. I turned to page, the second page, that is page 12. Thanks. And I was reading from paragraph 1, which says that, that he was suspended, his license was suspended for a period of 12 months with said suspension stayed after 6 months, correct?
That's correct.
Okay. So the suspension was 12 months originally. The board, it was stayed for 6 months. And then Dr. Headley was given the opportunity, again, as described in paragraph 2, to reduce his suspension or have an additional 2 months stay by completing acceptable speaking. Correct?
That's correct.
Then the last sentence of paragraph 2, by completing 2 speaking engagements, Dr. Headley's 6-month active suspension could be reduced to as little as 4 months. Is that your understanding?
That's correct.
Did Dr. Headley, in fact, complete the speaking engagements?
He did.
Okay. Did he confer with you and the staff prior to making those speaking engagements as far as to get approval of his presentation, handouts, slides, that sort of thing?
So he met with us both as far as the content of his presentations, as well as about the groups that he would present to.
Okay. And did Dr. Headley have to end up spending or speaking to more than 2 groups?
He did.
Okay, and why is that?
Well, because he spoke at Mississippi Association of Family Practice at their summer meeting, which was well attended. So we counted that as 1. But then the next opportunity he had was like a small group of medical students, like 15 to 20. And so it was my decision that he had to get that number up to somewhere around 100. So if he was going to do only small groups, then he would have to do 4 or 5 of them.
And did he, in fact, speak enough times to get the number sufficiently close to 100 to satisfy you that he had fulfilled the terms of the consent order?
He did.
And did Dr. Headley appear reappear before this board after he had completed those speaking engagements and had earned the right to have those 2 additional months stayed and seek reinstatement of his license?
He did.
Dr. Headley was he owned the business, right?
He did.
Okay, he was physically here in the Jackson area, the same area, and it was in Madison. Is that right? If you,
Yeah, yes, it
it was in
was.
the Jackson area.
It was, yes,
Did Dr. Haley practice in the Jackson area?
yes.
Did Dr. Headley actually have any communications at any time with any of the RNs or paramedic or any of the non-prescriptive authority personnel who were administering IVs at Core?
He did.
Can you redirect?
I just have a couple, if I just said that.
Absolutely.
So you just said that Dr. Headley was the owner.
Does he need that mic?
That's correct.
You know, the only owner, sole owner? You know,
So he was not.
majority?
Between he and his wife, they owned 50%.
So, but then he would have had a say in how the operation ran. Correct.
And I don't know the mechanics of how they made their decisions.
And I believe Paul and I both asked you about guidance in the other states, South Carolina, Alabama, is that correct?
Yes,
And if I remember right, you told me you weren't sure when they issued theirs, you thought it was within this year? Or within,
oh, at the point where we are now,
well,
I mean-
when it was 2023, was it?
and prior to us issuing ours, theirs were issued within 6 months to a year prior.
Do you know if it would have been issued prior to Hydro shutting down in Mississippi in March of 2023?
I do not know.
That's all I got.
Do you have a few questions for this? And few, I mean few.
I don't have any questions, but I would suggest that I believe the information that even Mr. Chapman just asked about the database is contained in the record, reference in the guidance that we issued.
Okay, do the board members have any questions for Dr. Flynn? Okay, thank you.
Dr. Cleveland, excuse me.
He is. Thank you. Next meeting.
And we will recall Dr. Thompson.
I have two. Right.
You can- Let's, I was.
You need
say,
5 to 10?
Let's do a 10-minute break
Okay.
because this will be the longest. 10-minute break, we'll be back.
Where you are still under oath. Oh, just, I know we don't have, but just for the record, let's state your name again, please.
Benjamin Feinzimmer.
I don't believe we went through any of this with Paul's question of you. But do you have a copy of your CV over there?
I do.
That's gonna be Feinzimmer, pages 307 to 311. Represent, that's the CV of Dr. Feinzimmer on 11.
Okay.
Okay, so immediate.
So Dr. Feinzimmer, why don't you go ahead and give me a little bit, I guess, of your history from, so let's start with college through.
I went to Kenyon College, which is a small school in rural Ohio, and as a result, they have a volunteer fire department. They select 2 students to go through EMT and fire academy, so I joined the fire department for 4 years. I carried a pager around with me and got beeped to 911 emergencies in the county I was in school. I went to medical school at Midwestern University and then did residency at University of Illinois Chicago. I spent time with the Chicago Fire Department. My first job out of residency, as I mentioned, was in Kenosha, Wisconsin. I was the EMS director of several Kenosha County Fire Departments and the SWAT team medical director for the Sheriff's Department. Shortly after I started my medical direction, I thought it would be helpful if the doctor actually went out into the field alongside the paramedics, which although is unusual, there's about 20, 25 programs like that around the country, mostly in academic centers, but I love lights and sirens and I wanted to help. So I went to the fire chiefs and asked if they thought it'd be a good idea. They thought it would. I went to the hospital, admin, president, and they agreed. For 6 years, I operated an emergency response truck in Kenosha County, going out to 911 calls alongside the firemen and women and paramedics. I have 3 kids. They were young at the time. And about 7 years into doing it, I got in my car one day to go to work. My daughter had written in crayon a letter asking my boss to not have me work so much because they didn't see their daddy. Kenosha was about a 45-minute drive from my house, and though the hospital agreed to let to do the truck program, they didn't give me any protected time, so I was doing 15 shifts a month in the ER, and then on my off time, I would go out in the truck and respond to the calls. So I talked to my wife, and we decided it was time for a change. I left at the end of 2017 and came to North Shore, which is now called Endeavor, which is much, much closer to my home in the suburbs north of Chicago. I quickly became the EMS director there. Actually, though the hospital was supportive of, again, another truck program, they weren't really going to give money for it. So we luckily found a foundation, a private donor to fund the truck. And now I'm actually able to spend 50% of time in the ER and 50% of the time out in the field with paramedics.
Let me ask you something. Did you go to med school straight out of college?
I did not.
Did you continue doing it? What did you do in between?
I worked. Yeah, go ahead.
What did you do?
I spent some time being a young adult. I worked as a waiter at a restaurant.
Did you continue any EMT work during this time?
Between college and medical school? No.
Tell me a little bit more about this. I call it or you call it the Physician Response Vehicle Program. Is that correct?
Yes.
We shorten that to PRV.
Sure. Yes.
Tell me a little bit more about the PRV thing. What was your calling, I guess, to do that? What caused all that?
Well, certainly the volunteer fire department in college helped, but even before then, my cousin was a police officer. And all my friends in high school were doing whatever they were doing on the weekends. I was doing ride-alongs with him in his police car. I think I've always had a yearning for that line of work. Both my parents are physicians. My father's an internist, my mom's a radiologist, and I would hang out with them and did not feel the passion that I did with lights and sirens and emergency medicine.
Okay, tell us a little bit about what exactly you do in
Sure.
that program.
Sure.
Are you alone in this truck?
I am.
How do you get calls?
Sure. So I'm licensed in the state of Illinois as an ALS non-transport vehicle, so kind of like a fire truck, but I carry special equipment and medicine, including physician level medications. I have radios, as I mentioned, as lights and sirens. I have apps on my phone. I'm the medical director for the 911 dispatch center in our area. So when a call comes in, it will go off on my phone. I decide whether I think I could help or not, and I will meet the paramedics on scene.
You said you did this first in Kenosha, correct?
Yes,
And you left them in 2017, is that what you said?
correct.
What happened to that program after you left?
It failed.
Fairly quickly after you left?
Yes,
Why?
because my replacement didn't have the same passion that I did, and though I spent a year after I came to North Shore actually volunteering to help her promote the ongoing PRV up there, it just faltered and went to zero.
Does anyone assist you with the program in Chicago?
No,
It's just you.
yes,
You said there were only maybe 20 or 25 of these in the country, is that correct?
right,
How many more are in the Chicago area?
none.
How many more in Illinois?
Two others.
Where are they in relation to you?
One is in Rockford, Illinois, one is in Peoria,
How far away is that?
over an hour.
Both of those?
Yes,
They vote north of you, south of you.
south, I cover from the northern Chicago border. The region goes up to Wisconsin. My fire department service area is a little small. Basically in Northeast Illinois after Chicago.
You have any anecdotes from that you want to tell us? From doing that?
Sure. One of the first calls I ever went on in Kenosha was a newborn, home delivery. The midwife was having trouble, the child was apneic. So I went with the paramedics, they had trouble intubating the newborn, I was able to do that. That kid's 10 years old now. There's a cardiac arrest of a father down the street from our house, actually in front of his teenage kids. We resuscitated him, but he kept going in and out of VFib, ventricular fibrillation. So I carry lidocaine on my truck. The paramedics don't. I was able to give lidocaine. It resolved the VFib. I activated a cath lab far earlier than the fire department would typically be able to. And that dad is now actually a board member for the fire department in my community. And a 50-something-year-old fella who had a large vessel occlusion stroke. He was flaccid on one side, aphasic. And I was able to activate the neurosurgeons and stroke neurologists from the field. We got him to the hospital and he's now symptom-free. And then actually this week I went alongside one of the fire departments for a 13-year-old who was in clear psychiatric distress. She was threatening to jump out of the car. That's her dad was driving, so he pulled into the fire department. And though the paramedics were trying mightily, it just wasn't going the way that I think everybody wanted. And I know they were about to put her in 4-point restraints and drag her out of the car screaming. I was able to actually contact the police social worker who I have a relationship with, who agreed to see her emergently and talk the patient down. I got dad to agree, and then I trailed them over to the police department. So she avoided the hospital and inpatient stay.
So safe to say without this program, these folks wouldn't have had probably nearly the beneficial outcomes that they had when,
Right.
tell us a little bit more about your family, please, sir.
My wife and I have known each other since we were in kindergarten. Our parents still live a block away from each other. Her dad and my mom were in medical school together. She dumped me in seventh grade and waited 25 years to marry her. I have a 20-year-old daughter who's a sophomore in college at University of Colorado. I have an 18-year-old son with autism. And then I have a 14-year-old daughter who's about to enter high school.
The autistic son, what are his particular needs?
Well, Nathan's one of the happiest guys I think you'd ever meet, which sometimes can be annoying. He doesn't drive. He can't live independently. So though he goes to public high school, he has a robust special needs program and services.
And I think we've been through a lot of this already, but let me just sort of repeat a little bit of this. Back to iDrip, yes. How and when did you get involved with it?
An ER nurse from Kenosha put myself and the other doctor in touch with Mr. Collins.
When was that?
Around spring, summer of 2020.
But it was already established. It was a going company in Arizona, that you called, correct?
Yes, sir.
And you were not an owner or a member of that company.
Correct.
So your role was, I believe you said earlier, you were an independent contractor medical director.
That's right.
Started in just Arizona when you first came.
Correct.
When did they begin expanding?
I don't remember exactly, probably a year after that.
Were you ever consulted or have any say in where they expanded to?
No.
Now, when you first joined up, yeah, I believe you said, that, I'll get you to repeat, you asked if it was compliant with state law in Arizona.
Repeatedly.
Whenever it expanded to another state, did you ask about those states?
Of course.
When did it expand to Mississippi?
I think the fall of, no, I'm sorry, about the summer of 2022.
Did you ask those comply with Mississippi?
Yes, of course.
Who did you ask?
Mr. Collins.
Now, he was the CEO and the owner, correct?
Yes.
Kind of akin to, how large was the company, do you know, in terms of?
He actually would evade that question. Sometimes I realize this goes to doctors' question if I have mental disorder, but we asked that and he would never give us a definite answer. I'd say at the end of operations, total of 20 employees.
So, but he was telling you that he or someone else had checked and verified that it was compliant, correct?
Yes.
You said you created the SOPs for iDrip?
Yes. Well,
Was there any, okay, go ahead.
sure. The handbook was a skeleton form when we came on, so myself and Dr. Tradesman and eventually the pharmacist made it much more robust, included contraindications, et cetera. And then the SOPs and the safety parameters were designed by Dr. Tradesman and I.
Now, so there were multiple medical directors. How did y'all split that up? Were you assigned to a state? Were you assigned to?
Sure. It was fluid, but the nurses by last name would get assigned to one of us and they could use our phone to contact.
Alphabetically.
Yes, alphabetically.
So, but you said that they all could text you or call you, they had questions or something.
That's right. Yes,
Did you ever get any of these kind of calls from these?
of course.
Ever get any from the Mississippi nurses? Don't know.
I don't know.
You ever tell them at any time, not to give fluids?
Yes,
So when did you first learn that iDrip may have a problem in Mississippi? Over
The
that.
beginning of 2023.
And how did you learn about it?
I think Brandon Collins was made aware of the nurse investigation. He let us know that there was a nurse investigation.
And then, so what did you do personally when you found that out?
Started importing him to get a more robust compliance picture together so we can make a decision.
What do you mean by compliance picture?
Though I had asked him if we were compliant and abiding by state's regulations and was assured that we had been, clearly this investigation meant that something was amiss.
And so when did iDrip then put a stop on business in Mississippi?
The day after the hearing for Nurse Bates, I think.
Hearing or interview?
What? Interview, I'm sorry,
So
yeah,
that was in March.
early March.
Had you been contacted by the Board of Medical Licensure?
No,
When were you first contacted?
I think August of 2023.
And we say that iDrip is no longer in business, is that correct?
Business was closed before I was even contacted by the board.
So then you were contacted by the board in August and you came here in September to meet with Dr. Cleveland, is that correct?
Yes,
Did you bring anyone else with you?
no,
Why not?
clients, individuals, basically told me this is most likely going to be an informal interaction that I didn't need counsel.
Did you talk to anyone before meeting with Dr. Cleveland?
No,
When you got here for the meeting, do you recall if they told you that day that I know you didn't bring a lawyer with you today. You remember they told you you could have one?
if they did, I do not remember that.
What about that you could leave at any time?
I don't remember that either.
What about that you didn't have to answer all of the questions or any of the questions?
No,
Did they tell you that they were recording it?
no.
What was your feeling about the interview once it started? How did you feel?
I've never been in trouble in 15 years of practicing medicine. I've never been in an experience like that, and it pretty quickly felt like an interrogation.
At one point during this, did Dr. Cleveland ask you if administration of IV fluids was the practice of medicine?
Yes, I think he did.
What did you answer that?
No,
Right? Did he question you about that answer?
yes,
Did you change your answer?
I did.
Why?
Like I said, I've never been in a situation before. I felt like I was an interrogation. I didn't know what answer they wanted, and I was trying to make it right by them.
Not saying that you did for purposes of just questioning, but did you ever intentionally violate a Mississippi law?
Of course not.
Did you know that what you were doing for iDrip was in violation of Mississippi?
No,
When did you find out it may even potentially be in violation?
at that meeting. Yeah.
Have you worked with any other IV hydration companies besides iDrip?
Absolutely not.
Have you owned or been a member of any of them?
No,
You weren't an owner or member of that one either, correct?
correct.
Will you ever do this again in the future?
Never.
Have you told your employer about this investigation?
I've told my employer and the state EMS director.
What is your understanding of what will happen if this board suspends or revokes, takes other action?
I'll be fired.
What would happen to the PRP program?
It will go away.
No one there to take it over for you in case you can't do it?
No. I'll also lose my spot. I'm co-chair for CESA legislation, CESSA, which is the Community Emergency Services and Support Act. It's state legislation toward helping people in psychiatric and social service crisis and trying to reduce the fire department and police response and getting these people to non-hospital, non-jail locations. So I'm one of the co-chairs for that committee. I will lose that position. Will also lose my faculty appointment at University of Chicago.
So that's really most of my 20 questions. I guess I'll leave it for this moment. What are you here asking the board for today, or what are you here wanting to tell the board?
I clearly understand why I'm being painted in the way that I am. I also understand that some of my answers can come across as seemingly evasive or like I'm non-remorseful. And I can't think of any other way that I can express that I certainly am remorseful. I don't sleep. I have a therapist. I'm not nice to my golden retrievers. I never would have participated in any of this had I known anyone was at risk of being harmed. And the moment that I found out that we weren't doing right by the statutes and guidelines, the thing was done. I just want to be an ER doctor and an EMS doctor and provide for my family.
We talked a little earlier about a couple of other cases that have previously come before the board, and one of which had some extra or varied things that doctor was allowed to do. Would you be willing to teach or offer CE courses or tell other doctors your story about the dangers?
Of course, I would do anything to minimize the risk that or eliminate the risk that my license is in jeopardy.
And you said you've already started, tailoring down your licenses in other states. I mean, do you have any intent to practice in Mississippi again?
Never.
And no interest in IV therapy anywhere ever again, correct?
Absolutely not.
Dr. Feinzimmer, when did you become an emergency medical technician?
I became an EMT for a volunteer fire department in 1995.
Okay, I'm not trying to trick you. I'm sorry, your resume, which I have not, I got to pull back up, but it said 94, but so 94, 95, roughly the same time, right?
Yes.
How long did you serve as an EMT? Just an EMT, that first shot stint.
Just under 4 years.
What training did you get to qualify you to serve as an EMT?
Classroom and clinical hours.
And what state was that?
Ohio.
Were you ever qualified as an EMT in any other state?
No.
You recall what you were taught about the scope of practice permissible for an EMT in the state of Ohio?
Mr. Burns, it was 30 years ago, so my memory is poor. Your next question.
Okay, so, well then, when you were an EMT, were you ever told, or do you recall ever learning that EMTs only had authority in emergency situations as part of an emergency response team?
Right. You're asking me, is as an EMT, I could only interact with someone during an emergency? Is that what you're asking?
Correct, as a medical professional.
No. If I had training and skills, I could help people. I mean, if someone falls down on the side of the street, of course, I would help.
But, and I'm not asking, for good Samaritan situation. I mean, as a type of licensed healthcare professional, or as a medical technician, do you know what your lawful prescriptive authority was? Was it the same in emergent situations as it was in non-emergent situations?
I need an example. I'm not following the line of questioning.
Okay. One second. Are you gonna do that? EMT system? You know anything about the laws governing the practice of the EMTs or paramedics, which is, I understand, is like the highest grade of EMT? Can we agree on that?
Paramedic is more highly trained than EMT, yes.
Okay. Do you have any understanding of the authority of an EMT or a paramedic, the prescriptive authority, the authority to practice medicine of one of those emergency professionals in the state of Mississippi?
Objections is not relevant. It's also not within the scope of Mr. Chapman's question.
Mississippi has wide open cross. That's what this is. Also, Dr. Beinzimmer is telling the board that he does not understand the differences in prescriptive authority. And he has been an EMT since 1994. I am asking him, trying to get to what was his understanding of the lawful scope of practice he was permitted to do when he was an EMT. One of the persons here was a paramedic. I think it's relevant to his understanding of prescriptive authority, both as an EMT and as a physician.
I'm gonna sustain your objection.
I believe earlier, one of the board members asked you some questions about, like, just what is good medical practice? Patient comes to you, and I'm paraphrasing, but a patient comes to you, you examine the patient, you have a doctor-patient relationship, good faith created, you evaluate the patient, check history, you do examination, reach diagnosis, and then you have a plan. Do you recall that general conversation?
Yes.
Okay. Earlier asked questions, I believe, about your practice as an emergency medical doctor in emergency. And I'd like to follow up a little bit on that, but to your recollection, have you ever ordered an IV for a person who reported that they were suffering from a hangover in your role as an emergency physician?
Yes.
You have. What was the medical diagnosis?
I don't know if I gave them a diagnosis that they felt dehydrated or tired.
Well, that's what I'm saying, was dehydration, that's a medical condition, is that why you would give some, is that one of the reasons you give someone fluids?
It can be.
Well, you recall giving someone an IV in an emergency room for your hangover, you do not recall, you made a medical diagnosis of dehydration or a regular condition.
Are you asking me to recall all the patients that treated with IV fluids for a hangover and what I gave them the diagnosis is?
Well, I certainly am interested to know if that's a routine part of your practice as an emergency physician, to treat hangovers with IVs.
When people describe they don't feel well, they're fatigued or possibly dehydrated, it is reasonable to give them IV fluid.
When they report to you as because of a hangover, because they consume too much alcohol.
Sure.
Dr. Meisner, I believe you testified earlier that you believe you made approximately $45,000 over the relationship with iDrip. Was that for the entire time or just for during the time that you were participating in Mississippi?
I don't remember the exact amount, but that's approximately the entire time.
Do you know how much money iDrip as a business made during that time?
No.
Do you know how much money the iDrip practitioners, the RNs, LPNs, paramedics, Mississippi made?
No.
Excuse me, I'm sorry. I apologize for cutting you off. To finish, my question was based on ordering supplies and using medications and supplies that were ordered under your prescriptive authority. You have any idea how much money they?
No.
Trying to make sure that I understood your prior testimony. I understood you to say that if you were working in the hospital, the CEO of the hospital told you what was acceptable for you to do as a physician so that you would convert to the CEO of the hospital. Did I understand you correctly? Or
You understand me correctly. Of course, there are gradations of that.
if the CEO of the hospital is not a physician, would you still defer to the non-physician to tell you what is acceptable for you to do as a physician in your professional capacity?
I would need examples. There are gradations, but if you're asking me if he told me what to do in a cardiac arrest, of course not.
Now, I thought that earlier today, when you testified, that you said that you had never communicated directly with the IDRIP practitioners in Mississippi, but I believe that when Mr. Chapman was questioning, now you said you're not sure. I'm just trying to understand.
I think the original question more targeted, did I know the names of the practitioners in Mississippi? And the answer is no, not off the top of my head. If any of them contacted me for medical, or via text or phone, I don't remember.
So you can't say that you cannot say affirmatively that you ever communicated with the IDRIP practitioner. And so did I understand you correctly say that when you were helping develop protocols or the manual or the safeguards for IDRIP, and I apologize, I don't recall the exact term. I'm not trying to be vague, but you said something along the lines of that you were available 24/7 and that the pharmacist available 24/7. Your license in Mississippi is under the Interstate Medical Licensure Compact, isn't it?
Yes.
I have no questions.
Any redirect? Okay.
Let me clean up the CEO. Doctor, the CEO of your hospital comes and tells you how to treat cardiac arrest. You have any word for it?
No.
The CEO comes to you and tells you that the HR department and legal team have decided that something that's being done in the ER is not in compliance with state law. Are you gonna take his word for that?
Yes.
So like you said, it's predations, right?
Yes.
That's what they're telling. Something else I forgot earlier, I guess, back in your EMT service, I think you did mention this earlier, either to one of the board members or in your earlier testimony, Ms. Barnes. Something about signing off on orders for narcotics and other medications for a paramedic truck, correct? Explain that a little bit more.
Typically, a fire department, municipality, or a private ambulance service will send to me a piece of paper from typically a company where they can order drugs, including narcotics and medical supplies. I use my DEA as their medical director, sign my name, check the box, they can order whatever substances they need. They use that over until the expiration date, at which point you have to re-sign, but over that period, they can order at will.
Because their truck has to have that on it.
That's right, the ambulances, yes.
Now, so how long have you been EMS director, some capacity for how long?
Almost 15 years.
Been doing that regularly throughout that 15 years?
Daily.
Practice. So you're used to in your practice that being acceptable habit, correct?
Yes.
So. So the IDRIP process seems similar to that. Granted, it's not an emergency, but it seems similar to that was what you had done.
Yes.
So when you asked if this was compliant with the law, you took the CEO's word, that was correct.
Right.
Arrest.
Mr. Chapman just asked you additional questions about, I assume, standing orders in the EMS context, correct?
Yes.
And testified that you were used to that, right? Do you know whether that is legal in Mississippi? A legal use of standing orders outside the context of an emergency system, an emergency management system context? Are you aware?
I am, after I came down, you explained it to me.
Okay. And so you understand that is not legal in Mississippi. That's not a legal use of standing orders in Mississippi. Or you understand that was represented too?
Yes.
Board members have any questions? I do. Dr. Lipcott, I'm gonna start with him. I thought he was itching at the big.
That's fine. Could you tell me about your relationship with Brendan Collins?
He was the CEO of Hydra.
He was the owner.
Yes.
Did he, were there other owners besides him?
No.
How did you meet this individual?
An ER nurse in my original job in Kenosha, Wisconsin, put us in touch. She was moving to Arizona. She knew of this program. She interacted with.
What program?
The IDRIP, she knew of IDRIP in Arizona.
Was it already established?
Yes.
And they were already operating?
Yes.
And they already had doctors
No,
How were they operating? I don't understand.
Brandon had explained to me that he looked into the operational standards in and around Phoenix, I think. And that they were following regulatory guidelines. And that me coming as medical director would help expand and write these protocols for them.
Okay. And you mentioned, Dr. Trezon, he was your colleague also at
Tradesman, yes.
At Tradesman. He was also your co-medical director at.
He was an ER colleague of mine and one of the other medical directors.
So, has he had problems like you're having?
No.
Was he operating in the same jurisdictions that you are?
No, Brandon used us separately. So if I held a license in a state, I would be responsible for that state, and Dr. Tradesman responsible for the state that he held a license in.
So, you had asked him about the compliance, but when the nurse in Mississippi was investigated, you got him to seek a compliance consultant, or what was that?
There had been some discussion with compliance personnel. I can't remember the timing, but it's of course after this nurse investigation, we ramped up. It's two ex-DEA agents who formed a consulting firm, a compliance consulting firm. So we hired them.
Okay, and what did they tell you?
That there were problems.
There were problems in Mississippi,
Yes.
Were there problems in other states?
Yes.
So the consultants told you there were problems, and this was in the summer of 23. I mean, this was.
No. The early months of 23 is when we were notified that there was an investigation of a nurse in Mississippi. The day after we were made aware of the interview of the nurse in Mississippi, we stopped Mississippi operations. Over the subsequent couple months, the compliance team formed recommendations, guidance, and warnings about other states. And over that time frame, we planned the complete shutdown of the company.
But the compliance team advised you that you would not need an attorney when you met with Dr. Cleveland in September. Is that
She
correct?
said to me, typically these are informal, you should be fine.
And when did you decide to get a lawyer?
As the interview was going on, I sensed this was not going to be fine. I knew I had a problem, and then after they excused me from the room and brought me back in, Dr. Cleveland told me that I have a problem, that I better get a lawyer. And then I was walking out, Mr. Barnes offered me the names of a couple of attorneys here, including Mr. Chapman.
Did you have any other assistance getting legal counsel besides that?
No.
And did Mr. Chapman advise seeking assistance with the legal counsel?
No, he didn't suggest that. I knew that since I have licenses in multiple states, and Dr. Cleveland made it clear that I'm going to have problems in multiple states, I sought out an additional attorney who had experience in multi-state jurisdictional matters. Then, as we tried to come to an agreement over the last several months, it was clear that that was not going to happen. So then I brought in Michael Bentley with the probability that this was not going to go my way and that we would have to file an appeal.
So have you been offered alternatives to a hearing?
I'm going to I'm gonna ask that that be struck from the record, that he can't answer that question. To the he can't answer that question. Do you have any other questions for him? Dr.
No, that was the last
Owens?
one.
Okay, thank you. Any other, Dr. Owens? I apologize.
Just a couple of quick follow-ups. When you think about your relationship with the then CEO, Mr. Collins, just your personal opinion, do you feel that, and I understand that retrospectively you may view this differently, so I'm giving you all the leverage there. Do you feel like they were being honest and transparent with you, or do you feel like that information was just, do you believe that they were genuinely, they genuinely believe they were in compliance? Or do you believe that it was just, you're asking the question, either they didn't do due diligence, or they made assumptions, or may not have recognized that it might not be the same from state to state? What's your impression of that being?
I've worked very hard at not being angry because this has threatened my livelihood and my ability to take care of my family. I don't think he's a bad person. I don't think he was out to harm anyone. I think he had dollar signs. So I suspect that he definitely was cutting some corners. And when he shared with me and Dr. Traceman that we were compliant, perhaps in his mind, he made one phone call to the wrong person. They said, sure. But I don't know.
And I apologize, because that question in retrospect was probably would cause you to be a little bit more speculative about a person's intentions. I guess the better question would be, from the person who never went to law school, the better question might be, was there ever any evidence that was presented to you when your requests were made that would have assured you that the information that you were given by the CEO was in fact accurate and reflected that they had done their homework to be able to give you that answer?
He would say to me things like, we've spoken to the state's attorney, we've spoken to the Board of Nursing, we've spoken to the Board of Pharmacy, and this is fine.
So it was all just verbal, never anything, okay. And you alluded to this, and I do not want to delve too far into your personal business, but I do think that this is important. This process has an effect on licensees. And so you mentioned a little bit about not sleeping and those kinds of things. What has this been like for you?
I hope this isn't targeted at getting on the record that I have a mental problem, but
No, and so it is not, it's just an opportunity for you to share that part. And you can feel free to share as little or as much as you choose. If it's just an opportunity.
like I said, I started seeing a therapist. I've never had trouble sleeping in my entire life until the last 9 months. I wake up repeatedly every night for multiple hours, can't fall back to sleep. I have vitiligo, and when I get stressed, it gets worse, and it's gotten a lot worse. I have heartburn that I can barely control sometimes. I'm afraid. I'm very afraid. I want to be able to take care of my son. If I lose health insurance, I don't know what happened. My daughter just got a slide tackle in a soccer game and destroyed her ankle, needed surgery the next day and 3 screws. And without health insurance, I don't know what I could do. I'm ashamed. I mean, to look at my kids in the face and say, Dad lost his job. I don't.
Thank you for that. And you don't have to say anything.
You need to talk to you.
Sorry, Dr. Feinzimmer. I've got Dr. Givens here. I've got a couple of questions, kind of maybe just like piggyback off what Dr. Owens said. These are just basic questions, but when you obtained your Mississippi license, that application, did you do it yourself, or did you have someone else?
The compact.
Okay, through the compact. Okay. And so that was granted. Two basic follow-up questions. When it comes to your license, okay, ultimately, regardless of who you ask, ultimately, who's responsible for your compliance and adherence to the rules and regulations? Who is ultimately responsible?
Me.
For you, right, okay. And then the third question is, this would be kind of in hindsight, what source would be a more trusted source if you had a question as to the structure of your practice or how it engage? What source do you think may have been something that you could have reached out to? Sure. Because you asked the CEO anything. Sure. What would have been an alternative, a more direct source to get the basic information that you need?
An attorney.
Or
directly to the medical board.
there we have. Okay. And that's all I wanted to just ask. Thank you.
Any other questions? Okay. You may step down. Are there any other witnesses? Sure, last one.
No.
Okay, closing argument.
If I may, I'd like to re-urge our motion earlier this morning.
You may.
At this point, I'd like to reassert, Dr. Feinberg's motion to dismiss on the basis that the eye drip therapy was not involved in the practice of medicine as defined in the district law. As we all saw today, they were not treating an ailment, but they were not trying to cure an ailment or a disease as the statute requires. We saw that the forms filled out by the client were acknowledging that they had no medical condition to be treated, and also acknowledged that they were not being provided medical treatment. The statute is vague enough that the guidance was required, that the board put together guidance, that it was because it was so vague, and any vagueness in a statute has to be construed in a manner most favorable to the alleged offender. Dr. Feinzimmer has testified that he was not aware that this eye drip therapy practice constituted the practice of medicine in Mississippi, and the fact that guidance was issued after Dr. Feinzimmer's interview underscores the vagueness of whether eye drip therapy constituted, that their business model constituted the practice of medicine in Mississippi. I'd also like to reassert our motion to dismiss for the need for a jury trial.
I'm gonna stop you there. That was already denied, and you did not submit that information to the board. Originally, they only considered your first motion to dismiss.
I'd just like for that ruling to be reconsidered. The board could consider our motion for a jury trial before making rulings that deprives Dr. Feinzimmer of his property rights and liberty to practice his chosen profession.
Any rebuttal from counsel?
Don't recall the name, but in our response to their to exclude evidence, we cited the Mississippi Bar case, which specifically said that there was no right to a jury trial in a professional discipline case. That was one example. Another was that there was no right to effective assistance of counsel, and another, these are mostly bar disciplinary cases. That's the context that come up because I think those lawyers are most argumentative. But that the full panoply of constitutional protections available to criminal protections do not apply in administrative proceedings, and that is a specific hold about the Supreme Court that there is no right to a jury trial in administrative disciplinary.
Again, I deny that motion. for jury trial. I am charged with giving legal advice to the board. And so I would advise the board to deny that motion. They didn't hear that motion or even consider that motion today, so their motion for reconsideration is denied. However, you can continue with your motion to dismiss based on the argument that eye dehydration is not the practice of medicine. At this time, would you like the board to consider that motion?
Yes, I would. I would also like the board to consider the argument in the omnibus brief related to the board's discipline must be proportional to the facts established in Dr. Feinzimmer's case. And that'll be covered in more detail by Chapman in his closing. However, we do have some legal authority in the briefing, the omnibus briefing that was submitted, and I would encourage the board to consider that legal authority as well as Mr. Chapman's arguments and those.
So procedurally, I just want to be clear, you want the board to consider, was that treated as a motion regarding the proportionality? We need the wording for the record.
So it is just a part of the larger omnibus motion, and that it is the board's discipline must be proportional. And it's section 5 of the omnibus motion.
Again, if Attorney Chapman is going to cover that, I think it's actually a moot point. There have also been 3 exhibits, if I'm not mistaken, or 4 board orders, which detail several different IV hydration issues. And the board can review those during their deliberation. So arguing that point would be moot, so I'm going to deny that as well.
Thank you very much.
Thank you. At this time, I'm ready for closing arguments.
Three charges have been brought against Dr. Feinzimmer and described in the charging affidavit. Count 1, licensee is guilty of prescribing, administering, or dispensing any legend drug without a good faith prior examination and medical indication in violation of Title 30, Part 2640, Rule 1.4, maintenance of records and inventories of the board's administrative code. That violation of the administrative code results in a charging offense of a violation of section 73-25-29. Count 2, based upon the foregoing, licensee is guilty of unprofessional conduct, which includes being guilty of knowingly performing any act which in any way assists an unlicensed person to practice medicine, all in violation section 73-25-29A-B, 73-25-A. Stop there for a moment. So that Dr. Feinzimmer testified extensively. He didn't know he was breaking the law. He didn't know he was violating the law. The question for this board to decide is, should he have done? Should a physician, putting himself in this position, have inquired with more diligence about whether or not the business he was associated with was in compliance with state law? Should he have known the standards that apply to the medical profession better than he did when he's been practicing since, I believe, 2008? So knowingly performing any act does not mean that he has to knowingly say, I'm going to assist them in unlicensed practice of medicine. Did he knowingly perform an act that permitted them to engage in this practice? He knowingly permitted iDrip to use his credentials, to use his signature, to use his licensure to order medications. He knowingly allowed iDrip, not just clinic supplies, but prescriptions, electronic prescriptions submitted with his credentials in his name. And as a result of that, unqualified, unlicensed personnel, RNs, LPN, and at least one paramedic, were assisted in their unlicensed practice of medicine. We admit that we do not have any evidence or to present of patient harm. However, patient harm does not mean that there had to have been an adverse outcome. Patient harm occurs when unqualified personnel are permitted or assisted or helped to practice beyond the scope of their practice, beyond their scope. Dr. Feinstein's attorney went over the discipline imposed by the nursing board on one of the RNs and emphasized that it was a reprimand, that there was a suspension. There were quite a few CMEs. Again, the approaches that different boards have toward discipline, that's, the business of each board. However, the admissions made by that RN in that order are extremely tough. She admitted that she was practicing beyond, her lawful scope of practice. She admitted that she was doing that by administering medications that she had no authority to do. And there are other admissions. The order is in the record. So I think that's very important for the board to consider on count 2. Count 3, based upon the foregoing, licensee is guilty of unprofessional conduct, which includes being guilty of any dishonorable or unethical conduct likely to deceive, defraud, or harm the public. 732529 AD and 732583A. A violation of the rules, a violation of professional standards, a violation of good medical practice is unprofessional conduct. Even if the board were to find that Dr. Feinzimmer was somehow not guilty of count 2, of this, the unlicensed practice of medicine, counts 1, prescribing, administering, dispensing alleged drugs without a good faith prior examination, and the resulting unprofessional conduct charge in 3, are fully applicable. Very briefly, I want to talk about the proportionality issue. As we know, or I fully expect that Mr. Scott is going to address it. You heard testimony concerning these particular orders in question. You heard testimony from Dr. Cleveland about his understanding of the differences in these cases. Mr. Chapman pointed out that there was a range of discipline given in those cases. And in each of those cases, those practitioners were actually physically present in Mississippi. Those practitioners actually had some direct involvement in the care and evaluation of patients. Example in Dr. Verisetti's case, the RN did an examination, but relayed all that information to Dr. Verisetti, and Dr. Verisetti actually considered it and then sent back an order saying it's okay. That doesn't comply with the board's rules, but that explains the differences in the levels of discipline that were applied. Dr. Headley received the most stringent discipline from this board in connection with these cases. And again, that was based largely on the fact that there were unqualified personnel at the core, I think it's core hydrotherapy. I forget the exact name. But at the core facility, of which he was a 50% owner, were being assisted to or allowed to practice medicine. They were being allowed to do things that they were not qualified to do. This board gave him a 12-month suspension, suspended 6 months of it. And then, at the request of his counsel, and with the agreement of the executive director, recommended to the board that you accept the consent order, giving him the opportunity to earn back 2 additional months off that 6-month suspension, resulting in an active suspension of 4 months. Dr. Headley cooperated with the board. Dr. Headley cooperated with the investigation. Dr. Headley agreed and came before this board, and there was the presentation of a consent order. Dr. Feinzimmer, of course, everyone is sympathetic, to a physician who has gotten himself in a position where he has committed serious violations of Medical Practice Act and the regulations. Everyone is naturally sympathetic for the consequences that that's going to engender. All discipline imposed by this board engenders consequences. Every suspension this board hands out has the potential to do that. Every reprimand, every form of discipline the board awards that's reportable to the data bank is going to have serious consequences. Dr. Feinzimmer is a compact licensee. That means that Dr. Feinzimmer, if he's found guilty and disciplined, will not be eligible to the expedited renewal available to compact licensees in the future. It does not mean that he would automatically lose his compact licenses. And I don't want to get into the legalities of the authority of boards to consider reciprocal action, et cetera, under the compact. But there is a provision that says any discipline results in the loss of the expedited renewal. However, Dr. Feinzimmer could still, in Mississippi, he could apply for a permanent DO license. He could apply for permanent licenses in all those other states where he originally became licensed as a member of the compact study. Dr. Headley, of the cases that in the 3 orders were given, is by far the closest to this. But again, that was one location. It was physically located in the Jackson area. Dr. Headley was here. Dr. Feinzimmer allowed this company to use his credentials and send them to 7 different locations across the state. Dr. Feinzimmer I'd like to suggest that the board must consider carefully how fully Dr. Feinzimmer in his testimony, his appearance today, has accepted responsibility for his actions and inactions and omissions that led him to be here today. That, of course, is the determination for this board as the finders of fact and the judges of credibility. And as I have said to the board many times, it is within this board's province to determine what the appropriate level of discipline is in a given case. We agree that proportionality is certainly one of those considerations. It is an important consideration that discipline be proportional to the misconduct. However, it's not the only consideration. Mississippi Bar v. Williamson, 368 Southern 3rd, 803. One case is one case. There are many bar cases that address these points. But it specifically instructs to determine the appropriate, this was a reciprocal discipline case. The bar was asked to mirror discipline for a lawyer who had disciplined another state. The Mississippi Supreme Court said, determine the appropriate sanction. We employ the same criteria as in ordinary discipline cases. 1, the nature of the misconduct involved. 2, the need to deter similar misconduct. 3, the preservation of the dignity and reputation of the profession. 4, protection of the public. 5, the sanctions imposed in similar cases. The proportionality, one factor. 6, the duty violated. 7, the lawyer's mental state. 8, the actual or potential injury resulting from the misconduct. And 9, the existence of aggravating and or mitigating factors. In that case, again, a bar case, the court went on to say The failure to follow the rules involving duties to clients involves the most important ethical standards this profession espouses. Thus, the need to deter the neglect of clients is great. The medical profession is subject to similar duties, obligations. Every physician licensed in the state has them. The court also went on to briefly mention preservation of the dignity and reputation of the profession and said this court has repeatedly observed the purpose of discipline is not simply to punish the guilty attorney, but to protect the public, the administration of justice, to maintain appropriate professional standards, and to deter similar misconduct. That is again, Williamson case, 368 Southern Third, 803. And the discussion is, I can't find the page number, and I don't want the whole thing's up, but I'll provide a copy to the hearing officer if the record could reflect that it is in that case. So Mr. Chapman has an opportunity to make a closing statement now, unless there's some reason that comes up that I feel that I simply must address the board again. This will be my last comments. You're each aware of your obligations, both to the profession, the disciplinary process, and to Dr. Feinstein. You know your duties. You are the finders of fact. You make the conclusions of law, which includes whether or not this was the practice of medicine. That's a conclusion of law that this board has specific authority to decide. This has been a long, grueling day. Again, I know Mr. Chapman has got comments and we'll listen to them carefully. I just want to thank you for your attention, because it has been a long day and it's not over yet, but it looks like we're nearing the finish line and the board has all the information necessary to reach it. And thank you. I'm sorry, yes.
I was wondering if Paul was gonna get around to thanking y'all. I was gonna start with that myself, actually. It has been a long day. We do appreciate y'all, appreciate the opportunity to be here. It's not a record for the latest I've been here, but we did close. So, I would just start with this. We would reiterate again, although this has all been admitted into evidence, we have all these exhibits that we checked earlier in your hand. Council office has several evidentiary problems. What we're looking at is a bunch of records that the board received, in some cases third hand, some cases fourth hand. That through no hand they touched was there ever a certification that these were the accurate, complete records. There's no evidence of nothing to verify or authenticate that there was no manipulation done to them, no changes made to them. The originals, nothing. We have none of the evidentiary issue. Now, that may not be something the board wants to take up, but it's still something we have to at least point out. In fact, we had one of the investigators earlier testify, you know what, I didn't ask for anything. Thought he had enough to make his case. Well, sometimes that's not good enough. You have to get every document. You have to get what you need to make the case. You have to make sure that those documents are valid. None of that was done. It wasn't. It's sloppy. But as we're talking about this, beyond that, there's been mention of some of the other things were brought up, Toradol, Subbrand, things like that. There is no evidence that either of those were ever prescribed or ordered or received. That's something to point out there. And they may not care about that because there's always been the argument all day that any of this, the fluids, saline, even is a prescription drug and therefore it counts. We'll allow that to stay in, obviously, but I mean, that's what we're talking about here is vitamins. And they've even admitted this is solely due to the route administration. These are things you can buy over the counter, et cetera, no problem. But it becomes a prescription because of the rent. That's what we're talking about here. There's no narcotics. There's no habit forming drugs. There's nothing like that involved in any of this. Paul mentioned patient harm. I would take some serious issue with his definition of what harm is or is not. Harm is harm. There's no evidence that any patient caused any harm. There's no evidence that any patient complained. The complaint came from I guess, anonymous concerned citizen, and in all likelihood was probably a competitor of the iDrip folks. Going to get them out of business, most likely. If we want to speak to specific counts, we certainly tried to present the other day an argument that this is not the practice of medicine. Again, as I mentioned in my opening, words have meaning. Statutes are in place for a reason. The general rule is a statute must be read with its plain meaning. And what we have here is a statute that says, state's definition requires that someone suggest, recommend, prescribe, or direct for use. So that's a lot of different things that not just prescribing. You can suggest something, recommend something, direct how to use something. A drug, medication, other agency, for the cure, relief, or palliation of any ailment or disease in exchange for monetary return. Now, I didn't bring this up with Dr. Cleveland because I know he would disagree with this. But if you take this definition out, stretch it the way I think it's been stretched in this case a little bit, you could probably make the argument that 5-hour energy is taking a practice of medicine anytime they sell or advertise something to relieve fatigue or give you a boost. It's not a great argument, but that's what we're looking at. That's how we're reading this statute. It's a possibility. So when we look at the facts, not even speaking to the question we have of whether the records are valid or not. What happens is every single record in evidence that shows client visits, that shows prescription, shows that each of these individuals was told that the service was not diagnostic, that it is not for the cure or treatment of any condition. They don't report any condition. That's in the records. That's an element of this statute. So we're talking about whether or not this is a practice of medicine. If you're going to have a defined practice in a statutory definition, you need to meet all those elements. They just don't. Another point to that same count too is whether he had knowledge he was assisting in the licensed practice. Well, Mr. Barnes is going to that too as well about whether or not it needs to be, should he have that knowledge or does he have knowledge? Well, he did. He made an effort. He asked something. Now, did he ask the right person? Maybe not, but he made the effort. He made the effort repeatedly. And he was told. Now, whether that was a lie or whether it was somebody saying, maybe I did, but here, yeah, you're good. I mean, he looked at someone that told him they asked, told him they inquired of the right. And he took that on faith. He did not know he was violating any of these statutes. I would also point back to whether this is the practice of medicine or not. The board has now issued guidance. We do appreciate that. We accept that. We acknowledge that fact that guidance is out there regarding IV hydration practice. That guidance did not come out until after Dr. Feinzimmer was interviewed, which was months after any of this actually happened and months after they shut this practice down, stopped doing it. Generally speaking, in my opinion, or not my opinion, my experience is guidance is not really always necessary unless there's a question about something. You don't issue guidance unless it's something that's complicated, complex. It needs an extra explanation. It's not just a clear-cut issue. It's not. And the board did that. The board recognized that. That's why I issued guidance. There's no dishonorable or unethical behavior here. Dr. Feinzimmer, again, did not intentionally violate any law. He's told you all that. He's clearly shown through his actions he did not intend to do any of this. As soon as they found out that it was possibly in violation, they shut it down. That was on his request, his intervention. Again, he did not even know he was possibly violating law until he got here and spoke with Dr. Cleveland. And again, as I mentioned, there was no guidance from the board yet at that time. Now, Paul can argue that he should have or should have done more. Everybody could always say they should have done more. But it's not a duty. It's not a specified legal duty to do. He asked. He applied. Sad state, sad fact, but that's what happened. Now, even if this board finds that Dr. Feinsmer violated the law, any of the board's regulations, as we mentioned, any discipline that the board imposes must be proportional. Both the United States and the Mississippi constitutions require that any penalties or discipline imposed by an administrative agency, which the board obviously is, be reasonable and proportional both to the government's objectives and to the rights and individual interests of the affected person. Now, if you'll allow me to get colloquial for just a second, basically what that means is you can't swat a housefly with a hand grenade. What you do has to be in relation to all the facts and circumstances of each individual case. And that's all the facts, all the circumstances, not just what was done, but why it was done, how it was done, what was done to mitigate it, the individual involved. All of that has to go into this gestalt we look at, put together, and turn into your decision. Now, the board has a lot of options for what it can do. Mississippi Code annotated 73-25-30, section 1 offers the board several options. You can revoke a license, you can suspend a license, put a licensee on probation, or you can take any other action that the board deems reasonable and proper under the circumstances in relation to that licensee's license. But again, the board has to look at each case's specific facts and circumstances and nuances in order to do that. Now, and it's not really a matter of worrying about what future licensees may argue here or any of that like that. You have to look at the specific facts of this case. And you shouldn't worry about second person because, again, we've had, as testified to here, there have been at least 3 of these so far. And Dr. Cleveland testified they have more in the hopper. They're more they're being looked at. None of these is going to be identical. They're going to be different facts, different circumstances in each one. Mr. Barnes mentioned that the closest one to this case may have been Dr. Headley. Probably is the closest of the 3 that we brought up, but it's still not the same. Dr. Headley, while he may have been Mississippi, was also an elder. Dr. Headley had decision-making authority over what they chose to do. Dr. Feinsmer did not have that. He didn't know, he had no say in what states they expanded to. He had no say in that hired. He was the medical director under contract. That's what he did. And he did his job as he was told was compliant. Now, again, we're talking about this discretion the board has. The board has the discretion to look at the totality of all the circumstances and then take whatever action it sees fit for a particular case. I'll give you a couple of analogies similar to this sort of ability in the healthcare arena. When I first started practicing law, I did a lot of nursing. I don't know how familiar all of you are with skilled nursing facilities, those ones that receive payment from Medicare and Medicaid. They have a specific set of regulations called the standards, not standards practice. They have the basic standards, but they have regulations set out by the CFR, by the federal government, that they have to meet. In states, conditions. And they're surveyed roughly every year by the Department of Health. Sometimes a little more frequently, sometimes a little less. They're supposed to do it every 12 months. Sometimes it goes a little longer. They also have complaint surveys or other things that happen. But when a survey is conducted, they look at that and they determine whether they are out of compliance or there's a violation of any of those regulations and conditions of participation. And what they do then is they plug that into a scope and severity grid, which is a 3x4 grid that looks at 3 levels of scope, isolated, patterned, or widespread, and 4 levels of severity, which is immediate jeopardy, which is the worst. Actual harm to the patient falls into that. No actual harm with potential for more than minimal harm, but not immediate jeopardy. And then the lowest is no actual harm with potential for nothing. If you get that lower level, that no actual harm, that's deemed to be substantial compliance. It means there is no penalty. Any of the other ones then go through a system where they determine what level of debt. And then there are a range of penalties that may be imposed by the CMS. Now, the board doesn't have any regs or statutes that lay out any ranges. It doesn't say this particular violation must get this particular. Something that's fully discretionary. And that's based again on all the facts and circumstances. We look here. Again, I argue with Mr. Barnes' representation of what harm actually caused here. There clearly is no evidence of anyway, any actual patient harm in this. There's no evidence of any harm, any complaints of patient harm. There's no issue of narcotics or having meds. You know, again, no one suffered any actual harm. So we kind of can throw that out. And whether there's potential for harm, yeah, there may have been. There's potential harm for everything that gets done in that arena. Basically, any medication you get can have a side effect, can have interaction with something else. The surgery can go wrong. There's always potential for harm. But again, now, but we're looking at this in terms of you have to look at the whole picture. We would chose that at worst, this is a potential for harm. And it is. I mean, we'll say that. But in case it is, that still should be a lesser standard, proportional to the facts and circumstances than something else that would happen. Now, similarly, another analogy I'll make to you real quick, or try to make real quick. Medicare exclusions. I'm sure y'all are all familiar with that. You know, your provider under Medicare can decide they want to exclude you from the program. Social Security Act, Section 1128, which is 42 USC 1328-7, if anybody actual statute there, allows the Secretary of Health and Human Services to exclude providers from Medicare. There are multiple, and I can't remember the numbers, like 15 or 16 permissive reasons where the Secretary may decide to exclude someone if they choose to. But there are also 4 mandatory reasons. These are automatic exclusions if you be found in violation. Those include conviction of program-related crimes, conviction related to patient abuse, felony conviction related to healthcare fraud, or felony conviction related to controlled substances. And obviously what we're talking about here doesn't rise to the level of any of those 4. Those are 4 mandatory exclusions. However, I would also point out, even though they are mandatory, there is another section in that same statute, in section C3B, which allows the Secretary to waive a mandatory exclusion, except for patient abuse. Obviously, if you use a patient safety, they throw that one out, that's automatic. But in the other 3, which include felony convictions, they may waive in the case where an individual is either the sole community physician or the sole source of essential specialized services in a community. Now, Dr. Beismer has testified to y'all today. He is the sole provider of an essential specialized service in the Chicago area and really at the state of Illinois. He runs a physician response vehicle program that assists paramedics in saving lives. Gave us several examples of lives he has saved doing it. And he is the only one doing it. If it goes away, if his license is suspended, revoked, that program goes away and it's no longer available. So I'll leave that with you. Now, obviously, neither of these analogies is entirely the point, but it does show the same type of flexibility that this board has in determining if a violation is. So let's look at Dr. Beismer's circumstance. This is a long-standing physician. By all accounts, he's a good physician. He's active in his community. He has gone out of his way to personally expand community health services through this physician responsibility program. He designed this program in Kenosha and moved it to Chicago when he moved. That Kenosha program went away when he was gone. Chicago one will dissolve if he's unable to continue practice. This is something he has done personally to expand those services by himself. He is the primary provider in his home to a family that includes a special needs teenager. He is not an intentional bad actor. He did not do any of this intentionally. He did not intend to break any laws. He did not intend to do anything out of compliance with Mississippi rules and regulations. Mr. Barnes stated that he allowed Hydro to use his credentials. I think use is the right word. They used him. They lied to him. They brought him in, and told him what he was doing was acceptable and compliant legal, and used him to run their business and make money for their owner. And he didn't see much of, none of, other than his contract work. He did probably need to get all of that. He inquired as to legality multiple times. But was misled by a greedy, unscrupulous business boss. Word. And then again, when he learned that there was any potential non-compliance, he immediately shut operations down. This was long before he was ever contacted by this board. It was long before any of this happened. That was done in March, immediately after they found out there was potential. He has removed himself from his practicing. He no longer does IV hydration. He's told you he's not going to do that. He's effectively removed himself from Mississippi. He has caused no harm to any Mississippi resident. He currently poses himself no danger. It's probably the first time I've been in this room. I've been here a lot of times where somebody from this board hasn't mentioned that the mission of the board is to protect the public. We get that. We know it. We appreciate that. We appreciate what y'all do to do that for us. He is not a danger to the public of Mississippi. Anything going beyond this now is not prevention, it's punishment. And that doesn't seem just to us. Now, he's also indicated he's willing to take any other extra steps or actions this board deems proper to aid or enhance care in the state, or anything else that the board requires him to do. He's willing to accept any sanction this board deems proper, so long as it allows him to continue practicing uninterrupted and illegal, to maintain this specialized program he's worked so hard to set up and maintain, and to maintain his practice and provide for his family. All we're asking is for the board to allow him to continue his practice so that he can maintain that provide for those people. That would make
I need 30 seconds.
Okay.
Dr. Feinzimmer did not need the guidance from this board to tell him that there were violations in multiple states by IDRA because their compliance consultant told them that months before our guidance was issued, according to his testimony. So that undercuts the argument. Dr. Feinzimmer chose to get licensed in specific states where he was then assigned those states as medical director because he was licensed there. That is a level of control. Dr. Feinzimmer could not be forced to get a license in a state that he didn't choose. 3, if we follow Dr. Feinzimmer's logic about the consent forms and the other forms that were the patient charge, any licensee could avoid responsibility for his conduct merely by getting the patients to disclaim that they're suffering from any illness or condition. 4, Dr. Feinzimmer testified that he regularly treats hangovers in the ER as medical conditions, and he specified dehydration and a very vague not feeling. Last, the public safety is harmed when unqualified personnel are allowed to practice and treat patients. Dr. Feinzimmer's conduct assisted that. Thank
you. At this time, this matter, this hearing in this matter is now closed. I have advised that the board consider that motion to dismiss during executive session. At this time, I will turn it back over to Madam President for further instructions.
Thank you, Madam Hearing Officer. So at this time, is there a motion to consider, to close the meeting and to consider whether to go into executive session?
Madam President, I move to close the meeting to consider whether to enter into executive session on this time.
Second.
That's been moved and properly seconded. Any discussion? Hearing none, all in favor? Thank you.
Aye.
Thank you, Dr. Gersh. All opposed? Any abstention? Meeting is now closed.
Hello? Hello?
Hello,
Hey, yeah. Can you hear me?
I can hear you, but I don't hear them or anybody else.
Hi. I would like to Hello? Hello?
All right, we are now back in open session and Dr. Kennard, our active secretary, interim secretary, will discuss the findings of the executive session, starting with the, motion to deny. Dismiss, sorry. Deny the motion to dismiss, sorry, my bad.
Thank you, Madam President. There were two matters before the general board in the executive session. The first one was the request for dismissal, and that is denied. The second one were the stated counts against the defendant. The board, the general board unanimously votes that the defendant is guilty on all three accounts. And the remedy for the guilty decision is a 6-month suspension of your license with an immediate stay effective December 8th of 2023. That significance of that date is that is the date you sign the affidavit.
He didn't sign it.
Or the affidavit was signed. Sorry. We are recommending completion, that you have 1 year to complete AMA Category 1 CMEs that are board approved in the disciplines of professionalism and ethics. You'll follow up with the executive director on the details of those. But the time frame is 1 year.
I'm sorry, it's late. I got lost. Keep repeating.
Okay, sure. So guilty on all three accounts. The suspension is 6 months, immediately stayed, effective December 8th. So time served has been completed.
December 8th.
Correct.
1 year to get how many hours?
That's
Just
that
the courses.
the courses and the number of hours to be determined.
Just complete the courses.
Yeah.
Professionalism and.
Just completion of those hours, what they may be determined to be.
Philip, we'll get you another list. You don't already have it.
Yeah, if you would.
Anything else? Thank you very much for your time. And hopefully this gets you closer to where you ultimately want to be. Just wish the best to you and to your family and to your practice and for the work that you're doing in service to the state of Illinois.
Thank you all.
Thank you.
We do have one more item before we adjourn, just in general. I just wanted to announce to everyone that Shoba Gaines, our public member or consumer member, is going to be reappointed and will continue her service to the Mississippi Board of Medical Licensure and to the citizens of Mississippi. All right. No. What, we didn't meet long enough for you today? You ready? You're excited already? Sure, let's see. So, so July is that meeting. And the proposed dates, I believe, are isn't it 17th, 18th? Are our dates. Thank you, David, for keeping me honest. Nothing like having a former president to keep you where you need to be. So July 17th and the 18th are the dates that we have. Is that going to work for everybody?
Yes.
I don't even know if it's gonna work for me. Yeah. Cause our board retreat will be held at its usual time in August, in conjunction with or immediately preceding the MSMA. All right, so, any other issues? Thank you all so much, staff, everybody, for all of your hard work. To my board members, thank you for staying in for the long haul. And so if there's nothing further, I'll entertain a motion to adjourn. All right, that's it. We're adjourned. Thank you. Good night.